Mention through video. Memos from left side. No need to move any application. No need to move any memos. It will come automatically. Is true. You have filed a fresh application. Once office objection, the application is complied with. If any application would be automatically listed. No need to move any memo. Days of payment to click here. Yes.
My lord.
ಬೇಗ ಬೇಗ ಹೇಳ್ರಿ. ಸಂತೋಷ ಹೋಗಿ ಬರ್ಲಿ ಒಳಗೆ. ಏನ್ ಅಫೆನ್ಸ್? Yes. Yes, Monday. Yes.
Conviction order challenge ಮಾಡಿದೀವಿ.
ಅದು ಆರ್ಡರ್ಸ್ ಗಾದ್ರೆ ಮಾತ್ರ ಹಿಯರಿಂಗ್ ಆದ್ರೆ ಬೇಡ. ಡೆಪಾಸಿಟ್ ಅಮೌಂಟ್ ಬರುತ್ತೆ ಅದಾಗಿ. ನೋ ನೀಡ್ ಟು ಮೂವ್ ಎನಿ ಮೆಮೋ. ಯಾಕಂದ್ರೆ ಎಲ್ಲರೂ ಮೆಮೋ ಮಾಡ್ತಿದ್ದಾರೆ, ಅವ್ರು ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಿಲ್ಲ ಹೇಳಿ. ಇದೇ ಕರೆಸಿ ರಿಜಿಸ್ಟರ್. ಹಾ, ಏನ್ ಅಫೆನ್ಸ್? ಟ್ಯೂಸ್ಡೇ. IA for what? Tuesday. Tuesday. Offense. That's it. Tuesday. Yes. Call the witness.
Not the base of office objections first time. Claim number 1, Vijay Shetty B.
For the petitioner who got this matter specially listed by a memo, despite there be office objections to comply with, is now seeking an adjournment without showing any reasons. Thus, not properly in the precious time of the court, and getting the matter listed by moving a memo, no meaningful purpose, a cost of ₹500 is imposed upon the petitioner, payable by him to the legal services court within 3 days from today, and filing a compliance memo along with receipt to that effect in the registry within the set time. It is only after the payment of the cost registry to permit the compliance of office objection and proceed further. Next line. The office objection to comply with it auto after payment of the cost within a week from today.
Serial number 2, Srinivasan.
2 to 8, 1 week. Yes.
Serial number.
One.
Serial number 8, my lord. ಅದೊಂದು ಮೈನರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
ನಿಮಿಷ ಇರ್ರಿ.
ನಮ್ಮ ಕಲೀಗಲ್ ಇದ್ದಾರೆ.
accused was taken into custody. Proprietor seal ಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು ಜೈಲಲ್ಲಿ ಮೊಕಾಲ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ದಾರೆ.
ಈ ಸಬ್ಮಿಷನ್ ಅನ್ನ ಅಲ್ಲಿ ಮಾಡಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಅವ್ರು ನಾಟ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಅಂದ್ರೆ ಬರ್ಲಿ. ಐ ವಿಲ್ ಹಿಯರ್ ಆನ್ ದ ಸಬ್ಮಿಷನ್, ಪಾಸ್ ದಿ ಆರ್ಡರ್. First they have to hear, they have got a right to hear the submissions of the council.
Third time, serial number 9, Akshata Shetty K.
Serial number 8
Yes, please.
during the course of the day ನಮ್ಮ
ಮಾಡಿ ನಾಳೆ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ನಮ್ಮ ಕಲಿಗಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿರ್ತೇನೆ ನೀವು
ಅಲ್ಲ.
ಇವತ್ತು ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಮಾಡಬಾರ್ದಂತೇನಿಲ್ಲ, ಈಗಲೇ ಹೋಗಿ ಮಾಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್.
Third time, serial number 9, Akshata Shetty K.
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ನಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ರಿ ಅದನ್ನೇ ಹಾಕಿ 1000 rupees. 1,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕಟ್ಟಿ, ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ವಿತಿನ್ 3 days. Just next.
Serial number 10, Krishna Goda, BD.
Can I say final opportunity? What is last chance? Otherwise would be dismissed. Format ಇದೆ ಭಾರತೀಯ ಕೇಳಿ ಹೇಳ್ತಾರೆ. 22/11. 4 days ಒಳಗೆ ಮಾಡಿ, ಇಲ್ಲರ ಡಿಸ್ಮಿಸ್.
Fourth time, serial number 11, Muttaraju H.
In 11/2022, this court had made the following observations. Topic. In spite of the above, the counsel for the petitioner neither present physically nor through video conference or complied with the subsection. No reasons of forthcoming for his non-appearance. Since a sufficient time of not less than 4 times have already been granted to comply with office subsection, but the petitioner has not utilized the opportunities, the petition stands dismissed for not prosecution as well as for non-compliance.
Order matter, serial number 12, PM Matthew, SPP for respondent.
Where is the petitioner?
The petitioner, she has a heart operation and she's having bad health. She's staying in her native right now. On the respect of hearing, if you're not supportive, will make a procedure. I was regularly appearing and while shifting the office, the file has been displaced. I already applied for certificate copy on it. On the last day appearing, my father's 40th death ceremony was there, so I couldn't appear. I was in my native. There's no proper range also for me. Except for last 1 day, I was regularly appearing for the court election. No matter, even the police is also in touch with her over phone. How this protest come over here?
Proceed with the matter, please.
Sure.
Proceed with the matter, please.
It is short because I applied for certificate copy. My official file has been displayed by shifting the office. It is short date. I have already applied
For the petitioner is physically present, the bailable warrant issued against the petitioner Since his counsel had remained absent on the previous date of hearing, has returned unserved. The player counsel for the petitioner, though physically present, once again prays for a short accommodation. Posing a cost of ₹500, payable by the petitioner to the Legal Services Committee of this court within 3 days from today, and filing a compliance memo along with.
In working time, I've been
Indeed.
it's already applied.
Just within the said time as a final last opportunity. Each time is granted to proceed further in this matter, which has arisen from a criminal case of the year 2010. On the first date of hearing, the counsel for the petitioner, apart from furnishing the center and complete address of the petitioner, also to keep her physically present in the court. List the matter in the next 2 days.
Any date may be given.
23.
Student number 13, Vinita P. Kale.
Because of the microphone. The counsel for the petition, though physically present but doesn't submit to the court about the petitioner ascertain the correct, complete and present address of the respondent and taking steps to include service notice upon the respondent. The result of the order sheet is go to show that the receipt could not issue to notice for not taking step. The previous occasion, consideration of IA 2 or 2022 was a deferred. The petitioner had not ensured the service of notice upon the respondent. Since the petitioner, even thereafter also has not taken appropriate steps to ensure the service of notice upon. There's no point in abstaining the interim order of suspension of sentence. Because hence the interim order dated 25/3/2022 stands vacated. Just need to transmit today's order to the concerned prior court immediately. Yes.
Student number 14, Srikanta KS.
The counsel for the petition, the needful done. The magistrate to verify if steps have not been taken by him, which this matter on 18/11. Yes.
Student number 15, Avinash AP.
one day time may be granted in the PF office. One day, ma'am.
Petitioner, Learned Counsel for the petitioner appearance through video conference. Type of time. There was a lot of order sheet would go to show that even though the interim order was granted on 11/8/2022, simultaneously ordering for issuance of notice to the respondent, but the petition enjoying the benefit of the interim order of suspension of sentence, not bothering to take steps to ensure the service of notice upon respondent. The time as paid is granted, however, vacating the interim order granted on 11/8/2022. Accordingly, the interim order dated 11/8/2022 stands vacated. Each time is granted to take step. To communicate today's order to the consent trial court.
Bill number 16, Venkatram.
Yeah, petition.
Order as of serial 14 is
Serial number 17, Rajesh A.
I'm the respondent, my lordship.
In.
In 4/11/2022, the petitioner filed an objection statement of objection. A copy has been issued, my lordship. And the petitioner has not complied the trial court order, my lordship. In page number 41, my lordship. Page number 41, my lordship. The trial court has passed an order.
one nimshai. Yes.
Yes, my lord.
Why did you get this matter listed without complying objections raised on your application for vacating the stay?
Yes, my lord. IA1 for the objection. The office objection, raised the office objection. This matter has been listed, my lordship, on 2/11/2022, my lordship. And this honorable court has given the opportunity to the petitioner to file any objection regarding IA2 of 22, my lordship. And the petitioner has filed an objection on 3/11/2022, my lordship. And the petitioner has served the copy on 4/11/2022, my lordship. And 4/11, that matter has been posted, my lordship.
My question to you was not that why he did not file objection to your IA, but why did you move the matter and got it listed to hear on IA filed by you when there are office objections on the IA yet to be complied by you?
So, Lordship, the IA 2 of 22, objection number 1, my Lordship, and that petitioner has given served to the copy on 4/11 or 2022, sir, my Lordship, that office objection has been overruled, my Lordship, and listed on 4/11/2022, my Lordship. And second office objection, as the petitioner filing the statement of objection is not filing along with verifying update, maybe that is an objection, my Lordship. But here,
Counsel from both sides present.
my Lordship.
Despite the court repeatedly asking the learned counsel for the respondent as to why did he move the memo and got the matter listed out of turn? When in fact,
My Lordship, so
there
sorry, my
are
Lordship.
several office objections yet to be complied with on his IA number 2/2022. Without even knowing what the office objections that are yet to be complied with, the learned counsel makes the submission which is not connected with the non-compliance of office objection raised by the registry on his IA number 2/2022. In that way of the matter, since the applicant or the respondent has not properly utilized the precious time of this court, but got the matter listed to serve no purposes when the office objections are yet to be complied with an IA 2/22, a cost of ₹500 is imposed upon the respondent, payable to the Legal Services Committee of this court within 3 days from today, and filing a complaints memo along with receipt to that effect in the registry. Further proceeding to be taken in the matter by the registry only after the payment of the cost by the respondent within the time as mentioned above. As a last chance, a week's time is granted to complete office objection on IA 2/22.
My Lordship, kindly have it on 50 date, my Lordship. I will comply the office objection, my Lordship, or within in time, my Lordship.
Serial number 18,
My Lordship.
Dalwai Venkatesh.
Sorry, my Lordship. See, education expenses, my Lordship.
Serial number 18,
Conclusion, my Lordship.
ವಕೀಲರೇ ಜವಾಬ್ದಾರಿ ಮುಂಚೆನೆ ಇರಬೇಕಿತ್ತು ತಮಗೆ.
Urgency is made out, my
ಫೀ
Lordship.
ಕಟ್ಟಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಬರ್ತದೆ ಮ್ಯಾಟರ್ ಆಟೋಮೆಟಿಕ್.
My Lord, kindly have to fix the date, my Lordship. Finally, I request this honorable court, my
Increase
Lordship.
that cost to 800 rupees. Yes.
serial number 18, Dalwai Venkatesh.
I will vacate the interim order for the day. Learned counsel for the petitioner who ought to have been taken steps by this time. Learned counsel for petition, but a petitioner who ought to have taken steps by this time to ensure the service of notice upon the respondent has admittedly not taken steps till date, but has been enjoying the benefit of interim order granted in his favor on 11/8/2022. The learned counsel for the petitioner, though physically present, prays for a short accommodation to take steps. In the light of the above, the granting of time would be only by vacating the interim order of suspension of sentence passed on 11/8/2022. Accordingly, vacating the said interim order dated 11/8/2022, a week's time is granted to take steps. Registry to transmit a copy of this order to the concerned trial court immediately.
Serial number 19, Sunil Kumar TR.
Thank you for petitioner. Either physically or through video conference, no reasons are forthcoming for non-appearance of current counsel for the petition. Court by granting interim order of suspension of sentence of the interim judgment on 8/7/2022. It also directed the petition to pay the necessary process fee and furnish copies in the registry within a day from the said date. In order for issuance of emergency notice to the respondent. In spite of the same, the petitioner has not taken steps to issue emergent notice to the respondent, thus defeating the very purpose of emergent notice ordered as against respondent. On the contrary, he is enjoying the benefit of interim order dated 8/7/2022. No reasons are forthcoming for not taking steps. Hence, the interim order dated 8/7/2022 stands vacated. The registry to transmit a copy of this order to the trial court.
Hearing on interlocutory application cell number 20, RB Deshpande, NR Krishnappa for appellant number 1.
ಮಾಡಿ ಏನ್ ಕೇಸ್ ಇದೆ ಮಾಡಿ % respondent is granted 10 days time to file your objection if any by 1/20.
Serial number 21, Manjunath Prasad V, SCGP for respondent.
One minute. Please. Subjection ಯಾವ್ದ್ರ ಮೇಲೆ ಇರೋದು ನಾನ್ ಕಾಂಪ್ಲೆನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಆನ್ ವಾಟ್ in petition or IA
I am. This is on silver 5 man. Previous dice silver 5.
gradient of a subsection
I am. Hale.
ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಏನು ಅಂತ ನಾವು ನೋಡ್ಬೇಕಲ್ವೇನ್ರಿ ಮತ್ ಯಾಕೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಿದ್ದೀರಿ Their objection appears to be not with respect to the date, but it appears it the same is with respect to the case year, right? What is the objection raised by the office? The office objection, serial number 5 reads as below. In criminal appeal number 167 of 2015, case year does not tally with preamble portion and signature to be clarified. Next one. Learned counsel for the petitioner submits the case year is shown as criminal appeal number 167 of 2015, both in the cost title preamble of the impugned judgment. There's no reflection of the case number in the operative portion of the order at the end. The criminal case number as CC number 576 of 2011 is reflected correctly throughout in the impugned judgment passed in criminal appeal number 167 of 2015. In the light of the above, learned registrar judicial to clarify what the office meant with the above extracted office objection and make his submission. Just the matter on 18/11. Yes.
Serial number 22. Ramaragowda, Prabhu Gowda, V.
Condemnation of the government the submission of learned counsel for the petition. First, the memorandum of petition improved judgments by the IAs. Since there is a delay in filing the present revision petition, seeking condemnation of each I1 of 2022. But I am of the view that before proceeding to pass any order on I2 of 2022, the order notice be issued to the respondent. Accordingly, issue notice to the issue emergent notice to the respondent, both on the main petition and on pending IAs. The petitioner to pay the necessary process and furnish copies in the registry if not already done during the course of the day. If the matter like 11. Yes.
Serial number 23, Vasanta Madhava, yes.
Emergency notice, same order.
Seal number 24, K. Ravishankar, Sharat Kumar, HN for respondent.
Yes. Counsel from both sides present. So the court specifically asking that counsel for the respondents makes no submission in the matter. It is taken that he has no objection to IA 1 and 2 of 2020. And perused IA 1/22. He filed under section 5 of Limitation Act seeking condonation of delay of 31 days in filing the revision petition. Considering the reasons shown in the affidavit accompanying the application, and of the fact that the respondent, despite granting sufficient opportunity, not filing objection to the said IA. Reasons shown in the affidavit is treated as sufficient cause for condonation of delay. Accordingly, IA 1/22 that's allowed under delay of 31 days in filing the IA 2. 31 days in filing the revision petition stands condoned. IA 2. Yes. Hmm.
Now with the affidavit of the respondent, so that the affidavit of the, since the petitioner is in judicial custody, whether the affidavit has been, and also coupled with the memorandum of fact.
Without copy to other side, you have no objection. One ನಿಮಿಷ ಇರಿ. Where is the respondent?
to VC on after tomorrow. As he since surgery. Able to come. Through VC.
Let him come, we will adjourn it in the next, we keep present the parties. The executant of the affidavit. Yes. Sir, had you keep them present, I would have passed the final order right now. Right now. Court is ready. But you are not utilizing. He has got one reason, you have got one reason. And moreover, mind it, the court can even reject the compounding application. The cash transaction, there is no burden on the court that it should accept it. The court can direct the parties to withdraw the amount and secure a demand draft and pay. Yes. So I can do that order also. Keep present the parties. No, you are inviting that by continuing the submissions, you are inviting that wrath of the court. Both sides file a joint application to section 147 NI Act. Declared counsel for the petitioner submits that since the petitioner is in judicial custody, his brother by name Harish Bhakta has sworn to an affidavit in support of the number so and mail files an application to section 147 and PDL files IA number so section 147 of NI. In court of said IA number so. Admittedly, neither the deponent inside the affidavit, that is the Harish Bhakta, nor the respondent who has also sworn to an affidavit are physically present in the court. As such, yes, so and so. File at 147 NI Act could not be proceeded today. Both side parties are directed to keep present the parties so that the court may proceed with IA filed under 147 NI Act. This is the matter on. I can give the date tomorrow also. Whenever you want to tell me, I can give the date. ನಾನು ನಾಳೆನೂ ಕೊಡಬಲ್ಲೆ ನಾಡಿದ್ದು ಕೊಡಬಲ್ಲೆ ನಿಮಗೆ ಯಾವಾಗ ಅನುಕೂಲ ಹೇಳಿ. Just the matter on so and so date. ಆಮೇಲೆ ಅವ್ರಿಗೆ ಡೇಟ್ ಹೇಳಿ ಅದು ಡೇಟ್ ಅವರಿಗೆ
Admission matter, serial number 25, SPP, TS Rajarajeshwari for R325, Muhammad Aibari for R2. Connected.
Yes.
The one appeal is filed by the state.
Yes, I am hearing on the main merit. itself.
Yes.
At the end of the admission list. At the end of the admission list.
Serial number 26, Chandrasekhar P. Patil, Basuraju P. for respondent.
Yes. PW.
Already a loan of. Because of that, we are getting the tax of. Because it is dated to 2008.
B11, B1, B2. B11, B1, B2. Yes, please.
Petitioner is the accused. The respondent has filed a complaint. That he is the proprietor of non-professional tours and travels. His appellant gave
What are the points of your argument?
points of argument is that I have taken a twofold defenses. One is that totally I don't know this person.
Yes.
There is no transaction. And the check is not given to him. Check is given to one Chandregowda.
Yes.
That Chandregowda has collected this blank check and another 100 rupees stamp paper. And
What
also,
action you have taken against such Chandragupta?
I have given a police complaint.
What happened to that police complaint given in the year 2008?
2008, I have given a complaint.
Yes,
Thereafter, the Chandregowda has absconded.
yes.
Immediately, this person has issued a notice. I have given complaint on 2/8/2008. I have received a legal notice. I mean, the check was presented on 8/8/2008. I have given police complaint on 2/8/2008.
Sir, my question to you is, after giving the police complaint on 2/8/2008 till date, what action you have taken or how you have proceeded in continuation of your complaint against Chandragupta?
To that extent, I do not have any.
That means except lodging the complaint, you have forgotten about your criminal complaint.
Because they have filed a complaint.
Then how to believe the contents of your complaint?
So-called check what they are saying is contained in the complaint.
Yes, sir. Complaint is your own document. You can write anything. You can give 100 checks to 100 persons and write a complaint, mentioning the number of all the 100 checks in that complaint and give it to police and forget the complaint. That cannot be a valid defense.
The cross-examination, my lord, so many things are admitted by the respondent here.
No, that is other part. That is other part. If according to you, the check was given to Chandragupta, And Chandragowda has misused that check with some criminal intention. If you have filed a complaint 14 years back against him, why did you keep quiet for such a long time without proceeding with respect to your complaint? Mere filing of the complaint and telling in all other check bouncing cases or civil cases that say, I have filed a complaint is not sufficient. Complaint is your own document. In pursuance to the complaint, what progress has been taken place? Then how can that come? That can come to your help.
Because the so-called check mallet, the number is contained one thing.
ಮತ್ತು ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
Other thing is mallet in the cross examination, the PW1 has admitted. Read the cross examination.
What he has stated?
The cross examination mallet, the PW1 admits that he has not received the.
ಏನ್ ಹೇಳಿ ಬಾಯಲ್ಲಿ ಹೇಳಿ. ಓದಿಲ್ಲ. Just give me the summary, please. ಬಾಯಲ್ಲಿ ಹೇಳಿ ಏನ್ ಹೇಳಿದ್ದೀರಿ.
The normal circumstances mallet, if a person wants to give a money.
ಅವ್ರ ಮನೆ ಮಠ ಆಸ್ತಿ ಗೀಸ್ತಿ ಅಂತಸ್ತು ಎಲ್ಲವನ್ನು ನೋಡ್ತಾನೆ. ಅದೆಲ್ಲದು ಸೆಕೆಂಡರಿ ಆಯ್ತು. ಪ್ರೈಮರಿ ಏನಿದೆ, ನಿಮ್ಮ ಚೆಕ್ ಇವರ ಕೈಗೆ ಹೇಗೆ ಬಂತು? ನಿಮ್ಮ ಪ್ರಕಾರ ಚಂದ್ರಗೌಡನ ಮೂಲಕ. ಆ ಚಂದ್ರಗೌಡನ ವಿರುದ್ಧ ಏನು ಕ್ರಮ ತಗೊಂಡಿದ್ದೀರಿ? ಮತ್ತೆ ಏನು ತಗೊಳ್ಳಿಲ್ಲ, ಏನು ಮಾಡ್ಲಿಲ್ಲ. ನಿಮ್ ಚೆಕ್ ಬೌನ್ಸಿಂಗ್ ಕೇಸ್ ನಿಮ್ಮ ಮೇಲೆ, ನಿಮ್ಮ ಅಕ್ಕನ ಮೇಲೆ, ಎಲ್ರ ಮೇಲೂ ಇದೆ. ನಿಮ್ಮ ಅಕ್ಕ ಜೈಲಿಗೂ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ ಇದೇ ಚೆಕ್ ಬೌನ್ಸಿಂಗ್ ಕೇಸ್ಗಳಲ್ಲಿ. Then how to believe your defense?
ಹೇಳೋದು ಚೆಕ್ ಕೊಟ್ಟಿರೋದು ಮಕ್ಕಳು ವಿದ್ಯಾಭ್ಯಾಸ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಮಕ್ಕಳು ಏನ್ ಓದ್ತಾರಂತನೂ ವಿಚಾರ ಮಾಡಿ ಏನೂ ನೋಡಿಲ್ಲ, ಇಲ್ಲಂತಾನೇ ಗೊತ್ತಿಲ್ಲ. ಆತರ
ಯಾರ ಚೆಕ್? ನಿಮ್ಮ ಚೆಕ್ ಅವರ ಕೈಯಲ್ಲಿ ಇದೆ. ಸೆಕ್ಷನ್ 139.
ನಾನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ.
ಹೌದ್ರಿ, ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಚಂದ್ರಗೌಡನ ಮಧ್ಯ ಇಟ್ಕೊಂಡು ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಚಂದ್ರಗೌಡನಿಗೆ ತೋರಿಸ್ತಾ ಇದ್ದೀರಿ ನೀವು ಬೆರಳು ಮಾಡಿ, ಅವನೇ ಕೊಟ್ಟಿದ್ದೇನೆ, ಅವನು ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾನೆ. ಅದನ್ನ ಸ್ವಲ್ಪನಾದ್ರೂ ನೀವು ನಂಬುವ ರೀತಿಯಲ್ಲಿ ತರಬೇಕಂತ ಹೇಳಿದ್ರೆ ಆ ಚಂದ್ರಗೌಡನ ವಿರುದ್ಧ ನೀವೇನು ಕ್ರಮ ತಗೊಂಡಿದ್ದೀರಿ?
ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡದೆ ಹೋಗಿತ್ತು ಅಂದ್ರೆ ನನಗೇನು ರೈಟ್ ಇರ್ತಿದ್ದಿಲ್ಲ.
ಆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ರಿ, ಕಂಪ್ಲೇಂಟಿನ ಮೇಲೆ ಏನ್ ಮಾಡಿದಿರಿ? ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು ದೊಡ್ಡ ವಿಷಯ ಅಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ನಂತರ ಹೇಗೆ ಮುಂದುವರಿಸಿದ್ರಿ? ನಾನು ಹೇಳಿಲ್ವೇ, ಮೋಸ ಮಾಡ್ಬೇಕು, ಎಲ್ಲರ ಹತ್ರ ಸಾಲ ಇಸ್ಕೊಂಡು ಚೆಕ್ ಕೊಟ್ಟು ಆಮೇಲೆ 138 ಇಂದ ತಪ್ಪಿಸ್ಕೊಳ್ಬೇಕಂದ್ರೆ ದಟ್ ಇಸ್ ಒನ್ ಆಫ್ ದಿ ಬೆಸ್ಟ್ ಮೋಡಸ್ ಆಪರೆಂಡಿ. ಎಲ್ಲ ಸಾಲ ಮಾಡೋದು, ಚೆಕ್ಗಳನ್ನು ಕೊಡೋದು, ಆಮೇಲೆ ಚೆಕ್ ಕಳೆದೋಗಿತ್ತು ಮುಂಚೆನೆ ಅಂತ ಹೇಳಿ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲಿ 1 ತಿಂಗಳು ಮುಂಚೆನೆ ಚೆಕ್ ಕಳೆದೋಗಿತ್ತು ಅಂತ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು. ಸ್ವಾಮಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡ್ರಿ, ನನಗೆ ಚೆಕ್ ಕಳೆದೋಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿದ್ದೆ, ನನಗೆ ನೋಟಿಸ್ ಬಂದ್ರ ಮೇಲೆ ಅಲ್ಲಿವರೆಗೆ ಎಲ್ಲೋ ಹೋಗಿದೆ ಬಿಡು, ಅದೇನು ಆಗಲ್ಲ, ಖಾಲಿ ಚೆಕ್ ತಾನೇ ಸುಮ್ಮನೆ ಇದ್ದೆ. ನಾನು ಗೊತ್ತಾ, ಚೆಕ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರಲಿಲ್ಲ, ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ನೋಡ್ರಿ, ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಹೇಗೆ ಮುಂದುವರಿಸಿದ್ರಿ ಅದು ಇಂಪಾರ್ಟೆಂಟು. ಹಾ, ಅದೇ ಅದು ಇಂಪಾರ್ಟೆಂಟು. ಹೆಚ್ಚಿನ 138 ಕೇಸ್ಗಳಲ್ಲಾಗೋದು ಪಕ್ಷಕಾರರ ಈ ರೀತಿಯ ಅಸಡ್ಡೆ, ನಿರ್ಲಕ್ಷ್ಯತನ. ಅವರಿಗೆ ಕಾನೂನಿನ ತೀಕ್ಷ್ಣತೆ ಗೊತ್ತೇ ಇರಲ್ಲ ಅಷ್ಟೇ. ಆ ಕಡೆ ಬಿಡ್ತಾರೆ ಅವರು. ಎಸ್, ವೈ ಶುಡ್ ಯುವರ್ ಕಂಟೆನ್ಷನ್ ಬಿ ಬಿಲೀವ್ಡ್? Are there not lot of loopholes in your case? And he had, say, introduced several doubts in your case. Is it not sufficient to rebut the presumption formed in your favor.
He had tendered, he had contacted General and sought for financial assistance. In the reply notice. In the complaint, exhibit D1, she narrated the fact. The checks and bond papers have been delivered to her sister Kanakaratna. And in turn, Kanakaratna delivered to General. In the, before the trial court, my lord, she categorically admits prior to 27/2008 or subsequently, she had not met Chandregoda. We may need 3 lines in cross-examination of DW1.
Yes, please.
The cross-examination of DW1. Page number 3.
Yes.
Third line.
Yes.
ಚಂದ್ರೇಗೌಡರವರಿಗೆ ನಾನು ಯಾವುದೇ ಪತ್ರವನ್ನು ಬರೆಯುವ ಮೂಲಕ ಆಗಲಿ ಅಥವಾ ವಕೀಲರ ಮೂಲಕ ನೋಟಿಸ್ ಅನ್ನು ಕೊಡುವ ಮೂಲಕ ಆಗಲಿ ಚೆಕ್ ಮತ್ತು ಇತರ ದಾಖಲೆಗಳನ್ನು ನನಗೆ ಹಿಂದಕ್ಕೆ ಕೊಡಬೇಕು ಎಂದು ಬರೆದಿಲ್ಲ. ಆದರೆ ನಾನು ಅವರ ಮನೆ ಹತ್ತಿರ ಹೋಗಿ ಅವರನ್ನು ಖುದ್ದಾಗಿ ಭೇಟಿಯಾಗಿ ಕೇಳಿದ್ದೇನೆ. ಸದರಿ ಚಂದ್ರೇಗೌಡರವರು ಹನುಮಂತೇಗೌಡರ ಬಳಿ ಸಾವು ತಿಳಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ಸದರಿ ಚಂದ್ರೇಗೌಡರ ಮನೆಯ ವಿಳಾಸ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. From the bottom, the very same page, from the bottom. ನಾನು ನಮ್ಮ ವಕೀಲರು ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ಉತ್ತರದಲ್ಲಿ ದಿನಾಂಕ 15/7/2007 ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟ ವಿಚಾರ ಆಗಲಿ ದಿನಾಂಕ 27/2008 ಸದರಿ ಚೆಕ್ ಮತ್ತು ಇತರ ದಾಖಲೆಗಳನ್ನು ತನಗೆ ಹಿಂದಕ್ಕೆ ಕೊಡುವ ವಿಚಾರವನ್ನು ಹೇಳಿರುವುದಿಲ್ಲ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಅದು ನಮ್ಮ ವಕೀಲರಿಗೆ ಗೊತ್ತು. ನನಗೆ ಒಬ್ಬಳೇ ಮಗಳು ಮತ್ತು ಮಗ ಬಿಕಾಂ 2ನೇ ವರ್ಷ ಓದುತ್ತಿದ್ದಾನೆ ಮತ್ತು ಮಗಳು ಡಿಗ್ರಿ ಇದಿರುತ್ತದೆ. ನನ್ನ ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸಕ್ಕಾಗಿ ಮತ್ತು ನಾನು ಮಾಡಿರುವ ಮನೆಯ ಸಾಲದ ತೀರುವಳಿಗಾಗಿ ಫಿರ್ಯಾದಿದಾರರಿಂದ 3 ಲಕ್ಷ ಹಣವನ್ನು ಸಾಲವಾಗಿ ಪಡೆದಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಬ್ಯಾಟರಾಯನಪುರದ ರಾಮೇಗೌಡರು ಯಾರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ವಕೀಲರು ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ಉತ್ತರದಲ್ಲಿ ಹೇಳಿರುವ ರಾಮೇಗೌಡ ಎಂಬ ವ್ಯಕ್ತಿ ಯಾರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಮೇಲೆ ಹೇಳಿರುವ ನನ್ನ ಸಹೋದರಿಗೆ ಗೊತ್ತು. ನಂದೀಶ್ರವರು ಧನಲಕ್ಷ್ಮಿ ವಿರುದ್ಧ ಇದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ NIA ಸಂಬಂಧಿಸಿದಂತೆ ದೂರನ್ನು ಹಾಕಿರುವುದು ನನಗೆ ಗೊತ್ತು. ಸದರಿ ದೂರಿನಲ್ಲಿ ಆರೋಪಿ NPW ಆಗಿದ್ದ ವಿಚಾರವನ್ನು ಅವರೇ ನನಗೆ ತಿಳಿಸಿದರು. ನೆಕ್ಸ್ಟ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ದಿನಾಂಕ 27/2008 ಮುಂಚೆ ಆಗಲಿ ಅಥವಾ ನಂತರವಾಗಿ ನಾನು ಚಂದ್ರೇಗೌಡರನ್ನು ಖುದ್ದಾಗಿ ಭೇಟಿಯಾಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. Subsequent to filing this examination.
No, how that statement that ದಿನಾಂಕ 27/2008 ಮುಂಚೆ ಆಗಲಿ ಅಥವಾ ನಂತರವಾಗಲಿ ನಾನು ಚಂದ್ರೇಗೌಡರನ್ನು ಖುದ್ದಾಗಿ ಭೇಟಿ ಆಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ would come to your help.
Because my lord, she contends these checks and the small papers have been delivered to Chandregoda in order to facilitate the law. My lord, she admits, my lord, prior to 27/2008 as she had not met Chandregoda. Question of delivering the checks to Chandregoda does not.
How can you infer that? Has she stated that after this date she personally met Chandregoda and delivered those documents? Has she anywhere stated ದಿನಾಂಕ 27/2008 ನಂತರ ನಾನು ಚಂದ್ರೇಗೌಡರನ್ನು ಖುದ್ದಾಗಿ ಭೇಟಿಯಾಗಿ ಚೆಕ್ ಅನ್ನು ಬಾಂಡ್ ಪೇಪರ್ ಅನ್ನು ಇತ್ಯಾದಿಗಳನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಎಲ್ಲಿಯಾದ್ರೂ ಹೇಳಿದ್ದಾಳ? ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರಾ?
16/7/2008 my lord, these checks have been delivered.
16/7. ನೀವು ಕೇಳಿದ ಡೇಟ್ ಯಾವುದು? 27.
27/8/2000 ಮುಂಚೆ ಆಗಲಿ ಅಥವಾ ನಂತರವಾಗಿ ಆಗಲಿ. Prior to 27/2008 or subsequent to 27/2008, she had not met Chandregoda.
Is it not an omnibus statement?
It's a irresponsible submission, my lord. It's an admission by the DW1. My lord, exhibit D1, my lord. They read, my lord, the complaint government what she made. The checks have been delivered to her sister. Her sister has given the checks to these documents to Chandregoda. That is the difference, my lord.
So, if her sister has given check to Chandregoda, the question of this witness, that is accused, meeting Chandregoda does not arise. Therefore, her statement that she has not met Chandregoda either prior to or subsequent to 27/2008 would not affect her interest in any manner. Right?
If you reply only, she stated these checks and documents have been delivered to Chandregoda. In exhibit T1, she stated these documents had been delivered to, handed over to her sister Kanakaratna, and then it has been handed over to
Reply notice kudi.
T11.
11 kudi.
Para 5.
Yes.
My client states that one Sri Chandregowda is a resident of Gavipuram, Kudralli, Bangalore 19, working as manager of the local cooperative bank limited, was introduced to our client by common friends. During the first week of July 2008, the said Chandregowda had represented to our client that he would arrange finance to our client for our client from a local financier, Sri Ramegowda, a resident of Badrayapura, Bangalore 26. With that representation, the said Chandregowda had collected from our client and two others, which Dhanalakshmi and Kanakaratna, sureties, one blank check from our client, and from each of the said two women, 3 rupees under stamp paper, all is to be presented, deposited with the said financier Sri Ramegowda, while releasing the loan amount. Sri Chandregowda had also collected the original mortgage document of the premises where our client is presently residing. While collecting the said signed and blank paper, the said Chandregowda had promised to arrange a loan of ₹5 lakh to our client by 25/7/2008. But the said Chandregowda has failed to arrange any loan amount to our client. When our client and the other two women demanded Chandregowda to return all the checks, these transactions, he used to say that the loan papers are under the process and pleaded our client and other two women to wait some more time. When our client smelled food play by Chandregowda, our client lodged complaint dated 2/8/2008 before the Nagara PS and before the police, though the said Chandregowda had undertaken to return all the papers and the checks to our client and to the other woman, he has failed to do so. Now he has gone underground and evading the police. But exhibit D1 mirror for D1 complaint.
Yes.
Merit.
Yes.
ವಿಷಯ ಚಂದ್ರೇಗೌಡ ಎಂಬುವರಿಂದ ದಾಖಲಾತಿಗಳು ಕೊಟ್ಟಿದ್ದು. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಗವಿಪುರ ಗುಡ್ಡಳ್ಳಿ ವಾಸಿ ಚಂದ್ರೇಗೌಡ ನನ್ನ ಅಕ್ಕ ಕನಕರತ್ನ ಎಂಬುವರಿಗೆ ಪರಿಚಯವಿತ್ತು. ಅವರ ಕಡೆಯಿಂದ ನನಗೆ ಬಡ್ಡಿಗಾಗಿ ಹಣ ಕೊಡಿಸುವುದಾಗಿ ಹೇಳಿ ನನ್ನ ಮನೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಮನೆಗೆ ಸಂಬಂಧಿಸಿದ ಭೋಗ್ಯದ ಅಸಲು ಪೇಪರ್, ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕಿನ ಚೆಕ್ ನಂಬರ್ 8685 ಹಾಗೂ ಖಾಲಿ 100 ಮುದ್ರೆ ಪೇಪರ್, ಮನೆ ಮಾಲೀಕರ ಹೆಸರಿನ ಮುದ್ರೆ ಪೇಪರ್ ಇವು ಹಾಗೂ ನನ್ನ ಅಕ್ಕ ಕನಕರತ್ನ ಹೆಸರಿಗೆ ಒಂದು ಬ್ಲಾಂಕ್ ಚೆಕ್ 100 ಮುದ್ರೆ ಪೇಪರ್ ಹಾಗೂ ಸರ್ಕಾರಿ ಕೆಲಸದ ಭದ್ರತೆಗಾಗಿ ಶ್ರೀಮತಿ ಧನಲಕ್ಷ್ಮಿ ಒಂದು ಖಾಲಿ ಚೆಕ್ ಹಾಗೂ 100 ಮುದ್ರೆ ಪೇಪರ್ ಇವುಗಳನ್ನು ಕೊಟ್ಟು ಒಂದು ಚೆಕ್ ಕೊಟ್ಟು ಭದ್ರತೆಗಾಗಿ ಖಾಲಿ ಬಾಂಡ್ ಪೇಪರ್ ಸಹಿ ಮಾಡಿಕೊಟ್ಟರು. ನಾವು ಸಹ ಎಲ್ಲಾ ಖಾಲಿ ಬಾಂಡ್ ಪೇಪರ್ ಹಾಗೂ ಚೆಕ್ ಗಳಿಗೆ ಸಹಿ ಹಾಕಿಕೊಂಡಿರುತ್ತೇವೆ. ಇವುಗಳನ್ನ ದಿನಾಂಕ 16/7/2008 ನನ್ನ ಅಕ್ಕ ಕನಕರತ್ನ ಎನ್ನುವರು ಚಂದ್ರಗೌಡನಿಗೆ ಕೊಟ್ಟಿದ್ದು ಸದರಿ ಅವರು ಲೋನ್ ಕೊಡಿಸದೆ ಬೇರೆ ವ್ಯಕ್ತಿ ಹನುಮಂತಪ್ಪ ಎಂಬ ವ್ಯಕ್ತಿಯ ಮೇಲೆ ಹೇಳುತ್ತಾರೆ. ದಾಖಲೆಗಳನ್ನು ವಾಪಸ್ ಕೊಡುವಂತೆ ಚಂದ್ರೇಗೌಡನಿಗೆ ಕೇಳಿದರೆ ಸಬೂಬು ಹೇಳುತ್ತಾನೆ, ಸದರಿ ಅವರನ್ನು ಕರೆಸಿ ನನಗೆ ಬರಬೇಕಾದ ದಾಖಲೆಗಳನ್ನು ಕೊಡಿಸಿ. But in the cross examination of PW1, while the suggestion was made, while the handwriting found in the exhibit P2 check are one and the same, the ink used to fill up the exhibit P2 are one and the same. Read the suggestion.
That portion not relevant.
So, they contain the blank side check was given. Well, it has been filled up for transfer. In the cross examination, suggestion was made. All are one and the same ink and the same handwriting.
They have not admitted this suggestion as true.
No,
We are
but-
making a suggestion won't support your case.
Well, after the cross examination, she had orally examined again, and she had reiterated the same, and she admits in the cross examination she won't sign any blank papers, blank instrument, blank stamp paper. Period 3 lines of the exhibit DW accused evidence maybe.
That relevant portion you read, that particular portion.
Please. This is dated, my lord, 28/9/2013. Date 9/2013.
Yes.
But from the bottom, my lord, third line.
Yes.
ನಾನು ಸಾಮಾನ್ಯವಾಗಿ ಯಾವುದೇ ಖಾಲಿ ಹಾಳೆ ಅಥವಾ ಚಾಪ ಕಾಗದಗಳಿಗೆ ಅಥವಾ ನೆಗೆಟಿವ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ಗಳಿಗೆ ಸಹಿ ಮಾಡುವುದಿಲ್ಲ. With regard to the, my lord, that two defense have been set up by the accused. Questions have been posed, my lord, in the same page, my lord, they are permitted. From the top, my ಕನಕರತ್ನ ನನ್ನ ಅಕ್ಕ ಇರುತ್ತಾಳೆ. ನನ್ನ ಅಕ್ಕ
That I have read it complete.
middle, my lord, middle. Seventh line.
Yes.
ಇಡೀ ಒಂದನ್ನು ನನ್ನಿಂದಲೇ ನಾನೇ ಬರೆದು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಬರೆಸಲಾಗಿದೆ. ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್ಗೆ ನಾನು ಮಾಹಿತಿ ಕೊಟ್ಟು ಉತ್ತರ ಕೊಡಿಸಿರುತ್ತೇನೆ. ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್ಗೆ ಕೊಟ್ಟ ಉತ್ತರದಲ್ಲಿ ರಾಮೇಗೌಡರಿಂದ ಹಣ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ನನ್ನಿಂದ ದಾಖಲೆ ಪಡೆದರೆಂದು ನಾನು ಉಲ್ಲೇಖ ಮಾಡಿಸಿರುತ್ತೇನೆ. ಇಡೀ ಒಂದರಲ್ಲಿ ಹನುಮಂತಪ್ಪ ಎನ್ನುವಾತನಿಂದ ಹಣ ಕೊಡಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ ಬಗ್ಗೆ ಉಲ್ಲೇಖವಿತ್ತು. ಎರಡರಲ್ಲಿ ಯಾವುದು ಸರಿ ಎನ್ನುವ ಕುರಿತಾಗಿ ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿ ಉತ್ತರ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. My respectful submission, my lord. In view of section 118 of the Act, 138(9) of the Act, 114 of the Indian Act, my lord, there is a distinction in the my lord, the holder of the check. My lord, it is the defense, my lord, the preponderance of probabilities, my lord, the accused has to be established, my lord, by reading the quoted evidence. My lord, in the reply notice, they contain they required Chandra. In the complaint, he contends he had delivered the checks to her sister. In turn, she delivered the checks. My lord, this is not probable. Hence, my lord, established by the accused. My lord, that these circumstances, my lord, the presumption will be held in favor of the, my lord, the complaint.
So if for settlement, what is the expectation of your client less than the check amount?
Quite.
Whether your client is inclined to settle the matter?
My lord, he is inclined to settle the matter.
Yes, whether your client is inclined to settle the matter? Can you inform me this afternoon as to their proposals if any?
Try to get.
Phone ಮಾಡಿ ಕೇಳಿ.
I have not contacted. I will ask my counterpart.
There are counsel from both sides present. After making some submission, both sides submit that they try to find out whether the parties are inclined to settle the matter. It's the matter on 21/11, on which day the parties to report the settlement if they arrived at or to proceed further in the matter. On that day, don't come with the only proposal here, exchange the proposal among interse. Tell your client that let him not expect the check amount or something more than that. Let him be prepared even for the lesser amount also because he is getting money. Tell your client not to be too mean in giving the proposal. The check amount is 3 lakh rupees. And the weaknesses in her defense has been highlighted or enlarged by the learned counsel for the other side. Keeping that in mind, let her proposal for any particular sum be made to the complainant.
60,000 already.
1,60,000 already deposited. Withdrawn. ನೋಡಿ ಬನ್ನಿ ಪಾರ್ಟಿನೂ ಅವತ್ತಿನ ದಿವಸ ಪ್ರೆಸೆಂಟ್ ಇಡಿ ಏನಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ರೆ 147 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ graded cost may have to be paid 45,000 rupees to the court. That also let your party be kept in mind. Parties are also made known of payment of graded cost in case of the application is made under section 147 NA Act. Yes.
Still number 27. Rishipal Singh Verma, Harish TS, Chandrasekhar P. Patil for respondent.
Yes. I couldn't get you. I couldn't get you. Huh. You should have done that in the registry, not in the court hall. Hmm. There are counsel from both sides proceed. The first of all, counsel for the petition, a week's time as paid is granted. Go through the file in the registry, not here, yes.
Serial number 28, Chandrasekhar P, Sharad Kumar HN for respondent.
Yes, please.
Allegation of the complaint is last to the fact that the accused petitioner provided financial assistance on 5/2/2015 from the complainant prisoners to perform the marriage of her son and etc. And on the same day, that alleged check exhibit P1 was handed over to the defendant and the complainant prisoners by availing financial assistance from others, especially his friends, and from his savings prisoners. He handed over an amount of this 2,50,000 to the complainant, to the accused, in the case of the complainant. It is this further case in this matters that when the accused failed to repay the amount, he issued notice for which there was no reply, tendency by the payment company. As in the examination in chief, this matters, it is this case that on 5/12/2014 was the date of the alleged transaction. It is this case, please, matters, that the transaction was 5/2/2015. Whereas in this examination in chief, this matters, he has contended that on 5, the transaction was on 5/12/2014, please, matters, and he borrowed from his friends, borrowed the amount from his friends. He has not read from the names of his friends, from whom he borrowed the amount, how much he borrowed, what was his savings, nothing. And he was an employee at Canara Bank, knowing to the value of being an employee at Canara Bank. He was running chip fund business, financial business, and real estate business. That is the case. And he admits transaction with many persons.
Yes.
In the case of the accused was that she had invested with the complainant an amount of this 1,20,000 at the time of chip fund business by doing chip fund business with the complainant. At that time, this month she had handed over the check as security for the chip fund business, and he had also retained the pronoun along with the check. And by retaining the illegally retaining the check, is what she has initiated the proceedings. Is the case of the complainant. Both reports are not appreciated, although a defense is taken to the effect that the complainant did not have financial source to pay to the accused an amount of this 2,50,000.
Where he have suggested that he had no financial source. And what is his response?
That he borrowed from his friends.
If he, whether that is not possible, borrowing from his friends.
She says 1 week prior to I seeking him financial assistance will not be borrowed the amounts. ನಾನು ಕೇಳ್ತೀನಿ ಅಂತ ಅಂದ್ಕೊಂಡು ಅವರು ಫ್ರೆಂಡ್ಸ್ ಹತ್ರ ಸಾಲ
ಓದಿ ಅದು ಎಲ್ಲಿದೆ ಪೋರ್ಷನ್.
Page 7. Relevant question.
Page 7. Yes. Yes.
ನಾನು ಈ ಮೇಲಿನ ವ್ಯವಹಾರಗಳಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ನನ್ನ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ ಸದರಿ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲಾಗಿದೆ. ಸದರಿ ಹಣವನ್ನು ಯಾವ ದಿನ ಮತ್ತು ಎಲ್ಲಿ ಕೊಟ್ಟೆ ಎಂದು ನಮೂದಿಸಿದೆ ಸರ್. ನಾನು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮತ್ತು ಫೈನಾನ್ಸಿಯಲ್ ವೃತ್ತಿಯಾಗಿ ಮಾಡುತ್ತೇನೆ ಎಂದು ಪರವಾನಗಿ ಪಡೆಯಲು ಯಾವುದೇ ಬಡ್ಡಿ ವ್ಯವಹಾರ ಮಾಡಬಾರದು ಎಂಬ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಜೊತೆ ಕೃಷ್ಣಪ್ಪ ಎಂಬುವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅಸಿಸ್ಟೆಂಟ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ. ಚೀಟಿ ಬರೆದುಕೊಳ್ಳುವ ಕೆಲಸ ಮಾಡಲ್ಲ. ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮತ್ತು ಫೈನಾನ್ಸ್ ನಾನು ಚೀಟಿ ಮಾಡಬಹುದು. ಶಾರದಮ್ಮ ಮತ್ತು ಚೀಟಿ ವ್ಯವಹಾರ ಕೂಡ ಮಾತನಾಡಿದ್ದು ನೆನಪಿಲ್ಲ. Yes. Next big business. ಆರೋಪಿಗೆ 2,50,000 ಕೊಟ್ಟ ಬಗ್ಗೆ ನನ್ನ ಚೆಕ್ ಬಿಟ್ಟು ಒಂದು ಟಿಪಿ ನೋಡಿದೆ. ಆದರೆ ಅದನ್ನು ನೋಡಿ ಹೇಳುತ್ತೇನೆ, ನಾನು ಹಣವನ್ನು ಚೆಕ್ ತೆಗೆದುಕೊಂಡು ಕೊಡುತ್ತೇನೆ. ಚೆಕ್ ಪಡೆದ ತಕ್ಷಣ ಹಣ ಕೊಡುತ್ತೇನೆ. ಹಣ ಕೊಟ್ಟ ಬಗ್ಗೆ ನಾನು ದಿನಾಂಕವನ್ನು ನಮೂದು ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಬರ್ತೇನೆ. ಹಣ ಕೊಟ್ಟ ದಿನಾಂಕ ಬರದಿಂದ ನನ್ನ ದೂರಿನಲ್ಲಿ ದಿನಾಂಕ 5/2/2015 ಆರೋಪಿ ನನ್ನ ಹಣ ಕೇಳಿಕೊಂಡು ಬಂದಿದ್ದೇನೆ ಎಂದರಿಸಿ ನನ್ನ ಉಳಿತಾಯದ ಹಣ ಮತ್ತು ಬೇರೆಯವರಿಂದ ಹಣ ಪಡೆದುಕೊಂಡು ಕೊಟ್ಟೆ ಎಂದು ಹೇಳಿದ್ದೆ ಎಂದರಿಸಿ ದಿನಾಂಕ 5/2/2015 ಹಣ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ಬರಲಿಲ್ಲ ಎಂದರಿಸಿದ್ದೇನೆ. ನೆಕ್ಸ್ಟ್ ನಾನು ಸ್ನೇಹಿತರಿಂದ ಸಾಲವನ್ನು ಸ್ನೇಹಿತರಿಂದ ಸಾಲವನ್ನು ಸ್ನೇಹಿತರಿಗೆ 1 ವಾರಕ್ಕಿಂತ ಮೊದಲೇ ನಾನು ಹಣ ಕೇಳಿದೆ. ಆರೋಪಿಗೆ ಹಣ ಕೊಡಬೇಕು ಎಂದೇ ನಾನು ಕೇಳಿದೆ. ಹಣ ಕೊಡುವಾಗ ಕುಟುಂಬದವರಿಗೆ ಎಷ್ಟು ಹಣ ಬೇಕು ಮತ್ತು ಮರಳಿ ಯಾವಾಗ ಕೊಡುತ್ತಾರೆ ಎಂದು ನಿಗದಿಯಾಗುತ್ತದೆ. ಚೆಕ್ಕಿನಲ್ಲಿ ಬಡ್ಡಿ ಸೇರಿಸಿ ಹಣ ಮಾಡಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಆರೋಪಿ ಬಡ್ಡಿಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಕೊಡುತ್ತೇನೆ ಸೇರಿಸಿ ಒಂದು ವರ್ಷದಲ್ಲಿ ಕೊಡುವುದನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ನನ್ನ ಪ್ರಕಾರ ಆರೋಪಿ ಇದಕ್ಕೆ ವಿಷಯ ಹಣ ಬಳಸಿ ಸಹಿ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. Details of the complaint is placed not sites of financial assistance on the same day. He issued amounts on the same day and he borrowed the amounts from his friends and 1 week prior to I seeking for financial assistance he had borrowed the amounts. So both the courts are heard in the petitioner.
Yes. What is your submission?
What is next? Right. Yes, sir. Chapter 138 of proceedings in a state. Not road. Trial court has rightly rejected the.
Who has filed criminal cases against whom? Who has filed criminal cases against whom? What exhibit D3, D4, D5 and D6 are about? Take note, please receive. The confirmation to conviction for committed body. The summary of the case of the complainant in the trial court was that himself and the accused were neighbors living in the same area for several years. As such, they know each other. On 5/12/2014, the accused approached him and sought financial assistance as a hand loan of a sum of ₹250,000 to meet his urgent family necessities. Considering his request, he bracket complainant gave him a hand loan of a sum of ₹250,000. The accused has promised to repay the same within a period of 1 year with interest thereon at 24% per annum. At the time of borrowing of the loan amount, the accused had issued a post-dated check bearing number 107311 dated 1/3/2016 for a sum of ₹2,50,000 drawn in favor of the complainant and Canara Bank, Longford Town, Bengaluru. The complainant presented the said check the same came to be returned unpaid on 2/3/2016. The banker's share of funds insufficient. Thereafter, he, bracket complainant, got issued a legal notice through his counsel to the accused on 11/3/2016. Even after receipt of the legal notice, the accused neither paid the check amount nor replaced the said notice, which constrained the complainant to institute criminal case against him in the trial court for the offence punishable under section 138 and 40.30. Letter counsel for the petitioner in his argument submitted that complaint was a former employee of Canara Bank. He had no financial capacity to lend such a huge amount of loan to the accused. Thus, this aspect has been brought out in the evidence of PW1. However, the said aspect was not properly appreciated by the trial court and the session judge's court, which had led them to pass an erroneous judgment. For comptroller and counsel, the respondent submits that both the trial court and the session judge's court have rightly appreciated the materials placed before them in their proper perspective and have arrived at an appropriate conclusion, which does not warrant any interference at the hands of this court. Complainant got himself examined as PW1, who in his examination chief in the form of affidavit evidence reiterated the contentions taken up by him in the complaint. In support of his contention, he has got produced the dishonor check at Exhibit P1, the banker's endorsement at Exhibit P2, copy of the legal notice at Exhibit P3, postal receipt and acknowledgement at Exhibit P4 and Exhibit P5 respectively. The accused, though has extensively cross-examined PW1, has not denied that the parties knew each other and accused was the drawer of the check at Exhibit P1. He has also not denied that such check returned for reason of insufficiency of funds in the account of the drawer, and thereafter the complainant got issued a legal notice to him as per Exhibit P3. The above undisputed fact forms a presumption about the existence of legally enforceable debt in favor of the complainant under section 139 of NI Act. Full stop. However, the said presumption is rebuttable. In order to rebut the presumption, the accused, except suggesting to PW1 that he had instituted several similar cases of check bouncing against several other people and producing the certified copies of those judgments at Exhibit D3, D4, D5, and D6, has not placed even other material in corroboration of his contention. No specific defense has been taken by the accused in the cross-examination of PW1. Though the learned counsel for the petitioner contended in his argument that the complainant had no financial capacity, but no specific suggestion to that effect, suggesting to PW1 that he had no financial capacity to lend money was made in the cross-examination of PW1. Admittedly, the accused has not replied to the notice sent by the complainant to him. As such, no such defense was ever taken by the complainant, ever taken by the accused as against the complainant with respect to the transaction in question. So, admittedly, but undisputedly, the petitioner was previously an employee in Canara Bank, and at the relevant point of time, he was doing real estate business and also the business in chits. The accused himself has made suggestion to PW1 to that effect, which has been admitted by the witness. Furthermore, the witness has stated that to lend money to the accused who was his neighbor, apart from he making use available at his end, has also borrowed some money from his friends. No doubt, to show such an alleged borrower, he has not produced any documents. However, the said statement that he borrowed some money from his friends has not been specifically denied in his cross-examination. On the other hand, in the cross of PW1, a specific suggestion was made to the witness, suggesting that prior to the giving of loan, it was pre-decided as to the duration of the loan, the quantum of the loan, and how the said amount would be repaid. The witness has admitted the said suggestion as thus by making such a suggestion to none else than the complainant, comma, the accused has admitted the illicit loan transaction. Furthermore, comma, as observed above, comma, the accused nowhere has denied that the check at Exhibit P1 was drawn by him and the same came to be returned unpaid when presented for realization. Further, nowhere the accused has taken any specific defense as to how come the said check, of which he was the drawer, went into the hands of the complainant. Thus, in the absence of any specific defense and making any attempt to weaken the case of the complainant, the presumption formed in favor of the complainant under section 139 NI Act stands crystallized. It is analyzing these aspects since both the trial court and the session judges court have rightly held the accused and have given an appropriate finding holding the accused guilty of the alleged offense and ordered sentence in proportion to the gravity of the proven guilt. I do not find that the petitioner has got any grounds for admission of this revision petition. Accordingly, the revision petition stands dismissed as devoid of grounds for its admission.
Number 29.
Yes.
Number 29, Sandesh Kumar M.
Yes, please.
The contention of the there was a transaction between the company
But at the instance of the matter, there may be relationship between the company and the business. Employee has to work for gain and gain to depend. It is, my father has issued a check for the guarantee because responding to the Areca merchant. He has purchased the Areca from my father. That is misused. And at the same time, at the duty evidence, I have produced an annexure, P5 exhibit P5. There is an endorsement. Only 35,000 rupees remain to pay by my father. That will be when are you going to pay the amount? I will return the check. As mentioned in the case minutes. No legal supervision.
50% 2 weeks trial court, 50,000 rupees personal bond, 1 emergency notice, PCR, ACR. Process cutting, your court, yes.
Serial number 30, Jairaj G.
Yes. 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 50% 2 weeks trial court, 20,000 rupees. Personal bond, single surety. Emergency notice, PCR, ACR. Process cutting. Yes.
Serial number 31, Vijay Kumar K.
As confirmed the judgment passed by the trial court and check amount is 2 lakhs is the case of the accused before the trial court is that the section there was an agreement between the complainant and the accused regarding the construction of house wherein we have issued post-dated checks to the complainant. After completion of the work, the complainant has to present those checks. Without completion of work, they have presented the check. In that regard, we have lodged a police complaint, and where we have also issued a stop payment letter, and it is not a legally recoverable debt since he has not completed the work. Without completing the work, the said checks has been ordered. Therefore, we are for this court. This fact has been not appreciated by the first appellate court as well as like.
Similar to serial 29. Yes, 50% 2 weeks trial court, personal bond 50,000. Process cutting.
Serial number 34 also same complaint, same accused out of the same case. 34.
Yes. Serial number 32, K. Prasanna Shetty.
Remanded the recording statement and given these not recorded.
Why did the matter was remanded?
Remanded on the ground that was not.
Whether no opportunity was given to the accused to cross-examine you?
No opportunity has been granted. I have put it on. One more not, 3-4 times they have filed recalling application, but certain moment they state that they want to settle the dispute, but they have not either advocate or party has not entered into response, or they are not.
Don't you think that, say, by filing this revision petition and waiting for the appearance of the respondent, and after he appears in this matter, naturally the matter would take long time. The very purpose of you filing a criminal complaint would be frustrated. His purpose would be served. You now ask for a stay. Assuming for a moment the stay is granted, he won't oppose. You don't take steps immediately. And even if you take steps immediately, he don't receive it immediately. Because ultimately his purpose would be served. His purpose would be served. There will be enormous delay. Enormous delay. The check amount is not huge. 16 lakh. So his purpose would be served. Matter would be procrastinated. Ultimately, if this court comes to a conclusion that no, in the best interest of justice, an opportunity be given to accused to cross-examine PW1, but on cost, the very purpose of you approaching this court would be defeated. In the meantime, 8 to 10 years would have been lost. The money value of also would go down. And 16 lakh rupees at the time of the giving the loan, and the 16 lakh rupees in the future date, when assuming for a moment that you once again succeed in the trial court, would be totally different. Allige, the very purpose of you fighting all these aspects would go. Otherwise, now a date is given. At the maximum, what he can do, your cross-examination. If he doesn't cross-examine you on the said date, if he insists the court would again take, even after remanding the matter, the accused has not cross-examined, and it may proceed further to reiterate the previous order. Because order won't vary, then you will be in a better position. Just because oppose the matter, if you come here and oppose, in fact, you are favoring the accused. You are favoring the accused. ಅವರೇನೋ ಹೈಕೋರ್ಟಿಗೆ ಹೋಗೋಣ, ಇಲ್ಲೇನೋ ಆಗಿದೆ, ನಮ್ಮ ವಕೀಲರಿದ್ದಾರೆ, ನಿಮ್ಗೆ ಸ್ಟೇ ಸಿಗುತ್ತೆ ಅಲ್ಲಿ ಮಾಡೋಣ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ನೀವು ಸ್ವಾಮಿ ಅದ್ ಏನೇ ಆಗಲಿ ನಮಗೆ ಸ್ಟೇ ಕೊಡ್ರಿ ಅಂತೀರಿ. ಸ್ಟೇ ಕೊಟ್ರೆ ನಿಮ್ ಜೋಬ್ ತುಂಬುತ್ತೆ, ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ಜೋಬ್ ತುಂಬುತ್ತೆ, ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ನ್ಯಾಯ ಪೈಸೆ ಹೆಲ್ಪ್ ಆಗಲ್ಲ, ಇನ್ನು ಅವನಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಅದ್ರ ಬದಲು ಡೇಟ್ ಕೊಟ್ಟಿರೋ ದಿವಸ ಈಗ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಅಡ್ಜರ್ನ್ ಆಗಿರ್ತದೆ, ಈ ತಿಂಗಳು ಮುಂದಿನ ತಿಂಗಳಲ್ಲೂ ಇರುತ್ತೆ ಮ್ಯಾಟ್ರು. ಹೋಗಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನ್ ಮಾಡ್ತಾರೆ, ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗೂ ಕೂಡ ನೆನಪಿರ್ತದೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಯಾಕಾಯ್ತು, ಹೆಂಗಾಯ್ತು, ಏನ್ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೇನೆ, ನಾನು ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದೇನೆ ಅಷ್ಟು ನೆನಪಿರುತ್ತೆ. ಆ ಸ್ಪಿರಿಟ್ ಇರುತ್ತೆ, ಅವನಿಗೆ ಏನಾದ್ರೂ ಮಾಡಿ ಬುದ್ಧಿ ಕಲಿಸ್ಬೇಕು ಅಂತ. ಚಾನ್ಸಸ್ ಆರ್ ಮೋರ್ ಫೇವರ್ ಟು ಯು ದ್ಯಾನ್ ಟು ಹಿಮ್. ಈಗಿರೋ ಪಾಯಿಂಟ್ ಇಷ್ಟೇ, ವಕಾಲತ್ ವರ್ಸಸ್ ದಿ benefit to your client, which prevails. ಆಗ್ತದ್ರಿ ಇಂಥದ್ರಲ್ಲಿ ಎಲ್ಲ ಅವೆಲ್ಲ ಒಂದೊಂದು ಮೋಡಸ್ ಅಪರೆಂಡೈ. ಇಷ್ಟೆಲ್ಲ ಆದ್ರೂ ಇಂಥವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಾ, 16 ಲಕ್ಷ ಹೋಗ್ಲಿ, ಇನ್ನೊಂದು 50,000 ರೂಪಾಯಿ ಹೋದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗೋಣ ಅಂತಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ತಾರೆ, ಅಲ್ಲಿ ಏನಿಲ್ಲ ಕೇಳೋದು, ಸ್ವಾಮಿ ಅಮೌಂಟ್ ಇಸ್ 16 lakh. Not even a single opportunity was given. A fair opportunity is required to be given because the burden is on me to rebut the presumption. When the burden is on me to rebut the presumption, am I not unfair in expecting a reasonable opportunity? Mugit, iste, one day sentence, 30 seconds. In 30 seconds, order. Nima purpose ಏನಾಗ್ತದೆ? ಏನಿಲ್ಲ, ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ಇದ್ದಾನೆ, ಬ್ಯಾಡ್ ಬಿಡ್ರಿ ಸರ್, ಏನಾದ್ರೂ ಆಗ್ಲಿ, ಇಲ್ಲಿ ಕಾರ್ಪೊರೇಟರ್ ಇದ್ದಾರೆ, ಅವ್ರ ಹತ್ರ ಹೋಗ್ತೀನಿ, ಒಬ್ಬ ಹೊಸ PSI ಬಂದಿದ್ದಾನೆ, ಅವನ ಹತ್ರ ಹೋಗ್ತೀನಿ, ಏನೋ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿಸಿ ಕೊಡಿಸ್ತಾರೆ ಸರ್ ಅಂತಾರೆ. ವಕೀಲರು ನಂಬಲ್ಲ. ರಿಯಲಿ ಇಂಥ ಕೇಸ್ಗಳು ಆಗದೆ ಹಾಗೆ ನೋಡಿ. 3 ದಿವಸ ಅಡ್ಜರ್ನ್ ಮಾಡಿರ್ತೇನೆ.
that magistrate discussed in detail why not the 313 statement was not recorded.
ಹೌದು ರೀ, ಈಗ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಷ್ಟೆಲ್ಲ ಆಗಿದ್ರು ಕೂಡ ಅಸ್ಯೂಮಿಂಗ್ ಫಾರ್ ಅ ಮೂಮೆಂಟ್ ಹೆಚ್ಚಿನದ್ರಲ್ಲಿ ಆಪರ್ಚುನಿಟಿ ಡಿನೈ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎರಡು ಕಾರಣ ಇರ್ತದೆ. ಒಂದು, ಸಾಕಷ್ಟು ಅವಕಾಶ ಕೊಟ್ಟರು ಪಾರ್ಟಿ ಬಂದಿರಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರಲ್ಲ. ಎರಡನೇದು, ಹೆಚ್ಚಿನ ಕೇಸ್ಗಳಲ್ಲಿ ವೈ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜಸ್ ಪಾಸ್ ಸಚ್ ಕೈಂಡ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ಇಸ್ ಫಾರ್ ದ ರೀಸನ್ ದಿ ಅಡ್ವೊಕೇಟ್ ಈಸ್ ಸೇ ಆಫ್ ಎ ನೇಚರ್ ಆಫ್ ಅನ್ ಇರಿಟೇಟಿಂಗ್ ಟು ದಿ ಜಡ್ಜ್. ಕೆಲವು ವಕೀಲರುಗಳು ಏನೆಲ್ಲ ಮಾಡಿದ್ರು ಅವರ ನೇಸ್ ಮಾತುಗಳಿಂದ ಇನ್ನೇನೋ ಪಾಲಿಶಡ್ ವರ್ಡಿಂದ 40 ಆಪರ್ಚುನಿಟಿ ತಗೊಳ್ತಾರೆ. ಇನ್ನೊಬ್ಬ ಅಡ್ವೊಕೇಟ್ ಅವನ ಬಿಹೇವಿಯರ್ ಒಂದ್ ರೀತಿಯ ಸೀನು, ಆ ಇರಿಟೇಷನ್ ಆಟಿಟ್ಯೂಡ್ ಇಂದ 4-5ಕ್ಕೆ ಇವನದ ಕೇಸು ಅಂತ ಹೇಳಿ ಕೇಸ್ ಕರೆದಾಗ್ಲೇ ಜಡ್ಜ್ ಇದ್ದವ್ರು ಅವರಲ್ಲೇ ಬ್ರೈನ್ ಅಲ್ಲೇ ಥಿಂಕ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ. ಇವತ್ತು ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಏನಿಲ್ಲ, ಈ ಕೇಸ್ ಮುಂದೆ ಹಾಕೊಳ್ತೀನಿ, ಇನ್ಯಾರು ಆ ವಕೀಲ ಹತ್ರ ಹೊಡೆದಾಡ್ತಾರೆ ಅಂತ. ಎರಡೂ ಆಗ್ತದೆ. ಅಲ್ಟಿಮೇಟ್ಲಿ ದ ಫ್ಯಾಕ್ಟ್ ರಿಮೈನ್. The onus is on the accused to rebut the presumption. So the reasonable opportunity is not something like that. First opportunity, second opportunity, finally. It all depends upon the circumstance of the case and the court, how it takes and how it gathers. And normally in such a situation, the court generally would not deprive an opportunity to accused or one more opportunity to the accused for cross-examining PW1.
That procedural lapse was there. Even 313(1B is not compliant.
ಈಗ PW1 ಕ್ರಾಸ್ ಅಂತ ಹೇಳಿದ್ರೆ 313 ಆಟೋಮೆಟಿಕ್ಲಿ ಹೋಗುತ್ತೆ ಅಲ್ವೇ? ಹಾಗಾಗಿ ಅದು ಸೆಕೆಂಡರಿ. PW1 ಕ್ರಾಸ್ ಗೆ ಸಫಿಷಿಯಂಟ್ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಪಾಯಿಂಟ್ ಬರ್ತದೆ. ಈಗ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಫಸ್ಟ್ ಡಿಫೆನ್ಸ್, ಅವ್ರ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್.
Even the time of cross-examination, counsel was not present, neither reciprocated. 71-year-old man, again, it is demanded. That is the intention of the crime. Ultimately, I will agree with your logic, but definitely.
Heard the submission of learned counsel for the petition. Produced IA 1/22. Considering the contention taken up in the memorandum of petition and also the affidavit accompanying IA 1/22, petition stands admitted. IA 1/22 is allowed in part. The further proceeding in CC number so and so pending before so and so is stayed pending disposal of this writ petition. Issue notice to the respondent, call for TCR SCR. Mr. Prakash Shetty, you prove to be not good thinking or well thinking in the interest of client. 71 ವರ್ಷದ ಮುದುಕರು ಏನಾದ್ರು ಬೈದ್ರು ಕೇಸ್ ಡಿಲೇ ಆಯ್ತು ಅಂದ್ರೆ ಪಾಪ ನಿಮಗೆ ಬರ್ತದೆ.
ಅವರೇ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿ,
ಅವ್ರಿಗೆ ಕಕ್ಷಿದಾರಗಳಿಗೆ ಗೊತ್ತಿರಲ್ಲ. ನೀವು ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಕಕ್ಷಿದಾರ ತಿಳಿ ಹೇಳಲಿಕ್ಕೆ ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ಹೋಗುವವರೆಗೂ ಕೇಸ್ ಡಿಸೈಡ್ ಆಗಲ್ಲ. ಪಾಪ ನಿಮ್ಮನ್ನು ಸುತ್ತಗಳದು. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Serial number 33. Somsekhar Naidu B.
ಮಕ್ಕಳಿಗೆ ತಿಳಿ ಹೇಳುವ ರೀತಿಯಲ್ಲಿ ಹೇಳಿದ್ರು ಕೂಡ ಪರೋಕ್ಷವಾಗಿ ವಕೀಲರು ತಾವು ಏನ್ ನಿರೀಕ್ಷಿಸಿದ್ದಾರೆ ಅದೇ ಆಗ್ಬೇಕಂತ ಆದ್ರೆ ಕಕ್ಷಿದಾರಿಗೆ ಅವರಿಂದಲೇ ಅನ್ಯಾಯ ಆಗದಾದ್ರೆ ಕೋರ್ಟ್ ಅಸಹಾಯ.
Serial number 33.
ಈಗ ಅದೊಂದು ಟ್ರೆಂಡ್ ಆಗಿದೆ. ಅಡ್ವೊಕೇಸಿ ಅಂತ ಹೇಳಿಬಿಟ್ರೆ ನಂಗೆ ಬಂದಿರೋ ಕೇಸನ್ನ ಗೆಲ್ಬೇಕು, ಬಂದಿರೋ ಕೇಸನ್ನ ಫೈಲ್ ನನ್ನ ಹತ್ರನೇ ಇಟ್ಕೊಳ್ಬೇಕು. ಆ ಜಸ್ಟಿಸ್ ಅನ್ನೋದು ಇಲ್ಲ ಅಲ್ಲಿ. ಆರ್ಡರ್ ರೈಟ್.
33. Somsekhar Naidu B.
Come on settlement, your lordship, for ₹3.50 lakhs. But stated to appear since it was not an appropriate jurisdiction, sought the indulgence of the court court had granted liberty to agitate it before the appropriate bench and had taken the compromise petition on record. Say you have given him 5 DVs of rupees 3 crores and 1 check of rupees 50 lakhs as being recast to your lordship.
If the parties have settled the matter and it is only that the seal of the court is required to be stamped on that alleged settlement, then why don't you keep the respondent also present so that they can take the notice immediately and you can report the settlement in accordance with law. Heard the submission of land counsel for the petitioner who submits that parties have already settled the matter. However, such settlement has to be reported under section 147 of NIA. That a perusal of the petition also would go to show that the submission regarding the settlement was made in the criminal petition filed by the present petitioner against this very same impugned order for a coordinate bench of before this court. A joint memo of alleged compromise was also appears to have been filed in the said petition. The certified copies of the same are produced with this petition. The learned counsel for the petitioner prays for a week's time and submits that he would try to keep the respondent and his counsel also present so that the settlement can be, so that the permission for settlement can be sought for by the court in accordance with law and the matter can be settled without any further delay. Next line. Next line. Bringing to the notice of the petitioner about the liability to pay the graded cost in case the permission for settlement is granted under section 147 of NIA. The time as prayed is granted. Keep them present. I am not ordering summons. Let them come with the wakalat and the settlement application also, so that in the single shot you can clear the entire.
Serial number 34, Vijay Kumar.
23, 11.
Serial number 34, Vijay Kumar K.
And the sentence is 2,15,138. Court has confirmed serial number 31 similar matter between the same complaint, same transaction. The construction agreement may not be posted to checks are issued to the complainant without completing the construction work. Three checks he has in place. Out of them, not one of the check, and that is the subject matter of this revision petition. All the three posted checks he presented and it was dishonored as against the complaint filed. Number 31 is corrected in the process. Yes.
Same order, similar to 31.
But normally our tag one is the one with the three checks, that is also one of the things already the inspectors order is possible, that similar order is possible. Coordination. Right. Along with the serial number 52 or serial number 31 and 34.
Let notice go in this matter. That is also filed by you.
That filed by the same accused, same complaint, same transaction.
Whether the respondent is appearing in that matter,
That is no notice as ordered, but it is not written.
not written. Once notice is ordered in any one of the matter, then you mention this, we will tag it.
Serial number 35, Leelakanta Swami, CS.
Yes, your senior did not take fee in this matter. Ask Vivek whether he has collected single fee or fee in both the cases. Ask him that his teacher is asking. %, 2 weeks trial court, 2 lakhs personal bond, 2 sureties, emergent notice, TCR, SC. Learned counsel, Shri so and so, is called very learned counsel, Shri so and so, who is physically present. Seeks permission to take notice for the respondent and to file vocal for the respondent. Is permitted to take notice for the respondent by wakalat in the registry within 3 days from today. Furnish him the copies. The learned counsel for the petitioner is directed to furnish copies of the memorandum of revision petition along with annexes within a day from today. In the registry.
Serial number 36, Abhishek Malla, MJ.
50% 2 weeks trial court, 30,000 rupees personal bond, single surety. The emergent notice, PCR, SCR, process cut during the course of the case. Number 37 and 1.
Arguments matter, serial number 37, T.V. Vijay Raghavan, Geeta Menon for respondent.
Yes, please.
Lordship, my first submission to your lordship is
Yes.
the date when the judgment of the Sessions Court was passed. The date when the judgment of the Sessions Court was passed, which is imputed.
You can unmask yours.
I have a bad cough, so I just.
Yes.
The date when the Sessions Court judgment was passed, the revised judgment of 2011 was holding the field. The subsequent judgment of Haruni's case came subsequent to the filing of passing of the judgment of the Sessions Court. But Haruni's case does not overrule Nitin Bhai's case. It merely says do not follow the principles laid down in Nitin Bhai mechanically. So as on date, the Sessions Court passed the order, there was no illegality or infirmity because it was a mere application of the law of the Supreme Court at that point.
But as on today, Bharuni's case is there. That's what his argument is.
Yes,
So it is not the law prevailing then. It is the judicial precedent available then. Yes.
After that, Bharuni's case, there no judgment in 2018 and a constitution bench was constituted in 2021 by the Honorable Supreme Court to decide on the procedure and manner in which one I will be passing those judgments to your lordship, has also again explained that factor. Now, your lordship, even in Bharuni's case, what the Supreme Court did was they said they remanded the matter back to the High Court because the High Court applying Nitin Bhai's case sent it back for a de novo trial, as has been done in my case. But the Supreme Court said, it remanded the matter to the High Court to pass an order on merits. Now, if your lordship sees the appeal, your lordship, at para 21. And in page 33.
Yes.
It may be that if the matter is remanded back, the parties may face inconvenience and hardship because already once trial is concluded and judgment is rendered on merits. In this regard, relying on the judgment of the Honorable High Court of Karnataka noted above, I note that the Honorable High Court of Karnataka is pleased to note these circumstances and lay down guidelines to pass necessary orders in the initial stage of the proceeding without expressing anything on merits and regarding the alleged facts and circumstances involved in the case and the nature of evidence placed on record by the parties, as because the proceedings in this case before the trial court are void in nature, in the light of the principles of law laid out in the above said decisions, I am of the view that there is no course open but to remit the matter for fresh trial by settlement. So the Sessions Court did not go into the merits of the matter, the evidence before it, decide whether that evidence, when to appreciate whether that was enough for justifying the conviction given by the magistrate. So, because on the technical point, as regarding say whether it was a summary trial or a sessions trial or summary trial, the court remanded back for de novo trial. So, in effect, just as in Maharuni's case, the court remanded the matter back to the High Court because the High Court remitted the matter for de novo trial. The Supreme Court felt that the High Court should re-examine the matter in the light of its evidence and on merits. So my submission to your lordship would be that this matter may have to be remanded back to the Sessions Court. I'm not saying to the magistrate to re-examine and assess the evidence and a merits on the case because the court refused to go into it on that technical point. Third,
1 minute. Yes.
So many years, should the matter be remitted back to the Sessions Court for checking the evidence?
Sir, you get a chance.
No, the point is this. Now the learner.
No, you get a chance there. He too will. Say the appreciation of the evidence has to be done by the first appellate court. In Bauruni's case, the Court of Appeal had done that. In this case, it has not done. So, the opportunity for reanalysis and reappreciation of the evidence by the first appellate court cannot be denied or deprived to either of you. Either of you. By going there, once again, the Sessions Court, both of you would get an opportunity of approaching this court if the order passed by the appellate court is not satisfactory to you. So that you will get one more opportunity here. Otherwise, if for any reason, if this court appreciates the evidence, reappreciates the evidence and sits as the first appellate court, then both of you would lose one stage of appeal or the revision. The next recourse will be only to Supreme Court. Then, if either of you going to Supreme Court, they agitate this ground that the High Court has denied us or deprived us an opportunity of placing our case before the first appellate court. As a statutory matter, we have got a right there. So by fixing the time limit, outer time limit within so and so date, the matter can be disposed of by the Sessions Court. If the matter is remanded, what prejudice will be caused to your interest?
The evidence will arise, my lord, when there is a contest by the accused saying that I am not liable to pay under the check amount. There is a contest. But here in this case, the accused has approached before the learned magistrate, admitted the liability, and also said that I will make these payments in installments, and also paid certain amount of money during the pendency of the proceeding before the learned magistrate. So the entire case before the magistrate, by learned magistrate, is the accused has come before her and admitted the liability and also said, yes, I will make these payments. You'll also kindly see in page 45.
Mr. Counsel, exactly. Maybe that, even that also to be
appreciated, and whether that acceptance or undertaking or admission by whatever name you call, whether that results in permanently fostering liability upon the accused, whether the accused can be denied or deprived of his further defending the case by raising a fresh ground, has to be considered by the first appellate court. First appellate court. Maybe what you are submitting here, the admission on the part of the accused or admitting his liability towards the complainant, has to be repeated before the sessions court. That is all. The sessions court would appreciate that. If it doesn't appreciate in proper manner, then you would come here. If it appreciate it rightly, then he will come here. But that say that toll, that gate, that stage will be complained. ಅಯ್ಯೋ ವಕೀಲರೇ, ನೀವು ಬರ್ತಿರ್ಲಿಲ್ಲ ಈ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗದೆ ಹೋದ್ರೆ. ನೀವೇನೀಗ ಅರ್ಲಿ ಹೇರಿಂಗ್ ಕೇಳಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಹಾಕಿಸ್ಕೊಂಡಿದ್ದಿಲ್ಲ ಬಹುಶಃ, ಅಲ್ವೇ? ಆಫೀಸ್ನವ್ರು ಹಾಕಲ್ಲ ಇಲ್ಲಿ, ಆಫೀಸ್ನವ್ರು ಹಾಕಲ್ಲ ಇಲ್ಲಿ. ಏನ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಇಲ್ಲಿ. 2004 ಇಂದ ಹೋದ್ ಸರ್ತಿ ರೋಸ್ಟರ್ ಅಂತ ಕೂತಾಗ 2004 ಇಂದ 2008 ವರೆಗಿನದು ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಗಳನ್ನ ಕ್ಲಿಯರ್ ಮಾಡ್ತಾ ಬಂದೆ. ಆ ತಪ್ಪಿಗೆ ನನ್ನನ್ನು ಮತ್ತೆ ಅದೇ ರೋಸ್ಟರ್ಗೆ ಹಾಕಿದ್ರು. ಹಳೆ ಕೇಸನ್ನು ನೀವೇ ಹೇಳ್ಕೊಂಡ್ ಬರ್ತೀರಿ ಸರ್, ನೀವೇ ಮಾಡಿಸ್ತೀರಿ, ನೀವೇ ಮಾಡ್ಬೇಕಂತ ಸಿಜೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ. ಈಗ ಅಲ್ಲಿಂದ ತಗೊಂಡಿದ್ದೇನೆ, ಕ್ಲಿಯರ್ ಆಗ್ತಾ ಬಂದಿದೆ. 2013 ವರೆಗೆ ಬಂದಿದ್ದೇನೆ ನಾನು. ಫಸ್ಟ್ ಯಾವ್ದು ಇಲ್ಲ, ಎಲ್ಲ ಹಳೆದನ್ನೇ ಹಾಕಿ ಅಂತ. ಎಷ್ಟೋದ್ರಲ್ಲಿ ಲೋವರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಗಳೇ ಬಂದಿಲ್ಲ, ಡಿಸ್ಟ್ರಾಯ್ ಆಗಿದೆ ಅಂತಲ್ಲ. ಅದೆಲ್ಲದನ್ನು ಬುದ್ಧಿವಂತಿಕೆಯಿಂದ ಅಲ್ಲೇ ಇಡ್ತಾ ಇದ್ದಾರೆ ಲಿಸ್ಟ್ ಮಾಡದಿದ್ದಾಗೆ. ಅಂಥದನ್ನು ಹುಡುಕಿ ಹಾಕಿಸ್ತಿದ್ದೇನೆ ನಾನು. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಇನ್ನೂ ಲೇಟ್ ಆಗ್ತದೆ. ಇದು ಆ ರೀತಿ ಇನಿಷಿಯೇಟಿವ್ ತಗೊಳ್ದವ್ರು ಇನ್ನೂ ಲೇಟ್ ಆಗ್ತದೆ. ಹೌದು, ಸೆವರಲ್ ಕೇಸಸ್. ಈಗ NIA ಕೇಸ್ಗಳು ನಮ್ಮಲ್ಲಿ ಏನಿದೆ 6000 ಪೆಂಡೆನ್ಸಿ, ಹೆಚ್ಚಿನದ್ರಲ್ಲಿ ಹಾಗೆ ಆಗಿದೆ. ವೆರಿ ಆಬ್ಜೆಕ್ಟಿವ್ ಆಫ್ ದ ಆಕ್ಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡಿಫೀಟೆಡ್. ಏನ್ ಮಾಡ್ತೀವಿ?
ಈಗ ನಾನು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಕೂಡ ಏನಾಗ್ತದೆ, ಕೋರ್ಟ್ ವುಡ್ ಹ್ಯಾವ್ ಸೆಡ್ ಮ್ಯಾಟರ್ ಅರ್ಲಿಯರ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್, ಲೆಟ್ ಇಟ್ ಕಮ್ ಅಪ್ ವಿತ್ ನಾರ್ಮಲ್ ಪ್ರೋಸೆಸ್. It is not that my case will be what you call taken in the.
In Baroni's case, we could have laid down guidelines. That also is not being followed. Then in the latest constitution bench, they said high courts have issued direction to the respective courts. I have not been able to place whether our high court is. But that is the position. In fact, the Supreme Court judgment is an expeditious disposal of 138 cases. The constitution bench.
No, the finance ministry is thinking of, say, bringing one more amendment to NIA. Because of it has observed that, say, the very objective of 138 to 142 has been not fulfilled, or rather frustrated. So reasons are several, multifold. Reasons are multifold, but each one of us has to introspect, both you and me, as to why it is. In fact, both parties were directed to appear before the magistrate in 2013 itself. So can it be remanded now to the sessions court with a direction to dispose of the matter within 4 months? 4 months. Or you say, since he says that you have admitted your liability and even offered to pay the amount in installment, and thus it has come out in the evidence also in the trial court, then considering that, why don't you conclude that settlement amicably before this court itself, so that both of you can save time?
If you call 2 times, I made efforts to send the letter of retirement and asking them. No response, your lordship did not permit me to retire.
Is it possible? She has made an attempt, being frustrated by no response from her client. She even filed a memo of retirement, which this court rejected, telling that, say, the intimation of retirement has been reached the party. So if you are in touch, that means your client is in touch with the respondent. If your client could either, say, establish a connectivity between
the accused and her counsel here, or if your client himself can bring that party here, and in the court itself, the court would ask them in the presence of the learned counsel as to whether they are, say, ready to continue that settlement, maybe with some modified terms, if any, and if the circumstances warrants. If they are agreeable, then there is no bar in recording the settlement here under section 147 NIA. That is another possibility. In such an event, question of remanding doesn't arise. Spending of some more time also won't come in the way. A matter can be amicably settled here. No further appeal. If he doesn't keep up his promise, then coercive action would follow. Probably that appears to be more beneficial to your client. Even assuming for a moment, Mr. Counsel, assuming for a moment that, say, this revision petition is entertained, and judgment is passed on merit. Further assuming that you succeed, still your party would be in Bombay. He has to execute that. So putting that labor, that effort, that expenses at an uncertain future date, putting the very effort or a lesser effort now itself, and putting a permanent end to the matter amicable to both parties would fetch money to your client and satisfaction to the accused. Please. Otherwise, say, I will hear you further your submissions, and all these alleged proposals and the exchange of the views all would go to the background, and only on merit we can proceed. There are counsel from both sides present. There are counsel for the respondent. At the commencement of her argument, submitted that since the Session Judges Court has not decided the matter on its merit with reasons, but has only remanded the matter on some technicalities. If at all, after hearing her further argument, if the court comes to a conclusion that the matter requests to be remanded, the same would be to Session Judges Court with the direction to adjudicate the appeal on its merit. There are counsel from both sides. Also make a submission that considering the age of the criminal case, which is of the year 2010, and the amount involved in the matter, and also in view of the fact that the accused is alleged to have admitted the liability and alleged to have given some proposal for settlement, they would try to contact the parties and ascertain from them whether the parties can settle the matter in a process known to law before this court. In the light of the above, 10 days time as prayed is granted. After Nodi, ನೀವು ನಿಮ್ಮ ಕ್ಲೈಂಟಿಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಯಾರು ಒಬ್ಬ ಡೆಪ್ಯೂಟ್ ಮಾಡಿ ಅಥವಾ ಲೋಕಲ್ ಪರ್ಸನ್ಸ್ ಫ್ರೆಂಡ್ಸ್ ಹೆಲ್ಪ್ ಏನಾದ್ರು ತಗೊಂಡು ಈಗ ಅಂತದಕ್ಕೆಲ್ಲ ಪ್ರೈವೇಟ್ ಏಜೆನ್ಸಿಗಳು ಇದಾವೆ ಮಾಡಿದ್ರೆ ಬೇರೆದೇನ್ ಬೇಡ. ಒನ್ಸ್ ದ ಕಾಂಟ್ಯಾಕ್ಟ್ ಈಸ್ ಎಸ್ಟಾಬ್ಲಿಷ್ that can be ascertained. And counsels can't do without, say, knowing the present address of their client. Yes, they have come back. Yes. Stands adjourned by 10 days. Okay, when do you want? No, whichever is convenient to both of you, because ultimately it is your endurance. Okay. But my calendar don't have 31st November. You have to 30th November. List the matter on 30th November 2022 actually. End of the list includes end of the list.
Matter be heard at the end of the admission list. Serial number 25, SPP. T.S. Rajareshwari for R3 to 5, Mohammed I. Bari for R2, connected.
Ordering.
Submissions.
Yes, please.
Not find. She waited there. Just 10 minutes back, she told that she has given one matter. Since one appeal and revision is filed by the state, I am going to continue. She will join.
Oh, ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರು ಕೇಳಬೇಕಲ್ವೇ? ಮೂರು ಒಂದೇ ಜಜ್ಮೆಂಟ್ ಇಂದ
No, she is complaint appeal. She is signing with state appeal. Respondent accused counsel. There, that counsel is. For brevity of the court, just I will start with my argument. Your Lordship.
2:30. Ordering. At the request of the learned counsel for the appellant. In criminal appeal 283 of the 2013, the matter is again possible. 2:30, ask her colleague to be present.
Definition of the list is serial number 38, final disposal matter. Keshav Bhatt A, R.B. Deshpande for R2 to 5, actually for 1.
This is the complaint method. Respondent number 2 to 5 are the accused method.
An objection regarding the maintainability of the revision petition was made on the previous occasion. You answer that question and then you continue. ಯಾಕೆ ಅಂತ ಪಾಯಿಂಟ್ಗಳೆಲ್ಲ ಮರ್ತು ಹೋಗ್ತದೆ ನಿಮಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ನೆನಪು ಮಾಡಬೇಕು ನೋಡಿ ನಮ್ಮ ಅಡ್ವೊಕೇಸಿ ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಬಂದಿದೆ ಕೋರ್ಟ್ ಏನ್ ಗೊತ್ತಿಲ್ವೋ ಏನ್ ನೆನಪಾಗಲ್ವೋ ಅದನ್ನ ಹಂಗೆ ಬಿಟ್ಬಿಡು Draw my attention to that order, please. ಸರಿ ಹಾಗಾದ್ರೆ ಈಗ ನೀವು ರೀಸನ್ ಅಸೈನ್ ಮಾಡಿ ಇದು ಮೇಂಟೈನಬಲ್ ಅಂತ ಆ ಪಾಯಿಂಟ್ ಆದ್ರ ಮೇಲೆ ಮತ್ತೆ ಮುಂದೆ ಹೋಗಿ ದಟ್ ವಾಸ್ ಎ ಪ್ರಿಲಿಮಿನರಿ objection raised by the other side on the other day. ಹೌದು ವಕೀಲ್ರಿ ಅದನ್ನ ನೀವು ಇಡೀ ನನ್ನ ಮುಂದೆ ಈಗ ನಾನು I am not telling it is not maintainable. I am only asking your response and reaction. ನೀವು ಅಷ್ಟು ಬೇಕಾಗಿಲ್ಲ ಓರಲಿ ಹೇಳಿದ್ರು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಆ ರೀತಿ ಹೆಲ್ಡ್ ಮಾಡಿದೆ Not the way as an advocate say you should come equipped, well equipped. Yes, place that and then proceed. Last time you should address that point first. Point adjournment last time. Point Hatrali, 7 ಕೇಸಲ್ಲಿ the learned members of the bar test my memory. ಸಾಹೇಬ್ರೆ ನೆನಪಿತೋ ಸರಿ ಬಿಡು ನೆನಪಿರಲ್ಲ ನಾವು ಹಂಗೆ ಹೊಡ್ಕೊಂಡು ಹೋಗೋಣ ನಾನು ಅದನ್ನು ಹುಡುಕಿ ಏನ್ ಹೇಳಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ್ ಹೇಳಿದ್ರಿ ಅವಾಗ ಒಂಟಿ ಕಾಲಲ್ಲಿ ನಿಂತಿದ್ರ ಎಡಗೈನ ಮೇಲೆ ಓದಿದ್ರ ಅಥವಾ ಬಲಗೈ ನಿಂತಿದ್ರ ಅವೆಲ್ಲವನ್ನೂ ನಾನು ನಿಮಗೆ ರಿಯಲೈಸ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು ಅವಾಗ ಹೌದು ಅಂತ ಈಗ ಇದರಲ್ಲಿ ಕೂಡ ಅವ್ರ ಪ್ರಿಲಿಮಿನರಿ ಪಾಯಿಂಟ್ ಏನಿತ್ತು ಅದನ್ನ ನೀವು ignoring that you are proceeding further. Last time time ತಗೊಂಡಿದ್ದೀರಿ ನೀವು ಅದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ. ಮಧ್ಯಾಹ್ನ 2:30 ಬರ್ತೀರಿ? Counsel. Yes, please.
Lordship permits. Just I want to bring your lordship's attention.
Objection was raised by the other side. 2 to 5.
Citation is there.
ಇರ್ತದೆ ಅದನ್ನ ಅವ್ರ ಬಾಯಿಂದ ಹೇಳಿಸ್ಬೇಕಲ್ವೇ ಅವ್ರ ಬಾಯಿಂದ ಹೇಳಿಸ್ಬೇಕಲ್ವೇ ಇಲ್ಲವ್ರು ಅವ್ರು ಓದೋದೇ ಇಲ್ಲ ನಾಳೆ ಮೈ ಕಲೀಗ್ ಹ್ಯಾಡ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಅನದರ್ ಮ್ಯಾಟರ್ ಅಂತಾರೆ ಈಗ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಹ್ಯಾಸ್ ಸೆಡ್ ಅಂತಿದ್ದಾರೆ ಅಲ್ವೇ ಅದಕ್ಕೆ ನಾನು ಮಧ್ಯಾಹ್ನನೇ ಹೇಳ್ತೀರಾ ಅಂತ ಕೇಳಿದೆ. Learned counsel for the petitioner and learned SCGP for respondent number 1 are physically present. The learned counsel for the petitioner tries for a day's accommodation to commence his argument, including making his submission regarding the maintainability of this criminal rules petition, as observed on 2/11/2022. This is the matter on 21/11. ಅವತ್ತಿನ ದಿವಸ ಬನ್ನಿ. If the matter reaches today, otherwise it would come on its own. You may have to wait till the matter reaches. Yes. Make a mention when the matter reaches. ಇತ್ತೀಚಿನ ದಿನಗಳಲ್ಲಿ ಜೂನಿಯರ್ ವಕೀಲರುಗಳಿಗೆ ಮಧ್ಯಾಹ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಕಾಯುವ ಪೇಷನ್ಸೇ ಇಲ್ಲ. ನಾನು ಇದೇ ಹೈಕೋರ್ಟ್ನಲ್ಲೇ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದು. ಇಡೀ ದಿವಸ ಬೆಳಗಿಂದ ಸಾಯಂಕಾಲದವರೆಗೆ ಕೋರ್ಟಿನಲ್ಲೇ ಕೂತಿರ್ತಿದ್ವಿ. ಅವತ್ತಿನ ದಿವಸ 4 ಕೇಸ್ ಇರ್ಲಿ ನಮ್ಮ ಆಫೀಸಿಂದು, 40 ಕೇಸ್ ಇರ್ಲಿ ನಮ್ಮ ಆಫೀಸಿಂದು. ಕೋರ್ಟ್ ಹಾಲ್ ಒಳಗೆ ನಾವು ಏನ್ ಕಲಿತೇವೆ ಆ ವಿದ್ಯೆ ನಮಗೆ ಹೊರಗಡೆ ಎಲ್ಲೂ ಸಿಕ್ಕಲ್ಲ. ಈಗ ಜೂನಿಯರ್ಗೆ ಏನಿಲ್ಲ, ಏನಿದ್ರು ಲಂಚ್ ಬ್ರೇಕ್ ಒಳಗೆ ಏನೋ ಒಂದು ಆಗಿ ಬಿಡ್ಬೇಕು ಏನೋದಿಲ್ಲ. ಅಯ್ಯೋ ರೀಚ್ ಆಗ ಡೌಟ್ ಕಣೆ, ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ, ಅವ್ರ ಚಿಕ್ಕಪ್ಪ 5 ಸರ್ತಿ ತೀರಿ ಹೋದ್ರೆ 6ನೇ ಸರ್ತಿ ತೀರಿ ಹೋಗ್ತಾರೆ ಬಿಡು, ಒಂದು ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗ್ತದೆ.
ಬರ್ತೀವಲ್ಲ ತಾವು ಬರ್ತೀವಿ.
ಎಲ್ಲಿಂದ ಕರೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ಸರ್ ಸರ್
Rajesh? Rajesh sir? Rajesh G. Dodmani?
ಹೇಳಿ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಹಾ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Kota sir.
First case, second case over. Clear. Sir, patent sheet, sir, is it clear?
serial number 2.
Clear ಇದೆ sir, voice ಎಲ್ಲ?
Clear. Withdraw ಮಾಡ್ಬೇಕ್ರಿ ಇದು?
ಬರ್ಲಿ.
Withdraw ಮಾಡ್ತೀರಿ serial number 2.
As pertaining to Kalburgi bench, to retake serial number 1, Sri Rajesh Dodmani, SVP served.
Let's, I pay for the petitioners. This is a successive petition, my lords. The earlier order of rejection is at page, my lords, 113. It appears, my lords, on the earlier occasion, the complaint filed by petition number 1 against this complainant was not brought to the notice of the Honorable Court, my lords. I have produced the FIR which is lodged by this petitioner at page 87. This is a complaint which came to be registered on the basis of the complaint filed by this petitioner, accused number 1, my lords.
Counsel for the petition is apparent to the conference. To the respondent, Laurent CGP takes notice for respondent. Each time is granted to file objection if any to the petition. 1 week objection.
Obliged, my lords.
Serial number 2, Sri Shivanand B. Patan Shetty,
My
HCGP
lord,
for
kindly permit me to withdraw the same, my lord, petition.
R2 Aishwarya served.
Kindly permit me to withdraw the same, my lord.
Counsel for the petitioner appearing through video conference. This permission to withdraw this petition as not trust. The above, the petition stands dismissed as not trust. Yes.
Principal bench matters. Serial number 25. SPP.
Within 1026 of one. Whether the prayer made in criminal revision petition 1026/2012 sustains.
Payment was sought. Similarly, on the previous day, that amendment application was allowed by the sample. Then
impose maximum. Class C will be to impose maximum sentence for the offence punishable under section 3 of Offence Act, 3 of Dowry Prohibition. Prior to that, the first one is the acquittal may be removed and the dismissal one has to be inserted. That is the amendments act.
Proceed.
Yes. The appeals in the division is rise out of Genesis from CC 6008 of 2003 on the file of Additional Chief Metropolitan Magistrate, wherein the respondent accused number 1 to 5 have been convicted for the offence punishable in section 498A and section 3 and 4 of Dowry Prohibition Act. The offence of section 498A of IPC, the learned trial judge has convicted and ordered sentence for the imprisonment for the simple imprisonment for the 2 years. And for the offence under section 3 of Dowry Prohibition Act, the learned trial judge has sentenced the respondent accused for 2 years. And for the offence of section 4 of Dowry Prohibition Act, 6 month simple imprisonment was being ordered. Being aggrieved by the set order of conviction, the respondent accused have preferred Criminal Appeal 91 of 2010, challenging the order of conviction. In the meantime, state has also preferred an appeal challenging the inadequacy of a sentence passed for the offence under section 3 of the Dowry Prohibition Act, wherein by virtue of order dated 9/3/2012, the appeal filed by the respondent accused was
Yes.
the appeal filed by the respondent accused was allowed and the order of conviction passed by the learned trial judge was set aside. In the meantime, by virtue of the same order, both appeals were clubbed together and the common order was passed, wherein the state appeal filed in Criminal Appeal 466 for 2010, praying to impose maximum sentence for the offence under section 3 of Dowry Prohibition Act, was dismissed by the first appellate court. Now, being aggrieved by the set order of dismissal of the state appeal for inadequacy of sentence, state has prepared criminal revision petition number, and in the meantime, setting aside the order of conviction and passing the order of acquittal for the respondent accused, the criminal appeal has been preferred by the state. In the meantime, the complainant also filed criminal appeal before this honorable court to confirm the order of conviction passed by the trial court. That state has prepared a criminal appeal number 1169 of 2012 against the order of setting aside the conviction, and the criminal revision petition 1026 of 2012, which was challenged dismissing the appeal filed by the state in criminal appeal 91 of 2010. No, 466 of 2010. Now, my humble submission to this honorable court. The prosecution has led the evidence and got examined PW 1 to 9. The date of marriage is
1998. 23/3/1998. Date of complaint for which the law was taken into motion. 10/1/2002. My humble submission to this honorable court. At first, without going to the evidence on record, if your lordship permits, I will go through with the reasoning given by the first appellate court to set aside the order of conviction. Thereafter, if your lordship permits, I will go through with the evidence so that repetition of evidence, that time will be shortened.
Without knowing the evidence, how can you appreciate the reason?
I will go through with it. I will.
In the impugned judgment, you can skip the portion of the evidence. You can confine to reasoning, provided you read the evidence first.
First, I would like to draw your lordship kind attention to Exhibit P1 complaint. Exhibit P1 complaint. Proceed, your lordship.
Yes.
Directly, I will go to the main. ಮೇಲ್ಕಂಡ ವಿಷಯದ ಬಗ್ಗೆ ತಮ್ಮಲ್ಲಿ ನೀಡುತ್ತಿರುವ ದೂರು ಏನೆಂದರೆ ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳು the complainant is wife of accused number 1. So wife has filed this complaint. ತಂದೆ ತಾಯಿಗಳು ದಿನಾಂಕ 23/3/98 ಇಸ್ವಿಯಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರದ ಚಂದ್ರ ಬಡಾವಣೆಯ 8ನೇ ಕ್ರಾಸ್ನಲ್ಲಿರುವ ಮನೆ ನಂಬರ್ 1234/B ನಲ್ಲಿ ವಾಸವಾಗಿರುವ ಶ್ರೀಮತಿ ಜಯಮ್ಮ ರಾಮಕೃಷ್ಣರವರ ಎರಡನೇ ಮಗನಾದ ಶ್ರೀನಿವಾಸ ಎಂಬುವನಿಗೆ ಕೊಟ್ಟು ಶಾಸ್ತ್ರೋಕ್ತವಾಗಿ ಹೊಸಕೆರೆಹಳ್ಳಿ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿರುವ ಸುಂದರ ಮಹಲ್ ಕಲ್ಯಾಣ ಮಂಟಪದಲ್ಲಿ ಹಿರಿಯರ ಸಮ್ಮುಖದಲ್ಲಿ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದರು. ಮದುವೆಯಾದಾಗಿನಿಂದ ನಾನು ನನ್ನ ಗಂಡ ಮತ್ತು ನನ್ನ ಅತ್ತೆ ಮಾವನವರ ಜೊತೆಯಲ್ಲಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡಿದ್ದೆನು. ನನ್ನ ಮದುವೆಯಾದ 4 ತಿಂಗಳು ಎಲ್ಲರೂ ಚೆನ್ನಾಗಿದ್ದರು. ನನ್ನ ಮದುವೆಯ ಸಮಯದಲ್ಲಿ ರು 80,000 ನಗದು ಹಣ ಮತ್ತು ನಮ್ಮ ಯಜಮಾನಿಗೆ ಒಂದು ಟೈಟಾನ್ ಗಡಿಯಾರ, ಸೆಕೆಂಡ್ ಒನ್ ಚಿನ್ನದ ಬ್ರಾಸ್ಲೈಟ್ ಒಂದು 30 ಗ್ರಾಂ, 2 ಉಂಗುರ 18 ಗ್ರಾಂ, 1 ಕತ್ತಿನ ಚೈನು 20 ಗ್ರಾಂ ಇವುಗಳನ್ನು ನಮ್ಮ ತಂದೆ ತಾಯಿಗಳು ಕೊಟ್ಟರು. ನಂತರ ನನಗೆ ಒಂದು ಲಾಂಗ್ ಚೈನು 70 ಗ್ರಾಂ, ನೆಕ್ಲೆಸ್ ಜೊತೆಗೆ ಹರಳು 35 ಗ್ರಾಂ, ಓಲೆ ಮತ್ತು ಮಾಟಿ 13 ಗ್ರಾಂ, ಗುಂಡೋಲೆ 6 ಗ್ರಾಂ, ಹ್ಯಾಂಗಿಂಗ್ಸ್ 10 ಗ್ರಾಂ, ಬಳೆಗಳು 6 78 ಗ್ರಾಂ, ಉಂಗುರ 3.16 ಗ್ರಾಂ, ಚೈನು 38 ಗ್ರಾಂ ಇವುಗಳನ್ನು ಕೊಟ್ಟಿದ್ದರು. ನಾನು ನನ್ನ ಗಂಡನ ಜೊತೆ 2 ತಿಂಗಳು ಸಂಸಾರ ಮಾಡಿದ ನಂತರ ನನಗೆ ಹಣದ ತೊಂದರೆ ಇದೆ, ನಿಮ್ಮ ತಂದೆ ತಾಯಿ ಹತ್ತಿರ 20,000 ಹಣ ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದರು. ನಾನು ಅದರಂತೆ 20,000ಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದು ನಮ್ಮ ಯಜಮಾನರಿಗೆ ಕೊಟ್ಟೆ. ನಂತರ ನನ್ನ ಅತ್ತೆಯಾದ ಜಯಮ್ಮ, ನಮ್ಮ ನಾದಿನಿಯಾದ ಅಭಿನಯ, ಮೈದುನನಾದ ಚಲುವ ಮತ್ತು ನಮ್ಮ ಮಾವನಾದ ರಾಮಕೃಷ್ಣರವರು ಸೇರಿ ನಾವು ಮನೆ ಕಟ್ಟಿಸಿ ಸಾಲ ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ತಂದೆಯವರ ಮನೆಗೆ ಹೋಗಿ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣ ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದು ಪ್ರತಿದಿನ ಹಿಂಸಿಸಿ ಪೀಡಿಸುತ್ತಿದ್ದರು. ನಾನು ಈ ವಿಷಯವನ್ನು ನಮ್ಮ ತಂದೆಯವರಿಗೆ ಬಂದು ತಿಳಿಸಿದೆ. ಅವರು ನನ್ನನ್ನು ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ನನ್ನ ಗಂಡನ ಕಡೆಯವರಿಗೆ ಬುದ್ಧಿ ಹೇಳಿ ನಮಗೆ ಅಷ್ಟೊಂದು ಹಣ ಕೊಡಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ಹೇಳಿ ನನ್ನನ್ನು ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಬಿಟ್ಟು ಹೋದರು. ನಂತರ ನನ್ನ ಗಂಡ, ಮಾಮ, ಅತ್ತೆ, ನಾದಿನಿ, ಮೈದುನ ಇವರೆಲ್ಲರೂ ಸೇರಿ ಸೋ ಅಂಡ್ ಸೋ ಹಣ ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದರೆ ನಿಮ್ಮ ತಂದೆ ತಾಯಿಯನ್ನು ನ್ಯಾಯ ಮಾಡುವುದಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದೀಯಾ, ಸೋ ಅಂಡ್ ಸೋ ನಮ್ಮ ಶ್ರೀನಿವಾಸನಿಗೆ ಇನ್ನೊಂದು ಮದುವೆ ಮಾಡಿಸುತ್ತೇವೆ ಎಂದು ನಮ್ಮ ತಂದೆ ತಾಯಿಯವರು ಕೊಟ್ಟಿದ್ದ ಒಡವೆಗಳನ್ನು ಬಿಚ್ಚಿಸಿಕೊಂಡು ಬಿಟ್ಕೊಂಡರು. ದಟ್ ಲಾಸ್ಟ್ ಲೈನ್ ಇಟ್ ವಾಸ್. ಅಷ್ಟರಲ್ಲಿ ನಾನು 7 ತಿಂಗಳ ಗರ್ಭಿಣಿ. ಬಾಣಂತನಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ನೀನು ಬಾಣಂತನ ಮುಗಿಸಿಕೊಂಡು ವಾಪಸ್ ಬರುವಾಗ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣವನ್ನು ತರದಿದ್ದರೆ ನಮ್ಮ ಮನೆಗೆ ಬರಬೇಡ ಎಂದು ಎಲ್ಲರೂ ಹೆದರಿಸಿದರು. ನಂತರ ನಮ್ಮ ತಾಯಿ ತಂದೆಯವರು ನನ್ನನ್ನು ಬಾಣಂತನಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದರು. ನಾನು ಗಂಡು ಮಗುವಿಗೆ ಜನ್ಮ ನೀಡಿ ಸುಮಾರು 3 ವರ್ಷವಾಗಿದೆ.
ಅಂದಿನಿಂದ ನನ್ನ ಗಂಡನ ಕಡೆಯವರು ಯಾರೂ ಬಂದು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ನಮ್ಮ ತಂದೆ ತಾಯಿ ಹಾಗೂ ನಮಗೆ ಪರಿಚಯವಿರುವ ಸಿದ್ದವೀರಣ್ಣ, ನರಸಿಂಹಯ್ಯ, ಸುರೇಶ ಹಾಗೂ ಚಿಕ್ಕಮ್ಮನವರು ಹಲವಾರು ಬಾರಿ ಹೋಗಿ ನನ್ನ ಗಂಡ ಮತ್ತು ಹಾಗೂ ಅವರ ಕಡೆಯವರಿಗೆ ಬುದ್ಧಿ ಹೇಳಿ ನ್ಯಾಯ ಮಾಡಿದ್ಯಾಗಿಯೂ ಸಹ ಬಂದು ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ನಮ್ಮ ಅತ್ತೆಯವರ ಮನೆಗೆ ರಾತ್ರಿ ಸಮಯದಲ್ಲಿ ಯಾರ್ಯಾರೋ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿಗಳು ಬರುತ್ತಿದ್ದು, ನಮ್ಮ ಅತ್ತೆಯವರು ಮತ್ತು ನನ್ನ ಮೈದಾ ಮತ್ತು ಮಾವನವರು ಸೇರಿ ಅವರ ಜೊತೆಯಲ್ಲಿ ಹೋಗಿ ಮಲಗಿ ಅವರಿಗೆ ಸುಖ ನೀಡು ಎಂದು ಅವರು ನನಗೆ ಹಣ ಕೊಡುತ್ತಾರೆಂದು ಹೇಳುತ್ತಿದ್ದರು. ಆದ್ದರಿಂದ ಇನ್ನೂ ಹೆಚ್ಚಿನದಾಗಿ ವರದಕ್ಷಿಣೆ ತರದಿದ್ದರೆ ನಿನ್ನನ್ನು ಬಾಳುವುದಕ್ಕೆ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ನನ್ನ ಗಂಡ, ಅತ್ತೆ, ಮಾವ ಮತ್ತು ಎಲ್ಲರೂ ಮದ್ಯಪಾನ ಮಾಡಿ ನನಗೆ ದೈಹಿಕವಾಗಿ ಮತ್ತು ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದರು. ಇದಕ್ಕೆ ಮುಖ್ಯ ಕಾರಣಕರ್ತ ಶ್ರೀ ನಾರಾಯಣ, ವೆಂಕಟರಾಜು ಮತ್ತು ಬಾಯಮ್ಮನವರು ಎಂಬುವರು. ಇವೇ ನನ್ನ ಹಾಗೂ ನನ್ನ ಗಂಡನ ಮದುವೆಯನ್ನು ನಿಂತು ಮಾಡಿಸಿದ್ದರು. ಶ್ರೀಮತಿ ವಿಜಯಮ್ಮ ಎಂಬುವರು ಬ್ರೋಕರ್ ಆಗಿದ್ದು, ಇವಳು ಹೆಣ್ಣನ್ನು ತೋರಿಸ್ತೇನೆ ಎಂದು ಹೇಳಿ ಗಂಡ ಮನೆಗೆ ಬಂದಾಗ ಅವರಿಗೆ ಹೇಳಿದಂತೆ ಕೇಳು ಎಂದು, ಇಲ್ಲದಿದ್ದರೆ ತಾಳಿ ಕಿತ್ತು ಹಾಕಿ ಹೋಗು ಎಂದು ಹೇಳುತ್ತಾಳೆ. ಇವರು ನನ್ನ ತಂದೆ ತಾಯಿಯವರಿಂದ ಮದುವೆಯ ಸಮಯದಲ್ಲಿ ರು 15,000 ಕಮಿಷನ್ ಪಡೆದಿರುತ್ತಾರೆ. ದಿನಾಂಕ 9/11/2002 ನಾನು ಮತ್ತು ನಮ್ಮ ತಂದೆಯವರು ನನ್ನ ಯಜಮಾನರು ವಾಸವಾಗಿರುವ ಚಂದ್ರ ಲೇಔಟ್ಗೆ ಬಂದು ಯಾಕೆ ನನ್ನ ಮಗಳನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬರಲಿಲ್ಲ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ ನಮ್ಮ ಯಜಮಾನರು ಮತ್ತು ಅವರ ಮನೆಯವರು, ನೀವು ನನಗೆ 1 ಲಕ್ಷ ರು ವರದಕ್ಷಿಣೆ ನೀಡಿದರೆ ಮಾತ್ರ ನಿಮ್ಮ ಮಗಳನ್ನು ಮನೆಯೊಳಗೆ ಸೇರಿಸಿಕೊಳ್ಳುತ್ತೇವೆಂದು ಏರ್ದ ಧ್ವನಿಯಲ್ಲಿ ಬೈದು ಕಳುಹಿಸಿದರು. ನಾವು ಎಷ್ಟೇ ಕೇಳಿಕೊಂಡರೂ ನಮ್ಮನ್ನು ಮನೆಯೊಳಗೆ ಕರೆಯಲಿಲ್ಲ. ನಾವು ಬೇಸರಗೊಂಡು ವಾಪಸ್ ಬರುವಾಗ ನೀವು 1 ಲಕ್ಷ ಹಣ ಕೊಡದಿದ್ದರೆ ನಿಮ್ಮ ಸಂಸಾರವನ್ನು ಕೊಲೆ ಮಾಡಿ ಮುಗಿಸುತ್ತೇವೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ರೀತಿ ಇನ್ನೂ ಹೆಚ್ಚಿನದಾಗಿ ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತರುವಂತೆ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆಯನ್ನು ನೀಡುತ್ತಿದ್ದ ನನ್ನ ಗಂಡ ಶ್ರೀನಿವಾಸ್, ನನ್ನ ಅತ್ತೆ ಜಯಮ್ಮ, ನನ್ನ ಮಾವ ರಾಮಕೃಷ್ಣ, ನನ್ನ ನಾದಿನಿ ಅಭಿನಯ, ನನ್ನ ಮೈದುನ ಚಲ್ವ ರವರ ವಿರುದ್ಧ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಜರುಗಿಸಿ ನನಗೆ ನ್ಯಾಯ ದೊರಕಿಸಿಕೊಡಬೇಕಾಗಿ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಂಡಿರುವ ನತದೃಷ್ಟೆ. ಸೊ ಕಂಪ್ಲೇಂಟ್ ವಾಸ್ ಲಾಡ್ಜ್ಡ್ ಆನ್ 10/11/2022. Now, after a lapse of 4 years, in the year 2016, the evidence of PW1 was recorded. 31/7/2006 chief evidence was recorded. The entire chief evidence is replica of the government's made in complaint. If your lordship permits, I will go through with the chief evidence.
Yes.
The third para will the relevant portions. ಗುಟ್ಟಹಳ್ಳಿಯಲ್ಲಿ ನನ್ನ ತವರು ಮನೆ ಇದೆ. ಆರೋಪಿತರು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನ್ನನ್ನು ನೋಡಿ 1ನೇ ಆರೋಪಿಗೆ ಮದುವೆ ಮಾಡಲು ಒಪ್ಪಿಕೊಂಡಿದ್ದರು. ಮಾತುಕತೆಗೆ ಮನೆ ಸಣ್ಣದಾಗುತ್ತದೆ. ಬ್ಯಾಂಕ್ ಕಾಲೋನಿಯಲ್ಲಿ ನನ್ನ ದೊಡ್ಡಪ್ಪನಾದ ಗುಂಟಯ್ಯ ಎನ್ನುವರ ಮನೆಯಲ್ಲಿ ಮಾತುಕತೆ ಮಾಡೋಣ ಎಂದು ಮದುವೆಗಿಂತ ಅಜಮಾಸ 15 ದಿನಗಳ ಹಿಂದೆ ಮಾತುಕತೆ ಮಾಡಿದ್ದರು. ಮಾತುಕತೆಯ ವೇಳೆ ನಮ್ಮ ಕಡೆಯಿಂದ ನಮ್ಮ ತಂದೆ ತಾಯಿ, ನಮ್ಮ ಅಣ್ಣ ಸಿದ್ಧ, ರಾಜು, ಬಾಯಮ್ಮ, ವೆಂಕಟರಾಜು, ಸುರೇಶ, ಚಿಕ್ಕಮ್ಮ ಇದ್ದರು. ಆರೋಪಿತರ ಕಡೆಯಿಂದ 1ನೇ ಆರೋಪಿ, ಅವನ ತಂದೆ ತಾಯಿ, ಮೈದುನ, ನಾದಿನಿ ಇನ್ನೂ ಬಹಳಷ್ಟು ಜನ ಬಂದಿದ್ದರು. ಮಾತುಕತೆಯ ವೇಳೆ ಅರ್ಧ ಕೆಜಿ ಚಿನ್ನ ಕೊಡಲು ಕೇಳಿದರು. ಅಷ್ಟು ಕೊಡಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದಕ್ಕೆ 1/4 ಕೆಜಿ ಚಿನ್ನ ಕೊಡಿ ಎಂದು ಕೇಳಿದರು. ರೂಪಾಯಿ 80,000 ನಗದು ವರದಕ್ಷಿಣೆಯಾಗಿ ಕೊಡುವಂತೆ ಕೇಳಿದರು. 1ನೇ ಆರೋಪಿಗೆ ಬಂಗಾರದ ಬ್ರಾಸ್ಲೆಟ್, 2 ಬಂಗಾರದ ಉಂಗುರ, 1 ಕೊರಳಿನ ಬಂಗಾರದ ಚೈನು ಹಾಗೂ ವಾಚ್ ಕೊಡಬೇಕೆಂದು ಕೇಳಿದ್ದರು. ಅದಷ್ಟು ಕೊಡಲು ನಮ್ಮ ತಂದೆ ತಾಯಿ ಒಪ್ಪಿಕೊಂಡಿದ್ದರು. ಅಲ್ಲದೆ ಮದುವೆ ಖರ್ಚನ್ನು ನಮ್ಮ ತಂದೆ ತಾಯಿಯೇ ವಹಿಸಿಕೊಳ್ಳಬೇಕೆಂದು ಹೇಳಿದ್ದರು. ದಿನಾಂಕ 23/3/98 1ನೇ ಆರೋಪಿಯ ಜೊತೆ ನನ್ನ ಮದುವೆ ಗಿರಿನಗರದಲ್ಲಿರುವ ಸುಂದರಮಹಲ್ನಲ್ಲಿ ಆಗಿತ್ತು. ಮದುವೆಯಾದ ನಂತರದಲ್ಲಿ ನಾನು ಚಂದ್ರಾಲಯನವರ ಮನೆಯಲ್ಲಿ 1ನೇ ಆರೋಪಿಯ ಮನೆಗೆ ದಾಂಪತ್ಯ ಜೀವನಕ್ಕೆ ಹೋಗಿದ್ದೆನು. 4 ತಿಂಗಳವರೆಗೆ ಆರೋಪಿತರು ನನ್ನನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿದ್ದರು. In the complaint it was mentioned 2 months. Here she says for the first 4 months she was cordially resided at the matrimonial house. ರೂಪಾಯಿ 20,000 ವರದಕ್ಷಿಣೆಯನ್ನು ತವರು ಮನೆಯಿಂದ ತರಬೇಕೆಂದು ಆರೋಪಿತನಿಗೆ ಕಿರುಕುಳ ಕೊಟ್ಟಿದ್ದು, ನನ್ನ ತವರು ಮನೆಯವರು ಮದುವೆಯಾದ ನಂತರವೂ ವರದಕ್ಷಿಣೆಯಾಗಿ 20,000 ಕೊಟ್ಟಿದ್ದರು. 1ನೇ ಆರೋಪಿ ಮನೆಗೆ ಕುಡಿದು ಬಂದು ನನಗೆ ಬಹಳ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದನು. ತವರು ಮನೆಯಿಂದ ರೂಪಾಯಿ 1,00,000 ವರದಕ್ಷಿಣೆಯನ್ನು ತರದೇ ಇದ್ದರೆ ನಿನಗೆ ಏನಾದರೂ ಮಾಡುತ್ತೇನೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕುತ್ತಿದ್ದನು. ಆರೋಪಿತರ ಮನೆಗೆ ಯಾರ್ಯಾರೋ ಗಂಡಸರು ಬರುತ್ತಿದ್ದರು. 1ನೇ ಆರೋಪಿ ನನ್ನ ಬಳಿ ಅವರ ಜೊತೆ ಮಲಗು, ಹಣ ಸಿಗುತ್ತದೆ ಎಂದು ಹೇಳುತ್ತಿದ್ದನು. 1ನೇ ಆರೋಪಿಯ ಜೊತೆ ನನ್ನ ದಾಂಪತ್ಯ ಜೀವನದಿಂದ ನಾನು ಗರ್ಭಿಣಿಯಾಗಿದ್ದು ಶ್ರೀಮಂತಕ್ಕೆಂದು ನಾವು ತವರು ಮನೆಗೆ ಹೋಗುವಾಗ ನನ್ನ ಮೈ ಮೇಲಿದ್ದ ಎಲ್ಲಾ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ನನ್ನ ಅತ್ತೆ ಈಸಿದುಕೊಂಡಿದ್ದರು. ನಾನು ತವರು ಮನೆಗೆ ಹೋದ ನಂತರದಲ್ಲಿ ದಿನಾಂಕ 24/99 ನಾನು ಕೆಂಪೇಗೌಡ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಒಂದು ಗಂಡು ಮಗುವಿಗೆ ಜನ್ಮ ಕೊಟ್ಟೆನು. ಆರೋಪಿತರು ನನ್ನನ್ನಾಗಲಿ ನನ್ನ ಮಗುವನ್ನಾಗಲಿ ನೋಡಲು ಬಂದಿರಲಿಲ್ಲ. ಆ ನಂತರದಲ್ಲಿ ನನ್ನ ತಂದೆ ಆರೋಪಿತರ ಮನೆಗೆ ಹೋಗಿ ಸೊಸೆಯನ್ನು ಹಾಗೂ ಮೊಮ್ಮಗವನ್ನು ಕರೆದುಕೊಳ್ಳುವಂತೆ ಎಷ್ಟು ಕೇಳಿಕೊಂಡರು ಆರೋಪಿತರು 1,00,000 ಹಣ ಕೊಡದೆ ಸೊಸೆ ಹಾಗೂ ಮೊಮ್ಮಗನನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಳ್ಳುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದರು. ಆ ನಂತರದಲ್ಲಿ ಆರೋಪಿತರ ವಿರುದ್ಧ ಚಂದ್ರಾಲಯ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ಕೊಟ್ಟೆನು. ಅದನ್ನು ನೋಡಿದರೆ ತಿಳಿಸುತ್ತೇನೆ. ಸೊ ಹಿಯರ್ there is a corroboration with regard to the complainant's father going to the house of the accused person, calling them to take her daughter and grandchildren to their house, which was denied by the respondent accused. There is a corroboration with regard to the complainant, our mentioned complaint. Sakshi and EP that portions of it. ತೋರಿಸಲಾಗಿ ನೀತಿ 1 ಅಂತ ಗುರುತಿಸಿದ್ದಾರೆ. ನಾನು ದೂರು ಕೊಟ್ಟ ನಂತರದಲ್ಲಿ ಪೊಲೀಸರು ಆರೋಪಿತರ ಮನೆಗೆ ಹೋಗಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಒಂದು ಬಂಗಾರದ ನೆಕ್ಲೆಸ್, 4 ಬಂಗಾರದ ಬೆಳೆ, ಇನ್ನೊಂದು ಬಂಗಾರದ ಕೊರಳ ಚೈನು, 3 ಬಂಗಾರದ ಉಂಗುರ, 2 ಕಿವಿಯ ಬಂಗಾರದ ಓಲೆ, 1 ಬಂಗಾರದ ಬ್ರಾಸ್ಲೆಟ್, 1 ವಾಚ್, 2 ಬಂಗಾರದ ಉಂಗುರ, 1 ಬಂಗಾರದ ಕೊರಳ ಚೈನು PSI ER ರಂಗನಾಥ್ ಎನ್ನುವರು ಮಾಜರ್ ಮೂಲಕ ಜಪ್ತು ಮಾಡಿದ್ದರು. These details also corroborate with the exhibit B1 complaints. ನೀತಿ 2ರ ಮಾಜರ್ ಮೇಲೆ ನೀತಿ 2A ನನ್ನ ಸಹಿ ಇದೆ. ಆ ಒಡವೆಗಳನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವುದು ಅವಶ್ಯವಿರುವುದರಿಂದ ಅವುಗಳನ್ನು ನನಗೆ ಬಿಟ್ಟು ಕೊಡದೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುತ್ತೇವೆಂದು PSI ER ರಂಗನಾಥ್ ಅವರು ಹೇಳಿದರು. ಮದುವೆಗಿಂತ 1 ವಾರ ಮೊದಲು ರೂಪಾಯಿ 80,000 ವರದಕ್ಷಿಣೆಯಾಗಿ ನನ್ನ ಅತ್ತೆಗೆ ಕೊಟ್ಟಿದ್ದೆವು. ನನ್ನ ಗಂಡನಿಗೆ ಹಾಗೂ ನನಗೆ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಮದುವೆ ವೇಳೆಯಲ್ಲಿ ನನ್ನ ತವರು ಮನೆಯವರು ಕೊಟ್ಟಿದ್ದರು. ನನ್ನ ಮದುವೆಗೆ ಸಂಬಂಧಿಸಿ ಮದುವೆ ಲಗ್ನ ಪತ್ರಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದನ್ನು EP 3 ಥರ್ಡ್ ಲೈನ್ ಸ್ವಾಮಿ. ನನ್ನ ಗಂಡು ಮಗುವಿಗೆ ಚಂದನ ಎಂದು ಹೆಸರಿದ್ದು ಅವನಿಗೆ ಈಗ 7 ವರ್ಷ ಪ್ರಾಯ. 1ನೇ ಆರೋಪಿ ವಿಧಾನಸೌಧದಲ್ಲಿ ಗುಮಾಸ್ತನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಾನೆ. ತನ್ನ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟಲ್ಲಿ ನಿನ್ನನ್ನು ಹಾಗೂ ನಿನ್ನ ತವರು ಮನೆಯವರನ್ನು ಸಾಯಿಸ್ತೇನೆಂದು 1ನೇ ಆರೋಪಿ ನನಗೆ ಬೆದರಿಕೆ ಹಾಕಿದ್ದನು. ಮದುವೆಯಾದ ನಂತರದಲ್ಲಿ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆಗಾಗಿ ಆರೋಪಿತರು 4 ತಿಂಗಳ ನಂತರದಲ್ಲಿ ನನ್ನನ್ನು ತವರು ಮನೆಗೆ ಕಳಿಸಿದ್ದರು. ಆ ವೇಳೆಯಲ್ಲಿ ನನ್ನ ತವರು ಮನೆಯವರು ಆರೋಪಿತನ ಜೊತೆ ರಾಜಿ ಪಂಚಾಯಿತಿ ಮಾಡಿ ರೂಪಾಯಿ 20,000 ವರದಕ್ಷಿಣೆ ಕೊಟ್ಟಿದ್ದರು. ನೀನು ಮನೆಯಿಂದ 1,00,000 ರೂಪಾಯಿ ವರದಕ್ಷಿಣೆ ತರದಲ್ಲಿ ಒಂದು ಗತಿ ಕಾಣಿಸ್ತೇವೆ ಎಂದು ಆರೋಪಿ ನಂಬರ್ 1 ರಿಂದ 5 ರವರು ನನಗೆ ಹೆದರಿಸುತ್ತಿದ್ದರು. ತಮ್ಮ ಮನೆಗೆ ಯಾರ್ಯಾರೋ ಬರುತ್ತಾರೆ ಅವರನ್ನು ಪ್ರೀತಿಸಿ ಅವರ ಜೊತೆ ಸೋ ಮಾಡಿದ್ದಲ್ಲಿ ಹಣ ಬರುತ್ತದೆ ಎಂದು ಆರೋಪಿ ನಂಬರ್ 1 ರಿಂದ 5 ರವರು ನನಗೆ ಹೇಳಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದರು. ಮದುವೆಯ ಬ್ರೋಕರ್ ಜಯಮ್ಮ ಅನ್ನುವರಿಗೆ ನಾವು ರೂಪಾಯಿ 15,000 ಕೊಟ್ಟಿದ್ದೆವು. ಮದುವೆಯಾದ ನಂತರದಲ್ಲಿ ಅವಳು ಆರೋಪಿ ಜೊತೆ ಶಾಮೀಲಾಗಿ ಅವರು ಹೇಳಿದಂತೆ ಕೇಳಬೇಕೆಂದು ನನಗೆ ಹೇಳುತ್ತಿದ್ದಳು. ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ corroborate with the version of exhibit B1 complaint. ದೂರು ಕೊಟ್ಟ ನಂತರದಲ್ಲಿ ಪೊಲೀಸರು ಆರೋಪಿತರು ಮನೆಗೆ ಹಾಗೂ ನನ್ನ ತವರು ಮನೆಗೆ ಬಂದು ವಿಚಾರಣೆ ಮಾಡಿದ್ದರು. ಆ ವೇಳೆಯಲ್ಲಿ ಪೊಲೀಸರು ಆರೋಪಿತರ ಮನೆ ಬಳಿ ಮಾಡಿದ ಸ್ಥಳ ಮಜಲಿಗೆ ನಾನು ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಈಗ ನಾನು ಹಾಗೂ ನನ್ನ ಮಗ ನನ್ನ ತವರು ಮನೆಯಲ್ಲಿ ಇದ್ದೇವೆ. ಆರೋಪಿತರನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ. ಆ ಪೈಕಿ ಆರೋಪಿ ನಂಬರ್ 1, 2 ಹಾಗೂ 4ನೇಯವರು ಕಟಕಡೆಯಲ್ಲಿ ನಿಂತಿದ್ದಾರೆ. ಆರೋಪಿ ನಂಬರ್ 2 ಹಾಗೂ 3ನೇಯವರು ಗೈರು ಹಾಜರಾಗಿದ್ದು ಆ ಬಗ್ಗೆ ಆರೋಪಿತರ ವಕೀಲರು ವಿನಾಯಿತಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 1ನೇ ಆರೋಪಿ ವಿವಾಹ ವಿಚ್ಛೇದನಕ್ಕೆ ಸಹಿ ಮಾಡು, ನಿನಗೆ 2,00,000 ರೂಪಾಯಿ ಕೊಡುತ್ತೇನೆಂದು ಬೆದರಿಸುತ್ತಾನೆ. ನನ್ನ ನಾದಿನಿಯು ವರದಕ್ಷಿಣೆಗಾಗಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದಳು. ನನ್ನ ಮಗನನ್ನು ಅಪಹರಿಸುತ್ತೇವೆಂದು ಆರೋಪಿತರು ಹೆದರಿಸುತ್ತಿದ್ದರು. So further chief examination that articles were being got marked and that exhibit P6 and 7 that the marriage invitation, those are marked, and subsequently exhibit P8 also with regard to the seizure of gold articles was being marked. Cross examinations. Shall I proceed?
Yes.
ಮದುವೆ ಆಗುವುದಕ್ಕಿಂತ ಮೊದಲು 7ನೇ ಪುಟದಲ್ಲಿ ಕೆಳಗಡೆ ಮದುವೆ ಆಗುವುದಕ್ಕಿಂತ ಮೊದಲು ನಮಗೆ ಆರೋಪಿತರ ಪರಿಚಯ ಇರಲಿಲ್ಲ. or shall I take only relevant portion or shall I enter?
Read it and take.
Some
Read it in its entirety.
ಮದುವೆ ಆಗುವುದಕ್ಕಿಂತ ಮೊದಲು ನಮಗೆ ಆರೋಪಿತರ ಪರಿಚಯ ಇರಲಿಲ್ಲ, ಅವರಿಗೂ ನಮ್ಮ ಪರಿಚಯ ಇರಲಿಲ್ಲ. ಮದುವೆ ವೇಳೆ ಒಂದನೇ ಆರೋಪಿ ವಿಧಾನಸೌಧದಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು ಎಂದು ಗೊತ್ತಿತ್ತು. ನನ್ನ ತವರು ಮನೆಯ ಕುಟುಂಬದ ಬಗ್ಗೆ ಮದುವೆ ವೇಳೆಯಲ್ಲಿ ಆರೋಪಿತರಿಗೆ ವಿಷಯ ಗೊತ್ತಿತ್ತು. ನನ್ನ ತಂದೆ ಆರ್ಮಿ ಕಾಲೇಜಿನಲ್ಲಿ ಅಟೆಂಡರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಮದುವೆಗಿಂತ 1 ತಿಂಗಳ ಮೊದಲು ಮದುವೆ ಮಾತುಕತೆ ಆಗಿದ್ದು, ಆ ಮಾತುಕತೆಗೆ ನಾನು ಇದ್ದೆ ಎಂದು ದೂರಿನಲ್ಲಿ ಪ್ರತ್ಯೇಕ ಹೇಳಿಲ್ಲ. ನನ್ನ ತಂದೆ ತಾಯಿಗೆ ನಾನು ಒಬ್ಬಳೇ ಮಗಳು. 3 ಜನ ಗಂಡು ಮಕ್ಕಳು ಇದ್ದಾರೆ. ನಮ್ಮ 4 ಮಕ್ಕಳಿಗೆ 1 ವರ್ಷದ ಅಂತರ ಇದೆ. ನನ್ನ ಮದುವೆಯಾದಾಗ ನನಗೆ 27 ವರ್ಷ ಪ್ರಾಯವಾಗಿತ್ತು. ನನ್ನ 3 ಮದುವೆಯ ಮಾತುಕತೆ ನನ್ನ ದೊಡ್ಡಪ್ಪನ ಮನೆಯಲ್ಲಿ ಆಗಿದ್ದು, ನನ್ನ 3 ತಮ್ಮರು ಮದುವೆಯ ಮಾತುಕತೆಗೆ ಬಂದಿದ್ದರು. ಮದುವೆಯಾದ ಅಜಮಾಸು 3-4 ತಿಂಗಳವರೆಗೆ ಆರೋಪಿತರು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡರು. ಆರೋಪಿತರದ್ದು ಅವಿಭಕ್ತ ಕುಟುಂಬ. ನಾನು ಗರ್ಭಿಣಿ ಇದ್ದಾಗ ಆರೋಪಿತರೇ ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಹಾವನ್ನು ಬಿಟ್ಟು ಕಚ್ಚಿಸಿದ್ದರು. ಆಗ ನಾನು 2 ತಿಂಗಳ ಗರ್ಭಿಣಿ ಆಗಿದ್ದೆ. ನಂತರ ನನಗೆ ಗರ್ಭಪಾತ ಆಗಿತ್ತು. ಹಾವು ಕಚ್ಚಿದ ಎಷ್ಟು ತಿಂಗಳಲ್ಲಿ ನನಗೆ ಗರ್ಭಪಾತ ಆಗಿತ್ತು ಎಂದು ನೆನಪಿಲ್ಲ. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನನಗೆ ಗರ್ಭಪಾತವಾಗಿದ್ದು, ಅಲ್ಲಿಂದ ನನ್ನ ತವರು ಮನೆಗೆ ಹೋಗಿದ್ದು, ನಂತರ 2 ದಿನಗಳಲ್ಲಿ ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಬಂದಿದ್ದೆ. ನನಗೆ ಹಾವು ಕಚ್ಚಿಸಿದ ವಿಷಯವನ್ನು ನನ್ನ ತಂದೆ ತಾಯಿಗೆ ಹೇಳಿದ್ದೆ. ಇಂದಲ್ಲ ನಾಳೆ ಆರೋಪಿತರು ಸರಿ ಹೋಗುತ್ತಾರೆ ಎಂದು ಆ ಬಗ್ಗೆ ಆರೋಪಿತರ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟಿರಲಿಲ್ಲ. ಆರೋಪಿತರು ನನಗೆ ಹಾವು ಕಚ್ಚಿಸಿದ ವಿಷಯವನ್ನು ದೂರಿನಲ್ಲಿ ಹೇಳಿ ಬರೆಸಿಲ್ಲ. ಮೊದಲ ಗರ್ಭಪಾತವಾದ ನಂತರ ನಾನು ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ 4 ತಿಂಗಳವರೆಗೆ ನಾನು ವಾಸವಾಗಿದ್ದೆ. ಕೆಲವೊಮ್ಮೆ ನಾನು ಆ ಮನೆಯಲ್ಲಿ, ಕೆಲವೊಮ್ಮೆ ನನ್ನ ತವರು ಮನೆಯಲ್ಲಿ ಇರುತ್ತಿದ್ದೆ. ನಾನು ತವರು ಮನೆಯಲ್ಲಿ ಇದ್ದಾಗ ನನ್ನ ಗಂಡ ತವರು ಮನೆಯಲ್ಲಿ ಬಂದು ಇರುತ್ತಿದ್ದರು. ಮದುವೆ ಮಾತುಕತೆಯಲ್ಲಿ ಆರೋಪಿತರು ಅರ್ಧ ಕೆಜಿ ಚಿನ್ನ ಕೊಡಲು ಕೇಳಿದ್ದರು. ನಾವು 1/4 ಕೆಜಿ ಚಿನ್ನ ಕೊಡಲು ಒಪ್ಪಿದೆವು ಹಾಗೂ 1 ಲಕ್ಷ ವರದಕ್ಷಿಣೆ ಕೇಳಿದ್ದರು. ಆದರೆ 80,000 ವರದಕ್ಷಿಣೆ 80,000 ಕೊಟ್ಟಿದ್ದೆವು. ಮದುವೆಯ ಮಾತುಕತೆಯಲ್ಲಿ ನಾನಾಗಲಿ ನನ್ನ ತಮ್ಮಂದಿರಾಗಲಿ ಭಾಗವಹಿಸಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಾನು ಗರ್ಭಿಣಿ ಇದ್ದಾಗ ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ ಶ್ರೀಮಂತ ಕಾರ್ಯ ಮಾಡಿದ್ದು, ಅದನ್ನು ಚೆನ್ನಾಗಿ ಮಾಡಿದ್ದರು. ಆ ವೇಳೆಯಲ್ಲಿಯೂ ಸಹ ನನಗೆ ಆರೋಪಿತರು ವರದಕ್ಷಿಣೆಗಾಗಿ ಕಿರುಕುಳ ಕೊಟ್ಟಿದ್ದರು. ನನ್ನ ಅತ್ತೆಗೆ ಆರೋಗ್ಯ ಸರಿಯಾಗಿ ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ವಾಸವಾಗಿದ್ದರಿಂದ ಆ ಮನೆಯಲ್ಲಿ ನನಗೆ ವಾಸಿಸಲು ಇಷ್ಟ ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆದ್ದರಿಂದ ಪ್ರತ್ಯೇಕವಾಗಿ ಮನೆ ಮಾಡುವಂತೆ ನಾನು ಗಂಡನಿಗೆ ಒತ್ತಾಯ ಮಾಡುತ್ತಿದ್ದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ತವರು ಮನೆಯಲ್ಲಿ ನನಗೆ ಹೆರಿಗೆ ಆದ ನಂತರ ಆರೋಪಿತರು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಲು ಬಂದಿರಲಿಲ್ಲ. ಆದ್ದರಿಂದ ನಾನು ಆರೋಪಿತರ ಮನೆಗೆ ಹೋಗಿಲ್ಲ. ನನ್ನ ತವರು ಮನೆಯವರು ನನಗೆ ಮದುವೆಯಲ್ಲಿ ಹಾಕಿದ್ದ ಒಡವೆಗಳನ್ನು ನಾನು ಗಂಡನ ಮನೆಗೆ ಹಾಕಿಕೊಂಡು ಹೋಗಿದ್ದೆ. ಅದು ಇಂದು ನನಗೆ ತೋರಿಸುತ್ತಿರುವ ಫೋಟೋದಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ. ಆದರೆ ಆ ಒಡವೆಗಳನ್ನು ಆರೋಪಿತರು ನನ್ನಿಂದ ಶ್ರೀಮಂತ ಆದ ವೇಳೆ ಕಿತ್ತುಕೊಂಡಿದ್ದರು. ಸದರಿ ಒಡವೆಯನ್ನು ನಿಶಾನೆ ಡಿ ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಾಕ್ಷಿಗೆ ಇನ್ನೊಂದು ಫೋಟೋ ತೋರಿಸಲಾಗಿ ಅದರಲ್ಲಿ ತನ್ನ ಮಗುವಿನ ಫೋಟೋ ಇದೆ ಎಂದು ನುಡಿದಿದ್ದಾರೆ. ನಿಶಾನೆ ಡಿ 2ರ ಫೋಟೋದಲ್ಲಿ ನನ್ನ ಮಗುವಿನ ಕೊರಳಿನಲ್ಲಿ ಬಂಗಾರದ ಸರಗಳು ಕಂಡು ಬರುತ್ತಿದ್ದು, ಅದು ಮದುವೆಯ ವೇಳೆ ನನ್ನ ತವರಿನವರು ಹಾಕಿದ್ದ ಸರಗಳು ಅಲ್ಲ. ನನ್ನ ಮದುವೆಯ ವೇಳೆಯಲ್ಲಿ 1/4 ಕೆಜಿ ಬಂಗಾರ ಹಾಗೂ 80,000 ಕೊಡುವಷ್ಟು ಶಕ್ತಿ ನನ್ನ ತವರಿಗೆ ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನನ್ನ ತಂದೆಗೆ ಅಷ್ಟು ವರದಕ್ಷಿಣೆ ಕೊಡಲು ಸಾಧ್ಯ ಇಲ್ಲ ಎಂದು ಆರೋಪಿತರಿಗೆ ಗೊತ್ತಿದ್ದರಿಂದ ನನ್ನ ತಂದೆಯ ಬಳಿ ಆರೋಪಿ ಅಷ್ಟು ಹಣ ಕೇಳಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನನ್ನ ಮದುವೆಯ ವೇಳೆ ನನ್ನ 3 ತಮ್ಮಂದಿರು ಕಾಲೇಜಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ನೆಕ್ಸ್ಟ್ ಇಂಪಾರ್ಟೆನ್ಸ್, ನಾನು ಕೆಂಪೇಗೌಡ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ಕೊಟ್ಟ ನಂತರದಲ್ಲಿ ನನ್ನ ಗಂಡ ಮನೆಗೆ ಬರುವಂತೆ ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ. ನನ್ನ ಗಂಡ ಮನೆಗೆ ಬರುವಂತೆ ನನಗೆ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ. ನಾನು ಕೆಂಪೇಗೌಡ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಾಗ ಪೊಲೀಸರು ನನ್ನ ಗಂಡನನ್ನು ಹಾಗೂ ಆರೋಪಿತರನ್ನು ಠಾಣೆಗೆ ಕರೆಸಿ ವಿಚಾರಿಸಿದಾಗ ಅವಳನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೇನೆ ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದರು. ಆರೋಪಿತರು ವರದಕ್ಷಿಣೆಗಾಗಿ ಕಿರುಕುಳ ಕೊಡುತ್ತಾರೆ ಹಾಗೂ ತವರು ಮನೆಯಿಂದ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿಲ್ಲ ಎಂದು ಕೆಂಪೇಗೌಡ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಿದ್ದೆ. ಪೊಲೀಸರು ಆ ಕೇಸನ್ನು ದಾಖಲಿಸಿಕೊಂಡಿರಲಿಲ್ಲ. ಬದಲಿಗೆ ಆರೋಪಿತರನ್ನು ಕರೆಸಿ ರಾಜಿ ಮಾಡಿಸಿದ್ದರು. ಆದರೆ ಆರೋಪಿತರು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಲು ಬಂದಿರಲಿಲ್ಲ. ಕೆಂಪೇಗೌಡ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನನ್ನ ಮಗನನ್ನು ಅಪಹರಿಸುವ ಪ್ರಯತ್ನದಲ್ಲಿ ಇದ್ದರು ಎಂದು ದೂರು ಕೊಟ್ಟಿದ್ದೆ ಹಾಗೂ ಆ ದೂರಿನಲ್ಲಿ ಆರೋಪಿತರು ವರದಕ್ಷಿಣೆಗಾಗಿ ಕಿರುಕುಳ ಕೊಟ್ಟ ವಿಷಯವನ್ನು ಹೇಳಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸಿದ್ದೂರಪ್ಪ ಎನ್ನುವರಿಂದ ಸಾಲ ಮಾಡಿ ನನ್ನ ತಾಯಿಯು 20,000 ನನ್ನ ಬಳಿ ಕೊಟ್ಟು ಕಳುಹಿಸಿದ್ದರು. ಆ ಹಣವನ್ನು ನಾನು ಆರೋಪಿತರಿಗೆ ಕೊಟ್ಟಿದ್ದೆ. ನನ್ನ ಅತ್ತೆ ಜಯಮ್ಮ ಎನ್ನುವರು ನನ್ನ ವಿರುದ್ಧ ಯಾವುದೇ ದೂರು ಕೊಟ್ಟಿಲ್ಲ. ನನ್ನ ಗಂಡನ ಮನೆಯವರು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋದಲ್ಲಿ ನಾನು ಹೋಗಲು ಸಿದ್ಧಳಿದ್ದೇನೆ. ತುಂಬಿರುವ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಾನು MC ನಂಬರ್ 481/2003 ದಾಖಲಿಸಿದ್ದು, ಆರೋಪಿತರು ಕೇಸನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಳ್ಳದಿದ್ದರೆ ನಿನ್ನನ್ನು ನಿನ್ನ ಮಗವನ್ನು ಕೊಲೆ ಮಾಡುತ್ತೇನೆ ಎಂದು ಧಮ್ಮಕಿ ಕೊಟ್ಟಿದ್ದರಿಂದ ಆ ಕೇಸನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ. ಮದುವೆಗಿಂತ 15 ದಿನ ಮೊದಲು ನನ್ನ ತಂದೆ ತಾಯಿ ಆರೋಪಿತರಿಗೆ 80,000 ವರದಕ್ಷಿಣೆ ಕೊಟ್ಟಿದ್ದರು. ನನ್ನ ಅತ್ತೆ ಆರ್ಥಿಕವಾಗಿ ಸಬಲಲಾಗಿದ್ದು ನನಗೆ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ವಾಸಿಸಲು ಇಷ್ಟ ಇಲ್ಲ. ನನ್ನ ತವರು ಮನೆಯ ಪಕ್ಕದಲ್ಲಿರುವ ಖಾಲಿ ಜಾಗೆಯನ್ನು ನಮಗೆ ಕೊಡಿಸಿ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿಸಿಕೊಂಡು ನಾನು ಹಾಗೂ ನನ್ನ ಗಂಡ ವಾಸಿಸುತ್ತೇವೆ ಎಂದು ಹೇಳಿದ್ದೆ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ನಾನು ಹೇಳಿದಂತೆ ರು 8 ಲಕ್ಷ ಹೊಡೆದೇ ಇದ್ದುದರಿಂದ 3 ವರ್ಷ ಕಾದು ಆರೋಪಿತರ ವಿರುದ್ಧ ಸುಳ್ಳು ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ನನ್ನ ಮಾತನ್ನು ಕೇಳಿದ್ದರಿಂದ ಆರೋಪಿತರೇ ನನಗೆ ಬೇರೆಯವರ ಜೊತೆ ಮಲಗಿ ಹಣ ತರುವಂತೆ ಹೇಳಿದ್ದರು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ ಪೊಲೀಸರು ಮಹಜರ್ ಮಾಡಿದ ವೇಳೆ ನಾನು ಆ ಮಹಜರ್ಗೆ ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿಯೇ ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಪೊಲೀಸರು ಆರೋಪಿತರ ಮನೆಯಿಂದ ಜಪ್ತು ಮಾಡಿಕೊಂಡ ಒಡವೆಗಳನ್ನು ಪುನಃ ಆರೋಪಿತರಿಗೆ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದರು. ಆ ಒಡವೆಗಳನ್ನು ಪೊಲೀಸರು ಜಪ್ತು ಮಾಡಿಕೊಂಡು ಅವುಗಳನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುತ್ತೇವೆ ಎಂದು ಪೊಲೀಸರು ಹೇಳಿದ್ದರು. ಮುಂದೆ ಏನು ಮಾಡಿದ್ದರು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಜಪ್ತು ಮಾಡಿಕೊಂಡ ಒಡವೆಗಳನ್ನು ಪೊಲೀಸರು ನನಗೂ ಕೊಟ್ಟಿಲ್ಲ ಹಾಗೂ ನ್ಯಾಯಾಲಯಕ್ಕೂ ಹಾಜರುಪಡಿಸಿಲ್ಲ ಹಾಗೂ ಮಹಜರ್ನ ವೇಳೆ ನಾನು ಸ್ಥಳದಲ್ಲಿ ಇರಲಿಲ್ಲ ಹಾಗೂ ಆ ಮಹಜರ್ಗೆ ನಾನು ಸ್ಥಳದಲ್ಲಿ ಸಹಿ ಮಾಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. This is the evidence of PW1, which entirely corroborate with the averments made in Exhibit P1 complaint. And during the course of the cross-examination also, nothing was elicited to discuss about giving the gold ornaments, handing over 80,000, subsequently giving 20,000 addition, and the further demand made by the respondent family in respect of the 1 lakh demand. So nothing contrary was elicited from the mouth of PW1 to discard the same. Now PW2 is mother of PW1 today. The Lordship permits I will.
Yes.
Wife of Kempayas. ಚಾಸ 2 ನನ್ನ ಗಂಡ, ಚಾಸ 1 ನನ್ನ ಮಗಳು. ದಿನಾಂಕ 23/3/98 ಚಾಸ 1ನೇಯವಳನ್ನು 1ನೇ ಆರೋಪಿಗೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಿದ್ದೆವು. ಮದುವೆಗಿಂತ ಮೊದಲು ಮದುವೆ ಮಾತುಕತೆ ನನ್ನ ಗಂಡನ ಅಣ್ಣ ಕುಂಟಯ್ಯ ಎನ್ನುವರ ಬ್ಯಾಂಕ್ ಕಾಲೋನಿಯಲ್ಲಿರುವ ಮನೆಯಲ್ಲಿ ಆಗಿತ್ತು. ಆ ವೇಳೆಯಲ್ಲಿ ನಮ್ಮ ಕಡೆಯಿಂದ ಚಾಸ 5, 6 ಮತ್ತು 8 ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಮತ್ತು ಮಕ್ಕಳು ಇದ್ದೆವು. ಆರೋಪಿತರ ಕಡೆಯಿಂದ ಆರೋಪಿತರು ಹಾಗೂ ಅವರ ಕಡೆಯ ಜನರು ಬಂದಿದ್ದರು. ರು 80,000 ವರದಕ್ಷಿಣೆ ಎಂದು ಬಂಗಾರದ 1 ಕೊರಳು ಚೈನು, ಬಂಗಾರದ ಬ್ರಾಸ್ಲೆಟ್, ಬಂಗಾರದ 2 ಉಂಗುರ ಹಾಗೂ 1 ವಾಚ್ ಹುಡುಗನಿಗೆ ಕೊಡಬೇಕೆಂದು ಹಾಗೂ ಹುಡುಗಿಗೆ ಬಂಗಾರದ 1 ಲಾಂಗ್ ಚೈನ್, 1 ನೆಕ್ಲೆಸ್, 6 ಬಳೆ, ಹ್ಯಾಂಗಿಂಗ್ಸ್, ಮಾಟಿ, 3 ಬಂಗಾರದ ಉಂಗುರ, ಬಂಗಾರದ ಗುಂಡು ಹಾಗೂ ಡ್ರಾಪ್ಸ್ ಕೊಟ್ಟು ಮದುವೆಯ ಖರ್ಚನ್ನು ಹೆಣ್ಣಿನ ಕಡೆಯವರೇ ಮಾಡಬೇಕೆಂದು ಆರೋಪಿತರು ಹೇಳಿದ್ದರು. ಆ ಪ್ರಕಾರ ಗಿರಿನಗರದಲ್ಲಿರುವ ಸುಂದರ್ ಮಹಲ್ ಛತ್ರದಲ್ಲಿ ಮದುವೆಯನ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದೆವು. ಮಾತುಕತೆಯ ಪ್ರಕಾರ ಮದುವೆಗಿಂತ 1 ವಾರ ಮೊದಲು ರು 80,000 ನಗದನ್ನು ನನ್ನ ಗಂಡ ಹಾಗೂ ನಾನು ಸೇರಿ ಆರೋಪಿತರಿಗೆ ಕೊಟ್ಟಿದ್ದೆವು. ಮದುವೆ ವೇಳೆ ಬಂಗಾರದ ಒಡವೆ ಹಾಗೂ ವಾಚ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದೆವು. This is also corroborate with ವರ್ಷನ್ ಆಫ್ PW1s.
Yes.
ಮದುವೆಯಾದ ನಂತರ ಫಿರ್ಯಾದುದಾರಳು ಚಂದ್ರ ಬಡಾವಣೆಯಲ್ಲಿರುವ ಗಂಡನ ಮನೆಗೆ ಹೋಗಿದ್ದಳು. ಆ ಮನೆಯಲ್ಲಿ ಆರೋಪಿತರೆಲ್ಲ ಒಟ್ಟಿಗೆ ವಾಸವಾಗಿದ್ದರು. ಅಜಮಾಸ ಕಟ್ಟಾಗಿದೆ. ತಿಂಗಳವರೆಗೆ ಆರೋಪಿತರು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡಿದ್ದರು. ಆ ನಂತರ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತರಬೇಕೆಂದು ಫಿರ್ಯಾದಿದಾರರ ಜೊತೆ ಜಗಳ ತೆಗೆದು ತವರು ಮನೆಗೆ ಕಳುಹಿಸುತ್ತಿದ್ದರು. ಆ ನಂತರದಲ್ಲಿ ಆರೋಪಿತಿಗೆ ನಾನು ಹಾಗೂ ನನ್ನ ಗಂಡ ಸೇರಿ 20,000 ಕೊಟ್ಟಿದ್ದೆವು. ಓನ್ಲಿ ವಿತ್ ಕಾಂಟ್ರಡಿಕ್ಷನ್ ಈಸ್ ಇನ್ PW1 ಶಿ ಸೇಸ್ ತಂದೆ ತಾಯಿ ನನಗೆ ಕೊಟ್ಟರು, ನಾನು ತಗೊಂಡೋಗಿ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ PW2 ಮದರ್ ಸೇಸ್ ನಾವೇ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿತ್ ರೆಗಾರ್ಡ್ ಟು 20,000 being handed over, there is a corroboration. ಆ ಅವಧಿಯಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಗರ್ಭಿಣಿಯಾಗಿದ್ದು 7 ತಿಂಗಳ ನಂತರದಲ್ಲಿ ತವರು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದೆವು. ಕೆಂಪೇಗೌಡ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ಗಂಡು ಮಗುವಿಗೆ ಜನ್ಮ ಕೊಟ್ಟಿದ್ದಳು. ಆ ಮಗುವಿಗೆ ಈಗ 7 ವರ್ಷ ಪ್ರಾಯವಾಗಿದ್ದು ಅವನ ಹೆಸರು ಚಂದನ್ ಎಂದಿದೆ. ಮಗುವಿಗೆ 1 ವರ್ಷವಾದಾಗ ಭಜನೆ ಮನೆ ಎನ್ನುವ ಛತ್ರದಲ್ಲಿ ನಾಮಕರಣ ಮಾಡಿದ್ದೆವು. ಆ ನಾಮಕರಣಕ್ಕೆ ಆರೋಪಿತರಿಗೆ ಕರೆದರೂ ಅವರು ಬಂದಿರಲಿಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರು ಹೆರಿಗೆಗಾಗಿ ತವರು ಮನೆಗೆ ಬಂದ ನಂತರದಲ್ಲಿ ಆರೋಪಿತರು ಅವಳನ್ನು ನೋಡಲು ನಮ್ಮ ಮನೆಗೆ ಬಂದಿರಲಿಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಗಂಡು ಮಗ ಜನಿಸಿದ ವಿಷಯ ಆರೋಪಿತರಿಗೆ ತಿಳಿಸಿದರೂ ಕೂಡ ಅವರು ಮಗುವನ್ನು ನೋಡಲು ಬಂದಿರಲಿಲ್ಲ. 1 ವರ್ಷ ಪ್ರಾಯವಾದ ನಂತರದಲ್ಲಿ 1-2 ಬಾರಿ ಹಿರಿಯ ಸಮ್ಮುಖದಲ್ಲಿ ನ್ಯಾಯ ಪಂಚಾಯಿತಿ ಮಾಡಿ ಫಿರ್ಯಾದಿದಾರರನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದರೂ ಕೂಡ ಆರೋಪಿತರು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರಲಿಲ್ಲ. ಆ ನ್ಯಾಯ ಪಂಚಾಯಿತಿಗೆ ಸಿದ್ದಪ್ಪ, ಲಕ್ಷ್ಮಮ್ಮ ಹಾಗೂ ನನ್ನ ಗಂಡ ಹೋಗಿದ್ದರು. ಆ ನಂತರದಲ್ಲಿ ಆರೋಪಿತರು ಒಂದು ದಿನ ನಮ್ಮ ಮನೆ ಬಳಿ ಬಂದು 1 ಲಕ್ಷ ಹಾಗೂ 1 ಸೈಟ್ ಕೊಡುವವರೆಗೆ ತಾವು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಹಾಗೂ ಅವಳ ಮಗುವನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವುದಿಲ್ಲ ಎಂದು ಜಗಳ ಮಾಡಿದರು. ಆದ್ದರಿಂದ ನಾವು ಕೆಂಪೇಗೌಡ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಆರೋಪಿತರ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟಿದ್ದೆವು. ಅದೇ ರೀತಿ ಮಹಿಳಾ ಸಮಾಜದಲ್ಲೂ ಸಹ ದೂರು ಕೊಟ್ಟಿದ್ದೆವು. ಮಹಿಳಾ ಸಮಾಜದವರು ಹಾಗೂ ಪೊಲೀಸರು ಆರೋಪಿತರನ್ನು ಕರೆಯಿಸಿ ಫಿರ್ಯಾದಿದಾರರನ್ನು ಹಾಗೂ ಅವಳ ಮಗುವನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವಂತೆ ತಿಳಿಸಿದ್ದರು. ಆರೋಪಿತರು ಫಿರ್ಯಾದಿದಾರರನ್ನು ಹಾಗೂ ಅವಳನ್ನು ತಮ್ಮ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರಲಿಲ್ಲ. 3 ವರ್ಷದ ನಂತರದಲ್ಲಿ ನನ್ನ ಗಂಡ ಹಾಗೂ ಮಗ ಸೇರಿ ಫಿರ್ಯಾದಿದಾರರನ್ನು ಹಾಗೂ ಆಕೆಯ ಮಗುವನ್ನು ಆರೋಪಿತರ ಮನೆಗೆ ಬಿಟ್ಟು ಬರಲು ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದರು. ಆದರೆ ಅವರನ್ನು ಮನೆಯ ಒಳಗಡೆ ಸೇರಿಸದೆ ಜಗಳ ಮಾಡಿ ಕಳಿಸಿದ್ದರು. ದಿಸ್ ಇಸ್ ಅಗೈನ್ ದ ಲಾಸ್ಟ್ ಲೈನ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್. ಕೊರಾಬರೇಷನ್ ಇಸ್ ದೇರ್. ಆ ಬಗ್ಗೆ ಫಿರ್ಯಾದಿದಾರರು ದೂರು ಕೊಟ್ಟಿದ್ದಳು. ಘಟನೆಗೆ ಸಂಬಂಧಿಸಿ ಪೊಲೀಸರು ನನ್ನನ್ನು ವಿಚಾರಣೆ ಮಾಡಿದ್ದರು. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಮುದ್ದೆಮಾರು 1ರಿಂದ 3 ಪುಸ್ತಕವನ್ನು ನಾವು 1ನೇ ಆರೋಪಿಗೆ ಕೊಟ್ಟಿದ್ದೆವು. ಮುದ್ದೆಮಾರು 1ರಿಂದ 3 ಪೊಲೀಸರ ಸ್ವಾಧೀನಕ್ಕೆ ಹಿಂತಿರುಗಿಸಲಾಗಿದೆ. ಮದುವೆಯ ವೇಳೆ ಆರೋಪಿತರು 1/2 kg ತೂಕದ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಫಿರ್ಯಾದಿಗೆ ಕೊಡಬೇಕೆಂದು ಹೇಳಿದ್ದರು. ಆದರೆ ಮಾತುಕತೆ ವೇಳೆ 1/4 kg ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಹಾಕುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದ್ದೆವು. ಆ ಪ್ರಕಾರ ಮದುವೆ ಸಮಯದಲ್ಲಿ 1/4 kg ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೆವು. ಈಗ ಆ ಎಲ್ಲಾ ಬಂಗಾರದ ಒಡವೆಗಳು ಆರೋಪಿತರ ಬಳಿ ಇದೆ. ಫಿರ್ಯಾದಿದಾರರು ಹಾಗೂ ಅವಳ ಮಗ ನಮ್ಮ ಮನೆಯಲ್ಲಿಯೇ ವಾಸವಾಗಿದ್ದಾರೆ. ಆರೋಪಿತರನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸೇನೆ ಅವರಿಂದು ಆರೋಪಿ ಕಟಕಟೆಯಲ್ಲಿ ನಿಂತಿದ್ದಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 47. ನನ್ನ ಮಗಳ ಮದುವೆಯ ವೇಳೆ ನನ್ನ ಗಂಡ ಕಾಲೇಜಿನಲ್ಲಿ ಅಟೆಂಡರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ 4 ಜನ ಮಕ್ಕಳ ಪೈಕಿ ಫಿರ್ಯಾದಿದಾರಳೆ ದೊಡ್ಡ ಮಗಳು. ಮದುವೆಯ ವೇಳೆ ಫಿರ್ಯಾದಿದಾರಳಿಗೆ ಅಜಮಾಸು 28 ವರ್ಷ ಪ್ರಾಯವಾಗಿತ್ತು. ನನ್ನ ಉಳಿದ ಗಂಡು ಮಕ್ಕಳಿಗೆ ಆ ವೇಳೆಯಲ್ಲಿ ಅಜಮಾಸು 20ರಿಂದ 24 ವರ್ಷ ಪ್ರಾಯವಾಗಿತ್ತು. ಆ ವೇಳೆಯಲ್ಲಿ ನನ್ನ 3 ಗಂಡು ಮಕ್ಕಳು ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದರು. ನನ್ನ ಗಂಡು ಮಕ್ಕಳ ಪೈಕಿ ಒಬ್ಬ RV ಕಾಲೇಜಿನಲ್ಲಿ ಅಟೆಂಡರ್, ಇನ್ನೊಬ್ಬ ಕಾರ್ ಚಾಲಕನಾಗಿದ್ದು ಇನ್ನೊಬ್ಬ ಮಗ ದೇವೇಗೌಡ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಹತ್ತಿರ ಇರುವ ಕಚೇರಿಗೆ ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದನು. ನನ್ನ ಗಂಡ ಕಾಲೇಜಿನಲ್ಲಿ ಅಟೆಂಡರ್ ಆಗಿ ಇರುವ ವಿಷಯ ಫಿರ್ಯಾದಿದಾರಳ ಗಂಡನ ಮನೆಯವರಿಗೆ ಗೊತ್ತಿತ್ತು. ಮದುವೆಯ ಮಾತುಕತೆಗೆ ಹಿರಿಯರು ಹೋಗುತ್ತಾರೆ ಎನ್ನುವುದು ನಿಜ. ಮದುವೆಯ ಮಾತುಕತೆಗೆ ಸಿದ್ದರಾಜು, ಕುಂಟಯ್ಯ, ಜಯಮ್ಮ, ಪೆಟ್ಟಯ್ಯ, ಚಿಕ್ಕಮ್ಮ ಹಾಗೂ ನಾನು, ನನ್ನ ಗಂಡ, ಮಕ್ಕಳು, ನನ್ನ ಮಗಳು ಹಾಗೂ ಇನ್ನೂ ಬೇಕಾದವರು ಇದ್ದೆವು. ಆ ಮಾತುಕತೆ ನನ್ನ ಭಾವ ಕುಂಟಯ್ಯನವರ ಮನೆಯಲ್ಲಿ ಆಗಿತ್ತು. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿ kindly this point may be noted to me. She stated about the ಮಾತುಕತೆಗೆ ನನ್ನ ಮಗಳು ಹೋಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. During the course of giving the reasoning by the first appellate court, that point was suspected by the first appellate. ಆ ಮಾತುಕತೆ ನನ್ನ ಭಾವ ಕುಂಟಯ್ಯನವರ ಮನೆಯಲ್ಲಿ ಆಗಿತ್ತು. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿ ದೂರು ಕೊಟ್ಟ ಅಜಮಾಸು 1 ವಾರದ ಮೇಲೆ ಪೊಲೀಸರು ನನ್ನ ಹೇಳಿಕೆ ಪಡೆದುಕೊಂಡಿದ್ದರು. ಸದರಿ ಮದುವೆಯ ಮಾತುಕತೆಗೆ ನಾನು, ನನ್ನ ಗಂಡ ಸಿದ್ದಪ್ಪ ಹಾಗೂ ನರಸಿಂಹಯ್ಯ ಮಾತ್ರ ಹೋಗಿದ್ದೆವು ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಪೊಲೀಸರು ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಓದಿ ಹೇಳಿದರು. ಮದುವೆಯ ಮಾತುಕತೆಯಲ್ಲಿ ರು 1 ಲಕ್ಷ ನಗದು, 2 ಬಂಗಾರದ ಉಂಗುರ, 1 ಬ್ರಾಸ್ಲೆಟ್ ಹಾಗೂ 1 ಬಂಗಾರದ ಚೈನ್ ಹಾಗೂ ವಾಚ್ ಕೇಳಿದ್ದರು. ಆದರೆ ನನ್ನ ಗಂಡ ಆರೋಪಿತರಿಗೆ ರು 80,000 ನಗದು, 2 ಬಂಗಾರದ ಉಂಗುರ, ಬ್ರಾಸ್ಲೆಟ್, ಬಂಗಾರದ ಚೈನ್ ಮತ್ತು ವಾಚ್ ಕೊಡಲು ಒಪ್ಪಿದ್ದರು. ಅವೆಲ್ಲವುಗಳನ್ನು ನನ್ನ ಗಂಡ ಆರೋಪಿತರಿಗೆ ಕೊಟ್ಟಿದ್ದನು. ಫಿರ್ಯಾದುದಾರರಿಗೆ ಆರೋಪಿತರು ಮನೆಯ ಒಳಗಡೆ ಹಾವು ಕಚ್ಚಿತ್ತು. ಫಿರ್ಯಾದುದಾರರಿಗೆ ಆರೋಪಿತರ ಮನೆಯ ಒಳಗಡೆ ಹಾವು ಕಚ್ಚಿತ್ತು. ಆ ವಿಷಯವನ್ನು ಆರೋಪಿತರೇ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದಾಗ ನಾವು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ನೋಡಿದ್ದೆವು. ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ ಆರೋಪಿತರೆಲ್ಲರೂ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ವಾಸವಾಗಿದ್ದರು ಅನ್ನುವುದು ನಿಜ. ಫಿರ್ಯಾದುದಾರರ ಶ್ರೀಮಂತ ಕಾರ್ಯಕ್ರಮ ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ ಆಗಿತ್ತು. ಸದ್ರಿ ಶ್ರೀಮಂತದ ವೇಳೆಯಲ್ಲಿಯೂ ಆಗಾಗ ಸಣ್ಣ ಪುಟ್ಟ ಗಲಾಟೆ ನಡೆಯುತ್ತಿತ್ತು. ಫಿರ್ಯಾದುದಾರರು ತವರು ಮನೆಯಲ್ಲಿ ಹೆರಿಗೆ ಆದ ನಂತರ ಆರೋಪಿತರ ಒಟ್ಟು ಕುಟುಂಬಕ್ಕೆ ಹೋಗಲು ಇಷ್ಟ ಇಲ್ಲದೆ ಬೇರೆ ಮನೆ ಮಾಡಲು ಹೇಳಿದ್ದಳು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಫಿರ್ಯಾದುದಾರರು ಆರೋಪಿತರ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದ ವೇಳೆಯಲ್ಲಿ ಆರೋಪಿತರು ತವರು ಮನೆಯಿಂದ ರು 1 ಲಕ್ಷ ಹಾಗೂ 1 ಸೈಟ್ ತರುವಂತೆ ಒತ್ತಾಯ ಮಾಡಿದ್ದು. ಆ ವೇಳೆಯಲ್ಲಿ ನನ್ನ ಗಂಡ ಸಿದ್ದಪ್ಪ ಎನ್ನುವರ ಕೈಯಲ್ಲಿ ಆರೋಪಿತರಿಗೆ 20,000 ಕೊಟ್ಟಿದ್ದರು. This is again corroboration. During the course of cross-examination also, nothing contrary was elicited to discard the payment of 20,000. ಆ ವಿಷಯವನ್ನು ನಾನು ಪೊಲೀಸರ ಹೇಳಿಕೆಯಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ. ಅದನ್ನು ಪೊಲೀಸರು ಬರೆದುಕೊಂಡಿಲ್ಲ. ಮದುವೆಯ ಮಾತುಕತೆಗೆ ನಾನಾಗಲಿ ನನ್ನ ಮಕ್ಕಳಾಗಲಿ ಹೋಗಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಹಣ ಹಾಗೂ ಒಡವೆಯನ್ನು ಕೊಡುವಂತೆ ಒತ್ತಾಯ ಮಾಡಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಅಷ್ಟು ಹಣ ಹಾಗೂ ಒಡವೆ ಕೊಡಲು ಆರ್ಥಿಕವಾಗಿ ನಮಗೆ ತಾಕತ್ತು ಇರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಗಲಾಟೆ ದೊಡ್ಡದಾದ ನಂತರದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರು ದೂರು ಕೊಟ್ಟಿದ್ದಾಳೆ. ಪೊಲೀಸರು ಒಂದು ಕಾಗದ ಪತ್ರಕ್ಕೆ ನನ್ನ ಸಹಿ ಪಡೆದಿದ್ದರು. ಆರೋಪಿತರು ಫಿರ್ಯಾದುದಾರರನ್ನು ಹಾಗೂ ಮಗುವನ್ನು ತಮ್ಮ ಮನೆಗೆ ಕರೆಯಲು ಬಂದರೂ ಕೂಡ ನಾವು ಅವರನ್ನು ಆರೋಪಿತರ ಮನೆಗೆ ಕಳುಹಿಸಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿತರು ಮದುವೆಯಾದ ನಂತರದಲ್ಲಿಯೂ ರು 1 ಲಕ್ಷ ನಗದು ಹಾಗೂ ಸೈಟ್ ಕೊಡಿಸುವಂತೆ ಫಿರ್ಯಾದುದಾರರಿಗೆ ಒತ್ತಾಯ ಮಾಡಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. So in the cross-examining evidence of PW2 also, the entire evidence of PW1 was corroborated with the PW2. And one point your lordship has to appreciate, during the course of cross-examination of PW1 and 2, the defense has not put any suggestion saying that those gold ornaments was not being given as customary ಅನ್ನೋದು ಎಲ್ಲೂ suggestion ಮಾಡಿಲ್ಲ. But that is the reason assigned by the first appellate court. That I will again highlight. But during the course of cross-examination, that point was not put. Because even section 3 of dowry prohibition, proviso clause also prescribes that condition. That suggestion was also not forthcoming during the course of cross-examination of PW1 and 2. PW3 is, if your lordship permits, I will go ahead with the PW3.
Yes.
PW3 is only Siddhappa, son of Siddhappa. He was said to be participated in the marriage talk in the house of Kuntaya, who is brother of PW Cruz. In the chief evidence, it was a replica about the demands being made by the complainant accused family and the handing over of 80,000 in gold ornaments. If your lordship permits, I will go with the cross examination.
Yes.
Cross examinations. ನನ್ನ ಮನೆ 4ನೇ ಕ್ರಾಸ್ ನಲ್ಲಿ ಇದೆ. ಫಿರ್ಯಾದುದಾರರ ತವರ ಮನೆ 8ನೇ ಕ್ರಾಸ್ ನಲ್ಲಿ ಇದೆ. ಕಳೆದ 40 ವರ್ಷದಿಂದ ನನಗೆ ಫಿರ್ಯಾದುದಾರರ ತಂದೆಯವರ ಪರಿಚಯ ಇದೆ. ಮದುವೆಯ ಮಾತುಕತೆಗೆ ನಾನು ಲಕ್ಷ್ಮಮ್ಮ, ಕೆಂಪಯ್ಯ, ಕುಂಟೇಗೌಡ, ನರಸಿಂಹಯ್ಯ ಹೋಗಿದ್ದೆವು. ಆ ವೇಳೆಯಲ್ಲಿ ಹೆಣ್ಣಿನ ಕಡೆಯಿಂದ ಅಜಮಾಸು 20 ಜನರು ಇದ್ದರು. ಫಿರ್ಯಾದುದಾರರು ಆರೋಪಿತರ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟ ವಿಷಯವನ್ನು ಕೆಂಪಯ್ಯನವರು ನನಗೆ ಹೇಳಿದ್ದರು. ದೂರು ಕೊಟ್ಟ ಅಜಮಾಸು 1 ವಾರದಲ್ಲಿಯೇ ಪೊಲೀಸರು ನನ್ನ ಮನೆ ಹತ್ತಿರ ಬಂದು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆ ಪಡೆದಿದ್ದರು. ಆ ಹೇಳಿಕೆಯನ್ನು ಓದಿ ಹೇಳಿದ್ದರು. ಆ ಮಾತುಕತೆಯಲ್ಲಿ ಆರೋಪಿತರು ರು 1 ಲಕ್ಷ ನಗದು ಕೇಳಿದ್ದು, ಫಿರ್ಯಾದುದಾರರ ತಂದೆ ರು 80,000 ಕೊಡಲು ಒಪ್ಪಿದ್ದರು. ಮದುವೆಗಿಂತ ಅಜಮಾಸು 15 ದಿನಗಳ ಮೊದಲು ನರಸಿಂಹಯ್ಯ ಹಾಗೂ ಕೆಂಪರಾಜು ಎನ್ನುವರು ಆರೋಪಿತರಿಗೆ 80,000 ಕೊಟ್ಟು ಬಂದಿದ್ದರು. ನಾನು ಸಂಜೆಯ ವೇಳೆ ಸಾಮಾನ್ಯವಾಗಿ ಫಿರ್ಯಾದುದಾರರ ತವರ ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದೆ. ಆ ವೇಳೆಯಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರ ಸಂಸಾರದ ಬಗ್ಗೆ ಫಿರ್ಯಾದುದಾರರ ತಂದೆ ನನಗೆ ಹೇಳುತ್ತಿದ್ದರು. ನೆಕ್ಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಆರೋಪಿತರು ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ಪಂಚಾಯಿತಿ ಮಾಡಿದ್ದು. ಆ ವೇಳೆಯಲ್ಲಿ 3 ತಿಂಗಳ ಒಳಗಡೆ ನಾವು ಫಿರ್ಯಾದುದಾರರನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೇವೆ ಎಂದು ಆರೋಪಿತರು ಹೇಳಿದ್ದರು. ಫಿರ್ಯಾದುದಾರರ ಮದುವೆಯ ಮಾತುಕತೆಯ ವೇಳೆಯಲ್ಲಾಗಲಿ ನ್ಯಾಯ ಪಂಚಾಯಿತಿಯ ವೇಳೆಯಲ್ಲಾಗಲಿ ನಾನು ಹೋಗಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸೊ regarding PW3 participated in the marriage talk and the subsequent Nyaya Panchayati, nothing contrary was elicited during the course of cross-examination. PW4 is CW4 Lakshmamma. She was a neighbor of PW2. Evidence ಸೇಮ್ ಅದೇ ಇದೆ. ಚಾಸ 2ನೇಯವರ ಅಣ್ಣನ ಮನೆಯಲ್ಲಿ ಮದುವೆಯ ಮಾತುಕತೆ ಆಗಿತ್ತು. ಆ ಮಾತುಕತೆಗೆ ಚಾಸ 1 3 ಹಾಗೂ ಅವರ ಬಳಗದವರು ಮತ್ತು ಚಾಸ 5 ನಾನು ಹೋಗಿದ್ದೆವು. ಲಾಸ್ಟ್ 2 ಲೈನ್ಸ್ ಡಿಮ್ಯಾಂಡ್ಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಕೊಡಲು ಒಪ್ಪಿಕೊಂಡು ಹುಡುಗಿಗೆ 1/4 kg ಬಂಗಾರ ಕೊಡಲು ಒಪ್ಪಿದ್ದರು. ಮಾತುಕತೆಯ ಪ್ರಕಾರ ಚಾಸ 2 ಹಾಗೂ 3ನೇಯವರು 1ನೇ ಆರೋಪಿಗೆ 80,000 ನಗದು, ಬಂಗಾರದ ಬ್ರಾಸ್ಲೈಟ್, ಬಂಗಾರದ ಚೈನು, ಉಂಗುರ ಕೊಟ್ಟು ಹುಡುಗಿಗೆ 1/4 kg ಬಂಗಾರವನ್ನು ಕೊಟ್ಟು ಅದ್ದೂರಿಯಾಗಿ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟು ಮದುವೆಯಾದ ನಂತರದಲ್ಲಿ ಚಾಸ 1ನೇಯವಳು ಆರೋಪಿತರ ಮನೆಗೆ ಹೋಗಿದ್ದಳು. So chief examination that with regard to the physical and mental torture she was deposing. Subsequently in 3rd page with regard to the site demand and the conciliation held at police station and before Mahila Sangha, that was deposed in the 3rd page of chief evidence. Cross examinations. ನನ್ನ ಮನೆಯ ಪಕ್ಕದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರ ತವರು ಮನೆ ಇದೆ. ನಾನು ಫಿರ್ಯಾದುದಾರರ ಮದುವೆಗೆ ಹೋಗಿದ್ದೆ. ಆಸ 2 ಮತ್ತು 3ರವರ ಪಾಟಿ ಸವಾಲಿನ ವೇಳೆಯಲ್ಲಿ ನಾನು ನ್ಯಾಯಾಲಯದ ಆವರಣದಲ್ಲಿ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ಕುಳಿತಿದ್ದೆ. ಫಿರ್ಯಾದುದಾರರ ಮದುವೆಯ ಮಾತುಕತೆ ಅವರ ದೊಡ್ಡಪ್ಪನ ಮನೆಯಲ್ಲಿ ಆಗಿತ್ತು. ಆ ಮಾತುಕತೆಗೆ ಫಿರ್ಯಾದುದಾರರ ತಂದೆ ತಾಯಿ, ನಾನು, ಸಿದ್ದಪ್ಪ, ನರಸಿಂಹಯ್ಯ ಹಾಗೂ ಫಿರ್ಯಾದುದಾರರ ತಂದೆಗೆ ಬೇಕಾದ ಕೆಲವರು ಮಾತುಕತೆಗೆ ಬಂದಿದ್ದರು. ಮದುವೆಯ ಮಾತುಕತೆಯಲ್ಲಿ ಏನೇನು ಕೊಡಬೇಕು ಎಂದು ತೀರ್ಮಾನವಾಗಿದ್ದು ಗೊತ್ತು. ಆ ನಂತರದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರ ತಂದೆ ಆರೋಪಿತರಿಗೆ ವರದಕ್ಷಿಣೆಯಾಗಿ ಹಣ ಮತ್ತು ಒಡವೆ ಕೊಟ್ಟುವುದು ಕೇಳಿ ಗೊತ್ತಾಗಿತ್ತು. ಆರೋಪಿತರು ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದ ವಿಷಯ ಫಿರ್ಯಾದುದಾರಳೇ ಅವಳ ತಂದೆ ತಾಯಿ ಹಾಗೂ ನಮ್ಮ ಬಳಿ ಹೇಳುತ್ತಿದ್ದಳು. ಮದುವೆಯ ಮಾತುಕತೆಗೆ ನಾನು ಹೋಗಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. PW4 CW5 PW5 CW6 ವೆಂಕಟರಾಜು. He is the relative uncle of PW1 Swami. Even he also deposes in the chief evidence about the participated in marriage talk at Kuntaya's house. Cross-examination, if your lordship permits, I will go cross-examination.
Yes.
ಮೈಸೂರು ಬ್ಯಾಂಕ್ ಕಾಲೋನಿಯಲ್ಲಿ ಇರುವ ನನ್ನ ದೊಡ್ಡಪ್ಪನ ಮನೆಯಲ್ಲಿ ಮದುವೆಯ ಮಾತುಕತೆ ಆಗಿದ್ದು, ಮದುವೆಯ ಮಾತುಕತೆಯ ವೇಳೆ ಸಿದ್ದಪ್ಪ ನರಸಿಂಹಯ್ಯ ಇದ್ದರು ಎಂದು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಮದುವೆಯ ದಿನವೇ ಗಂಡನ ಕಡೆಯವರಿಗೆ ಹುಡುಗನಿಗೆ ರು 80,000 ನಗದು, ಬಂಗಾರದ ಉಂಗುರ, ಬ್ರಾಸ್ಲೈಟ್ ಹಾಗೂ ಹುಡುಗಿಗೆ 250 ಗ್ರಾಂ ತೂಕದ ಬಂಗಾರದ ಒಡವೆ ಕೊಟ್ಟಿದ್ದೆವು. ಚಂದ್ರಾಲಯ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಾನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಮದುವೆಯ ಮಾತುಕತೆಯ ವೇಳೆ ನಾನು ಹೋಗಿರಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಾನು ಫಿರ್ಯಾದುದಾರರ ಸಂಬಂಧಿಕರಾಗಿರುವುದರಿಂದ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನನ್ನ ಮನೆಯಿಂದ ಫಿರ್ಯಾದುದಾರರ ತವರು ಮನೆ ಅಜಮಾಸು 10-12 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇದೆ. ಆರೋಪಿತರು ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದ ವಿಷಯವನ್ನು ಫಿರ್ಯಾದುದಾರರು ಹಾಗೂ ಅವಳ ತಾಯಿ ನನಗೆ ಹೇಳುತ್ತಿದ್ದರು. ಎಂ ರಾಜು PW6, CW7. He was also deposed about participated in the marriage talk. And subsequently, he deposes about the delivery of the boy baby and the petitioner family not taken the child and complained to their house. Cross-examinations. ಫಿರ್ಯಾದುದಾರರು ದೂರು ಕೊಟ್ಟ ವಿಷಯ 3-4 ದಿನದ ನಂತರದಲ್ಲಿ ಗೊತ್ತಾಗಿತ್ತು. 3-4 ದಿನದ ನಂತರದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರ ತಂದೆ ನನಗೆ ಹೇಳಿದ್ದರು, ಪೊಲೀಸರು ನನ್ನನ್ನು ವಿಚಾರಣೆ ಮಾಡಲಿಲ್ಲ, ನಾನು 7ನೇ ಕ್ರಾಸ್ನಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. Point your lordship has to appreciate. In the 4th line of chief evidence, ಆ ಮಾತುಕತೆಗೆ ನಾನು, ಸಿದ್ದಪ್ಪ, ಬಾಯಮ್ಮ, ವೆಂಕಟರಾಜುರವರು ಹೋಗಿದ್ದೆವು. This fact was not being disputed during the course of cross-examination. 7 Ramadevi. He is also participated in the marriage talks. 7 Ramadevi.
The PW7 Ramadevi has stated that he participated in the marriage talk.
But second page ಅಲ್ಲಿ ಹೇಳಿ, second page first line, ಮದುವೆಯ ಮಾತುಕತೆಗೆ ನಾನು ಹೋಗಿದ್ದೆ. Second para, second page first sentence. Cross examination ಅಲ್ಲಿ ಹೇಳಿ. It was elicited during the course of cross examination. PW8. Chirudrappa. The police official deposes about apprehending accused number 1 on 11/11/2002. So subsequent day of registering of the FIR, accused number 1 was being apprehended. To that effect, PW8 deposes and exhibit P9 report was marked through this. And during the course of cross examination, the contrary was elicited. PW9 sorry. PW9 receives exhibit P complaint, register exhibit P10 FIR, subsequently conducted the laid the charge sheet. The certified copy, party ಸವಾಲು ಕೋರಿಕೆ ಮೇರೆಗೆ ನೀಡುವುದಾಯಿತು ಅಂತ ಇದೆ ಸರ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡೋದು ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಆಲ್ಸೋ. Sorry, Ranganatha cross examination next page is separate party savalu.
Yes.
ಆರೋಪಿಯವರ ಮನೆಗೆ ಒಡವೆಗಳನ್ನು ಜಪ್ತಿ ಮಾಡಲು ಹೋದಾಗ ಫಿರ್ಯಾದಿದಾರರು ನನ್ನ ಜೊತೆ ಇದ್ದಳು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರ ಹೇಳಿಕೆಯ ಮೇರೆಗೆ ಆರೋಪಿತರ ಮನೆಗೆ ಹೋಗಿ ಒಡವೆಗಳನ್ನು ಜಪ್ತಿ ಮಾಡುತ್ತೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಒಂದನೇ ಆರೋಪಿ ಯಾವುದೇ ಸ್ವಇಚ್ಛೆ ಹೇಳಿಕೆ ನೀಡಿಲ್ಲ ಮತ್ತು ಅದನ್ನು ನಮಗೆ ಬೇಕಾದಂತೆ ಬರೆದಿರುತ್ತೇವೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ದಿನಾಂಕ 12/11/2002 ಪಂಚನಾಮೆ 10:30 11:15 ಮಾಡಲಾಯಿತು. ಶಾಸ 2-9 ಹೇಳಿಕೆಯನ್ನು ನಾನು ಠಾಣೆಯಲ್ಲಿಯೇ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ ಮತ್ತು ಅವರು ಠಾಣೆಯಲ್ಲಿ ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
Yes.
So subsequently, on the basis of the evidence recorded, the order of conviction. My precise argument in respect of the order of conviction is that I do accept the trial judge, by passing the order of conviction in detail, has not described the recital about the evidence of PW 1-9. However, he has framed some questions apart from the points for consideration. He has framed 4 more questions and tried to find the answer from the evidence of PW1 and other witnesses for that questions, and found the accused number 1 to 5 guilty for the offences punishable under section 498A and section 3 and 4 of the 4 of dowry prohibition. But your lordship has to appreciate during the course of appeal filed by the state trying to enhance the punishment for section 3 of dowry prohibition, and in respect of appeal conviction challenging the order of conviction, the first appellate court has in detail reappreciated the entire evidence on record. Now I would like to draw your lordship kind attention with regard to without going again and repeat the evidence part of discussed by the first appellate court. I would like to draw your lordship kind attention to the reasonings started from page number 24 onwards, para number 24 onwards. Your lordship permits, I will start from there. Para 24, I think it is in page 19 of the judgment.
Yes.
Para 24, on careful evaluation and assessment of the evidence of the PW1 coupled with the contents of Exhibit P1, it can be said that her evidence does not fully corroborate with the contents of complaint. This is the main reason. I will not again go in detail about para 24. Prima facie, your lordship has the governments in complaint and the deposition of PW1 corroborates.
Yes.
In respect of the allegation of demand of dowry and the physical and mental harassment caused by the petitioner family. And such being the case, the prima facie reasoning forthcoming in para 24 3 lines is against the facts Subsequently, I go to para 25. So 24 ಅಲ್ಲಿ ಮತ್ತೇನು ಆ ತರದ್ದು ಏನು ಇದಿಲ್ಲ. 25 ಅಲ್ಲಿ your lordship permits, I will skip to 25.
Yes.
25 ಅದು next page ಅಲ್ಲಿ sorry page number 21 ಅಲ್ಲಿ 25 ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. ಅಲ್ಲಿ third side only evidence of PW1 cannot be relied upon to believe the alleged demand by accused and payment of any dowry and other articles in the marriage as well. Again, this is an inadvertent reasoning for the reason PW1, the evidence of PW1, PW2, mother of PW1, and PW2 to 7, who are the members participated in the panchayat, depose about demands during the course of marriage talks, and the said demands being meted out by PW1 family. In spite of such corroboration, this inadvertent reasoning by the first appellant. Subsequently, the lordship permits, I will proceed with para 26.
Yes.
Furthermore, the very fact mentioned in complaint that marriage was performed by observing all the customary rite itself indicates that this is important. Indicates that whatever amount and articles alleged to have been paid to accused were given only on a custom, but not demand made by the accused. That's why while pointing out the evidence of PW1 and 2, I have submitted. There is no suggestion on the part of defense that the said gold ornaments given to the bride and bridegroom was of customary nature. To that extent, no suggestion was put by the defense counsel. In spite of no such suggestion, out of own, the first appellate court has come to a wrong conclusion and gave a contradictory reasoning.
Yes.
There are 27. Further, PW1 made a material improvement in her evidence by stating that once the accused had managed to get her bitten by a snake and she was subjected to abortion at a time of pregnancy of 2 months, but no such allegations are made in the complaint. This fact being a material improvement which amounts to a contradiction prevailed in the evidence of PW1 to that of the contents of Exhibit P1 goes to the root of the case and creates doubts as to the allegation made against accused. To this, my humble submission will be I do accept that in Exhibit P1 complaint there is no recital about snake bite. But during the evidence of PW1 and 2, in the chief evidence, it was mentioned, deposed, and during the course of cross-examination, nothing contrary was elicited to discard the same.
Can you draw my attention to that snake bite portion
in
and abortion portion in the evidence of PW1?
Evidences. Cross page number 8 of the evidence. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನನಗೆ ಗರ್ಭಪಾತವಾಗಿತ್ತು. ಅದಕ್ಕಿಂತ ಮಿಂಚು ಆರೋಪಿತರದ್ದು ಅವಿಭಕ್ತ ಕುಟುಂಬ. ಸೆವೆಂತ್ ಲೈನ್ ಅವಿಭಕ್ತ ಕುಟುಂಬ. ನಾನು ಗರ್ಭಿಣಿ ಇದ್ದಾಗ ಆರೋಪಿತರೇ ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಹಾವನ್ನು ಬಿಟ್ಟು ಕಚ್ಚಿಸಿದ್ದರು. ಆಗ ನಾನು 2 ತಿಂಗಳ ಗರ್ಭಿಣಿ ಆಗಿದ್ದೆ. ನಂತರ ನನಗೆ ಗರ್ಭಪಾತ ಆಗಿತ್ತು. ಹಾವು ಕಚ್ಚಿದ ಎಷ್ಟು ತಿಂಗಳಲ್ಲಿ ನಾನು ಗರ್ಭಪಾತ ಆಗಿತ್ತು ಎಂದು ನೆನಪಿಲ್ಲ.
What was your submission in that regard in your argument which you just now made?
During the course of cross-examination only it was elicited with regard to snake bite.
You made a specific mentioning in your argument that
Yes.
during their examination chief they have stated. ಅಲ್ವೇ?
Yes.
ಅದಕ್ಕೆ ನಿಮಗೆ ಓದಿಸಿದ್ದೆ.
Yes. Yes.
SCGP ಓದ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಓದಬೇಕು. ಅವ್ರ ಕಾಲ ಮೇಲೆ ಅವ್ರ ಕಲ್ಲು ಹಾಕೊಳ್ಬಾರ್ದು.
Correct. Sorry, proceed.
Yes.
Para 29. Para 29, learned portion.
1 minute.
There are 20 lines. Starting 7 lines will be with regard to the discussion that allegation made by PW1 with regard to the much made by petitioners to make her to sleep with the others in the house. To that reasoning given, so it would be, I hope, middle portion of the
Yes.
So it would be highly improbable to believe that accused number 3 insisted to the one to sleep with another person in a marital house. This aspect of the case also create doubt as to the genuineness of the allegation made in the complaint. But no such complaint had been filed against any of the accused prior to filing exhibit even alleged dowry harassment. So this finds me during the course of cross-examination of PW1 and PW2 and in the evidence of the Panchayatdar PW3 to 7, it was elicited that before lodging exhibit P1 complaint, there was a Panchayat and even in the course of evidence of PW1, she was stated that even police called accused and there was an undertaking by PW1 to that accused number 1 to that effect. That fact was being remained silent by the first applicant. Even there is no material to show that there were any conciliation efforts made by elderly person to reunite the husband and wife. So this aspect of the case creates doubt as to the allegation made in the complaint. Again, this reasoning also goes against the evidence of PW7-6, wherein they have deposed about subsequent to marriage also. They are intervened and participated to reunite accused and the PW1. Again, this is the counter reasoning adverted by the first appellate courts.
Yes.
There are 30 sorry. Further, PW in the course of cross-examination states that once her mother, by borrowing an amount of rupees 20,000 from one, Siddhurappa paid an amount, paid the amount in the hands of her in-laws. But Siddhurappa is not examined in the case on hand to substantiate said version. So this aspect creates doubt as to the payment of additional dowry in view of alleged harassment being extended by accused towards complainant. In spite, PW1 and PW2 deposes about handing over of 20,000 to met out the demands made by the petitioner's family, and the same was corroborated with PW3 to 7. The learned first appellate court gave contrary reason to that effect.
No, apart from PW1 and PW2, who has spoken about the payment of additional dowry?
20,000. So PW3, page number 4. Page number 4. ಕೆಳಗಡೆಯಿಂದ 7ನೇ ಸಾಕ್ಷಿ.
PW3.
PW3 ಹೌದು. PW3 ಚಿಕ್ಕಮ್ಮ. PW3 ಚಿಕ್ಕಮ್ಮ.
PW3 is Siddhappa, right?
Chikkama. PW2 sorry. PW2 is mother.
That is mother.
I will left it. PW PW1 evidence.
ಸರಿ ಓದಿದಿರಿ ಎವಿಡೆನ್ಸ್.
Sorry?
ಸರಿ ಓದಿದಿರಿ ಎವಿಡೆನ್ಸ್.
Okay.
Next.
There are 31. Even otherwise, there is no material to show that she was subjected to snake bite and she suffered abortion during her stay in the house of accused. If really she was admitted to the hospital due to snake bite and aborted her pregnancy, there should be any medical records to that effect with the complainant. But no such medical records are produced before court to appreciate this portion of evidence of PW1. To that extent, we do agree that prosecution has not adduced any medical document with regard to the PW1 being taken to hospital in respect of state. There are 34. 34. So, having regard to all these facts and circumstances, I am considering you that the evidence of PW1 is inconsistent with that of the contention of the exhibit given, and her testimony does not inspire the confidence of the court to believe the case of prosecution. Moreover, PW1 states in her cross-examination that she is ready to return to the house of her husband if she is taken aback. But at the same time, she made an allegation that she was being compelled by her in-laws to sleep with some unknown person who used to visit the house and to earn money. So both these versions are contrary to each other and appear to be very unnatural. As such, this portion of evidence of PW1 creates doubts as the allegation made against the accused. Therefore, having regard to all these facts and circumstances of the case, it can be said that the learned magistrate unfortunately has not taken note of all these material contradictions and improvements found in the evidence of PW1 and erroneously appreciated the evidence which had resulted in miscarriage of justice.
Yes.
Para 35.
Yes.
Similarly, the trial court has also not referred the facts stated by PW2 to 7 in its judgment before relying on the evidence. As such, it is necessary to appreciate and evaluate the evidence of PW2 to 7 in the light of the allegation made against the accused. Some relevant portions of it. Directly, I will go to 38. 38.
Yes.
A careful assessment and evaluation of evidence of PW2 coupled with her statement before police go to show that her evidence does not fully corroborate with her statement as well as the evidence of PW1. This witness has introduced a new story by saying that accused besides the demanding an amount of rupees 1 lakh also demanded to leave a site. But the very PW1 has not stated anything with regard to said fact. Further, this witness states that PW1 had not participated in the marriage talk Whereas PW1 has gone to the extent of deposing that she was personally present when the marriage talks were held. So the version stated by PW2 with regard to the alleged demand and payment of dowry is inconsistent with that of the say of PW1. Even this witness never states that cash amount and jewelry were given to accused on demand. So it appears that PW1 and 2 have exaggerated the incident and deposed facts which are inconsistent to each other. Further, it has come in the evidence of this witness that soon after PW1 became pregnant, she was brought to her parental house for delivery and PW1 did not return to the house of accused. It indicates that PW1 has not made effort to return to the house of accused along with her son after delivery. Further, this witness PW2 states that her husband sent an amount of 20,000 in the hands of one Siddhappa, but the said fact is not stated by PW1, who in turn states that her father directly paid such an amount of 20,000 in the hands of her husband. Furthermore, the very father of PW1 being a material witness is not examined in this case. The 39 with regard to, in nutshell, discuss about the evidence of PW 3 to 7. Para 40 is relevant. Para 40. Shall I proceed?
Yes.
Furthermore, all these witnesses state that the talks were held in the house of uncle of PW1 by Kuntaya, but the very witness by name Kuntaya is not examined in the case on hand. So, in the absence of evidence of said Kuntaya, it is very difficult to place reliance on the evidence of PW 3, 4, 6, and 7 to hold that any marriage talks were held amongst parents of PW1 and the accused number 1. Further, these witness states that except parents and relatives of PW1, no other had taken part in the marriage talk. So it becomes clear from the evidence of PW2 to 4, 6, and 7 that the complainant had not participated in the alleged marriage talks. Anyhow, any of the material contradiction which prevailed in the evidence of these witnesses, doubt arises as to the alleged talks held for payment of dowry and other articles and their participation. So, the first appeal court entirely suspected the participation of PW 3 to 7 in the marriage talk. Para 42 relevant portion. Para 42. Shall I start?
Yes.
Furthermore, PW 3, 4, 6, and 7 never state as to alleged demand and payment of dowry of rupees 20,000. It has been specifically stated by PW 6 that PW 1 was treated well and she was living happily in the house of accused for about 6-7 months, and thereafter she returned to her parental house for delivery. So this portion of his evidence go to show that to go to the root of the case and creates doubt as to any kind of harassment and cruelty being extended by accused to meet any of their unlawful demands. This is again the controversy. Now I will skip to para 45. Para 45.
Yes.
Another witness examined by the prosecution is the cousin brother of PW1, that is PW5. It is the evidence of PW5 that marriage talks were held 1 month prior to the date of marriage. Himself and parents of PW1 participated in the said talks, wherein the accused insisted to pay dowry of 80,000, accused number 1, and golden ornaments weighing 250 grams to the bride. As per the talks, the amount as well as golden ornaments were given in the marriage. It is his further evidence that PW1 lived happily for about 2 months, and thereafter she was subjected to harassment for bringing cash of rupees 1 lakh inside. Then PW1 returned to the parental house for delivery. Since accused failed to take back PW1 to their house, himself and the elderly person convened a panchayat, but the accused refused to take back PW1 to their house. In PW1 and 2, and the evidence of PW3, 4, 6, and 7 also corroborates about for first 2 months they lived a happy married life. This is once again a continuing reason.
Yes.
48. I would like to draw your lordship kind attention to the relevant portion of para 48.
Yes.
On careful evaluation and assessment of entire evidence of PW1 to 7, coupled with the contents of Exhibit P1, it can be said that except the bearing the broad evidence of PW1 and 2, there is no any other substantial evidence to believe the case of prosecution. Though PW1 and 2 states something against accused, their evidence is not cogent, consistent, and corroborative to each other. The facts stated by these witnesses do not establish the ingredients of offences alleged. There is no consistent evidence to show that talks were held prior to the marriage, and as per the talks, such an amount of this 80,000 was paid to the accused as dowry on demand. Even there is no such agreement prior to marriage for payment of any dowry. So the ingredient of the offence under Section 3 of Dowry Prohibition Act are not being attracted from the facts stated by these witnesses. So this is again
Yes.
Contrary reasoning in spite of the cogent evidence of PW1 and 2 and 3 to 7. Now, after Nantra discuss with regard to some paras pertaining to the provision of IPC and the dowry prohibition.
Yes.
There are 53 relevant.
Yes.
Further, if really there was any kind of harassment and cruelty being extended by accused, PW1 would not have kept mum without filing any complaint against accused up to 3 years, because she returned to her parental house while she was pregnant of 7 months and stayed back with her parents till today. This is again, once again, contrary.
What is the contrary?
So because PW1 and 2, in the evidence of PW1 and 2 and Exhibit P1 complaint clearly discloses about my submissions. The evidence of PW1 clearly demonstrates that subsequent to delivery of the child also, she has made an attempt to reunite. Subsequently, notice was issued, for which subsequently she lodged complaint with the Kempena Gowda Nagara police station, wherein the accused been called by the police and he has given the undertaking. That was elicited during the course of cross-examination. That point was not being really appreciated by the first appellate. There are 56 only. There are 56.
Yes.
There are 56. Therefore, as observed above, the trial court has improperly appreciated the evidence of PW 1 to 7, which has resulted in miscarriage of justice. Hence, having regard to all these facts and circumstances of the case, I am of the considered view that trial court committed serious illegality in convicting the accused without there being any substantial, cogent, and consistent evidence to that effect on record.
Yes.
With this, the prima facie material error found in the order of acquittal passed, setting aside the order of conviction passed by the first appellate court. Submit that the learned first appellate court duly failed to appreciate the
For DPI.
evidence
Yes.
on entire evidence on record in threshold and gave contrary reasoning and passed the order of setting aside the order of conviction. And I humbly pray this honorable court, the learned trial judge very rightly passed the order of conviction, and accordingly the same has to be confirmed and as per the prayer made in revision petition, as per the provision of section 3 of Rowdy Prohibition Act, not less than 5 years in this. It shall not less than be 5 years for section 3 of Rowdy Prohibition. So the learned trial judge has convicted the respondent accused for 2 years imprisonment for the offence under section 3 of Rowdy Prohibition. So, revision also is required to be allowed.
I will hear you day after tomorrow. Other thing. Called again. The concept from both sides. For the argument of learned HCGP. For the appellant in criminal appeal 1169 of 2012. Respondent number 6 in criminal appeal 280. 203 of 2013. For petitioner in criminal revision petition 1026 of 2004. For the arguments for the learned counsels in all these three matters. It's a matter ಯೂನಿಟ್ಗೆ ಎಷ್ಟಿದೆ ರೀ? Or 21, 11, 22 on the top of the list. 21, 11 top, yes.
21
Yes.
sorry, one second.
Hmm.
21
Hmm.
maybe on the
22. 22,
right.
22, 11 on the top of the list. ಅವತ್ತಿನ ದಿವಸ ನೀವು ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕ್ರಿ. ಆಮೇಲೆ ಇವತ್ತು ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದೆ, ನಮಗೆ ಇನ್ನೊಂದು ದಿವಸ ಟೈಮ್ ಬೇಕು ಅಂತ ಕೇಳಬಾರ್ದು. 230 ಮ್ಯಾಟರ್ ಇದೆ ನೋಡಿ.
Final hearing 230 matter, case number 44, Chandrasekhar K. V. Krishnamurthy for respondent.
ನಾವು ಚೇಂಜ್ ಮಾಡ್ತೀವಿ. ಅದು ಇಲ್ಲಿರ್ತದೆ. ನನಗೆ ಇಷ್ಟು ಹೈಟ್ ಬಂದ್ರೆ ಸಾಕು. ಬಂದ್ರೆ ಅದು ಪೂರ್ತಿ ಜಾಸ್ತಿ ಹೋಗುತ್ತೆ. ಪೇಪರ್ ಮೇಲೆಲ್ಲ ಇಷ್ಟು ಬಂದ್ರೆ ಸಾಕು. Yes, absolutely no passover. Look at the clock. Don't make all those, if I can use the word, dramas. Proceed with the matter. Absolutely not. Absolutely not, sir. ಮಧ್ಯಾಹ್ನದಲ್ಲಿ ಯಾರು ಪಾಸ್ ಓವರ್ನ ಕೇಳಬೇಡಿ ದಯಮಾಡಿ. ಇದನ್ನ ಕಳೆದ 6 ವರ್ಷದಿಂದ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಬೆಳಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಕರಿಬಹುದು. ಮಧ್ಯಾಹ್ನ ಕರೆದಾಗ್ಲೂ ಮತ್ತು ಪಾಸ್ ಓವರ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲ. ಇದರಲ್ಲಿ ನಾನು ಅವರೇ ಕೇಳಿದ್ದಾರೆ ಅಂತ 2.5 ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು. ನೀವೇ ಕೇಳಿರೋ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ನೀವು ಕೋರ್ಟ್ ಮಾತಾಡ್ತಾನು ಮಧ್ಯ ಮಾತಾಡೋದಾದ್ರೆ ಐ ಮೇಕ್ ಸೀರಿಯಸ್ ಅಬ್ಸರ್ವೇಷನ್ಸ್. ನೀವೇ ಕೇಳಿ ಟೈಮ್ ಹಾಕಿಸ್ಕೊಂಡಿದ್ರಿ, ಡೇಟ್ ಅಷ್ಟೇ ಅಲ್ಲ ಟೈಮು ಹಾಕಿಸ್ಕೊಂಡಿದ್ರಿ. ಟೈಮು ಹಾಕಿಸ್ಕೊಂಡಾಗ ಆ ಟೈಮಿಗೆ ಕಾಯ್ತಾ ಕೂರ್ಬೇಕಾಗಿರೋದು ನಿಮ್ಮ ಕರ್ತವ್ಯ. ಪ್ರೊಸೀಡ್ ಆಗಿ. ಅದು ನಮಗೆ ಗೊತ್ತಿಲ್ರಿ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವರಿಗೆ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟೇ ತಗೊಳ್ಬೇಕು. ಅವರೆಲ್ಲ ಜಾಸ್ತಿ ತಗೊಂಡು ನಮ್ಗೆ ಅದು ಟೈಮ್ ಇಲ್ಲ ಇದು ಟೈಮಿಗೆಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ ಇರೋದು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕಲ್ಲ. ನಮ್ಮ ಟೈಮಿಗೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಸ್ಗಳು ಬರಬೇಕು. ಹೇಳಿ ನಿಮ್ಮ ಜವಳಿಯವರಿಗೆ ಅದನ್ನ. ಈಗ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹರಡ್ ಅಂತ ತಗೊಳ್ತೇನೆ ನಾನು. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನಾಟ್. ಮತ್ತು ಅದನ್ನೇ ಕೇಳ್ತಿದ್ರಿ. ಐ ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅಮಿಕಸ್ ಕ್ಯೂರೆ. ಐ ವಿಲ್ ಅಪಾಯಿಂಟ್ ಅಮಿಕಸ್ ಕ್ಯೂರೆ. ಸಾಧ್ಯ ಇಲ್ಲ. ಯು ಕೆನಾಟ್ ಟೇಕ್ ದ ಕೋರ್ಟ್ ಫಾರ್ ಸೋ ಲೈಟ್ಲಿ. Yes, proceed please. Yes, proceed with the matter. Yes.
On complaint. Complaint for the trial court. 200 reduced was the day.
Yes. You cannot disturb another counsel when the matter is going on. That amounts to contempt. That amounts to contempt. Go. Yes, please.
On complaint.
Yes.
Complaint before the trial court. 138 of the negotiable is to be.
All the three matters are with respect to 138.
All the four,
All the four matters are with 138.
same single transaction.
Yes. In all these four matters, you have challenged the confirmation of conviction.
Please.
Yes. Is it between the same parties?
Same one.
Yes.
48 of 13.
Yes.
Trial
Why
court.
do you choose 448? Why not in the order of how they are?
449 is first matter. 448 is second matter.
Yes.
And stated convict the accused for the offense. 138 of the National Instrument Act. Impose sentence. Fine of rupees 50 lakh 5,000. What of the said fine amount?
No, need not read the operative portion of the order. Proceed with the points of arguments.
Not complaint aware alleging in the complaint.
Yes.
Complaint alleging in the complaint alleging that the agreement entered between the accuser and complaint on 28/6/2019 PPE. Complaint purchased for site flats, 5 flats. And
Whether the date of agreement, that is 28/6/1997, is the common date in all the four cases?
Single agreement.
Single agreement.
4 checks.
Yes.
The exhibit P1 manner. There's a total 44,60,000. Paid to the alleged accuser through DD.
Yes.
For sale consideration. Exhibit P1. Page number 5.
Yes.
And thereafter, they alleging that in the complaint, saying that 44,50,000 through US dollar. Dollars paid to the accused.
Repeat that, please.
But as initially they entered agreement on 28 June 1987, exhibit P1 for agreement of sale.
Yes.
And paid rupees for total
Yes.
6 DDs, total rupees of 44,60,000 to the accused.
Yes.
Then thereafter in the complaint argument alleged in the complaint saying that 44,50,000 that is equivalent to US dollar 1,000 to 22,000
1,22,000.
22,000.
Yes.
1,20,000 equal to Indian rupees 44,50,000.
Hmm.
Then paid to the complaint. Total amount for 18 lakhs 10,000.
Yes.
Then, my lord, there is complaint averment exhibit. They entered agreement MOU with the accused on 11/6/2002. Exhibit P2. What contention is that is fabricated, created. As per complaint averment, saying that is a entered agreement. Exhibit P2.
Yes.
Agreement for they agreed to execute a sale date. In default, they are agreeing to pay rupees 1 lakh initially. Then thereafter, he issued 2 checks. And further alleging that in the default for the purpose of non-compliance of agreement exhibit P1, they issued they agreed to pay of rupees 2 lakh 2 crores 25 lakhs 25,000. They issued a check. These total four checks. That is the allegation in the complaint. The honorable trial court, before the honorable trial court, the complaint is examined as a PW1. And marketer, total 19 documents.
How many checks were issued in total?
4. As per their allegation, 4 checks.
Yes. What is the amount of those 4 checks? Whether they were issued on the same day or difference of 2-3 days?
Is on 30th June 2007. Another one 29/9/2007. 2 checks are 31/7/2007. Sorry, one check. Another one is 31/7/2007. One check is and 31/8/2007.
Yes.
No, that is a part by limitation.
Yes.
The transaction took place.
Proceed, please.
Yes, I'm ready. More than 138 pages. This is one paragraph of the claim on the basis of paragraph number 2.
Complaint.
Complaint.
Go to the exhibit P1.
The complaint is not.
Complaint mark agreement.
Anyone complain. What for easy? I mean, be permitted for easy access.
No. You pretty well know that my court officers should do their job by themselves. I got it. Original.
Para number 2.
Yes.
I want to develop a point for consideration of this honorable court in the light of the pleadings in this paragraph. It is submitted that in furtherance, the accused had also instructed the complainant to pay further advance. On these instructions and request, the complainant paid $1,22,000, equivalent to 44,50,000 in London, UK, to the accused representative. Thus, the accused has received total amount of 89,10,000. Now, this is part of the amount so-called reflected in the checks, which, according to them, has bounced, leading to proceedings of conviction and confirmation. What I want to submit before this honorable court is, if something is barred by law, and that barred by law forms the basis, would that be a proceedings to which this honorable court would find relief to either of them?
What is that is borrowed by law?
Payment on behalf of a person resident in India, outside India, is barred under erstwhile para and section 3 of FEMA. It is void transaction. If it is void transaction, my humble submission here is it would be hit by section 23 of the Contract Act. Consequently, this entire proceedings would be void in law. This would be my stand and my attempt to show to this court that the entirety of these proceedings of 138 is, if I were to put it in simple language for purpose of easy understanding, if two of us join together to do some illegal act and I fail to give his share after the illegal act, can I proceed to the court to seek my share in it?
Analogy won't tally or correspond to the allegation made in the present complaint.
Absolutely, madam. But section 3 of the FEMA stands. Notwithstanding the allegation. FEMA. 2002. 1990. Section 3. Chapter 2.
Yes, read section 3, please.
Section 3. Save as otherwise provided in this act, rules or regulations made thereunder, or with the general or special permission of the Reserve Bank, no person shall deal in transfer. A is not applicable. B. Make any payment to or for the credit of any person resident outside India in any manner. Person resident outside India has been defined in the reverse in section 2 bracket B. Person resident in India has been defined.
Section 2.
2 bracket V. 2V definition.
Yes. Yes.
And 2W defines who is a person resident outside India, means a person who is not resident in India.
how FEMA is attracted in the case on hand.
The case on hand, FEMA is attracted because the party could not have made payment outside India.
Whether the party who made the payment was a resident of India and whether the payment was made to a non-resident of India.
Absolutely. It itself said, was paid in US dollars to the accused representatives in London.
Yes, payment might have been made, sir.
Please.
Payment might have been made abroad. Section 3B doesn't say that payment shall not be made outside India between two Indians.
No, Indians or foreigners makes no difference, Your Lordship. I am staying there. My daughter is staying there. My daughter pays on behalf of my father, me, the father, to somebody there. Gone in law. It does not say.
Read section, sir.
Absolutely.
Yeah.
My Lord, it is second.
Before interpreting, kindly read the section again.
Make any payment to
Huh.
or for the credit of any person resident outside India.
Yes.
That
An
is-
Indian making payment to a person who is not a resident of India, who is a resident of outside India, that is violated. Here, the payment, if at all, is shown to have been made as per the complaint, is to a resident of India, that is to his representative in abroad. The payment is made by a person probably or might be residing in America. That means payment made by an Indian to a resident who is not a resident of India is under section 3B.
With great respect, no, man. With great respect.
Then what it means?
What I would submit is, person resident in India does not necessarily mean an Indian resident. It could be a foreigner.
Yes.
It could be any person
Yes.
who is living in London. There is a person living in London who, on the instruction, pays 44,50,000.
No. How you are inferring that he was living in London? You are making use of the word living in London. How are you inferring that word living?
Your Lordship, assuming for a moment, I have gone there.
Yes.
I have gone to see cricket. And I ask for money. I have finished my money here. I got $10,000. I have got work. Kindly get me some money here extra. My pocket has become empty. I have come here for 3 days. Whatever money I had brought from India, I was exhausted. I want immediately some money. That is wrong, but not permitted. That's not permitted. I'll give a series of decisions of the tribunal on this. It is settled law. Cases and cases are registered on this basis. In fact, it went to an extreme extent where I had an occasion to argue that my father suffered an attack. I had to admit him to the hospital. I didn't have money. So my friend said, please put him inside the hospital. I'll send the money tomorrow morning. By the time I paid the money to the hospital, next day he sends it to me by remittance from abroad directly to my account. That was held to be done. Collection of rent on behalf of a brother who was studying abroad has been found to be bad. Family property, rent being collected. I am not even saying anything else. This is settled law under FEMA, Your Lordship. Otherwise, I wouldn't have taken this stand to even contend before this argument, this argument.
Merely because a learned counsel take a stand, I am not ready to accept it unless I am convinced.
Absolutely.
Yes. I am entitled to be convinced by you.
I have to convince Your Lordship.
Yes.
Accept my argument. Law has to be settled. I have to satisfy Your
A
Lordship.
bare reading of section 3B says, make any payment to or for the credit of any person resident outside India in any manner.
Please. All his instructions and request, the complainant paid US $1,22,000 equivalent to so and so in London, UK, to the accused representative.
Yes.
On his instruction, whose instruction? Instruction of the accused.
Instruction of the accused who was residing in India.
Yeah. The complainant makes payment of $1,22,000.
Yes.
In London.
Yes.
To the representative.
To the representative, not in London, to the resident of London. No.
In submitting, or possibly I am failing to make my point clear to Your Lordship. Person is in London.
Person?
Some person is there in London. I am not saying an Indian representative or anybody. There is some person.
Yes.
I request the complainant make payment to him.
Yes.
Complainant makes payment to him.
Yes.
Whether it's an Indian, foreigner, or whatever it is.
Yes.
On my behalf, complainant pays him. On instruction and request of the request made.
On instruction and request of accused, complainant paid to the representative of the accused in London.
That was included in this check amount. That 44 lakh 50,000.
That is true, sir. That is true. I am yet to be convinced that accused was a resident of India. I do not know what is the residential status of complainant.
You take it that he is also resident in India.
Yes, complainant is also resident of India. Let us assume for a moment. At the request of the accused, complainant makes a portion of the agreed amount in foreign currency abroad to the representative of the accused. Whether does it fall under section 3B?
Please, absolutely.
You convince me on the next date of.
Please, Lordship, have it on Monday.
Yes. Let us senior counsel for the petition. The counsel for the respondent are present. Of the argument of the senior counsel for the petitioner in part, since the court time is over, for a further argument on these matters, followed by respondent's argument and reply if any. If the matter on. Tuesday, 22nd.
If it gets spilled over, then on 23rd, I am in Kalburgi, Your Lordship. So I wanted on
Yes.
Monday.
Yes. On 21/11/2022.
2:30.
At 2:30.
Grateful.
Respond.
Yes, please.
I'm appealing for the response.
Yes, I have recorded. The other matters which have not listed would be spread over in the coming week. If you have got any convenient date before, between 21st to 24th, you can request the court officer, he will allot those dates.